tonight's meeting is a special meeting as part of Section 508 of the MPC. I'd like to kick things over to Solicitor Schultz. He will give an overview and outline of the meeting this evening. Solicitor Schultz.
Thank you, Chairman Bachmer. Tonight's hearing is for the Board of Supervisors to receive public comment on the Trindle Spring Trade Center subdivision and land development plan under Section 5085 of the Pennsylvania Municipalities Code, which I will refer to as the MPC. Section 5085 permits the municipality to have such a hearing on subdivision plans. The courts have noted that a decision to have such a hearing is discretionary for the elected body. The MPC does not have such a provision for land development plans. It says only that land development plans are to be considered and voted upon at a meeting of the elected body. Hearings are transcribed, meetings generally are not. However, nothing in the MPC prohibits the format of tonight's hearing, and the second-class township code gives the board fairly wide latitude in its meeting format. The township has chosen tonight's format in part because they must act on this plan by October 5th, or it will be deemed to be approved by law. There is a very real time constraint. This format will allow the board to hear succinct testimony from experts presented by the applicant and by representatives who have been represented, who are here represented by counsel and have requested party status by the deadline last Thursday. In large part due to the time constraints, the testimony and record tonight are not intended to limit further development of a record should the eventual decision of the board be appealed to court. This hearing is for the board to gain information and receive public comment. Although a portion of tonight's hearing is set up in a more adversarial format that you might see in a contested conditional use hearing or in court, it is distinct from such proceeding because it is truly only for the development of public comment. A by right plan, which this plan is tonight, is a plan for development of a property that has been zoned for that specific use. Under the Pennsylvania Municipalities Planning Code, a by right land development plan cannot be denied if it complies with all the objective provisions of the applicable subdivision and land development ordinance and other applicable regulations. Section 508, subsection 2 of the MPC mandates that if a plan is not approved as filed, the decision must specify the defects found in the application, describe the requirements that have not been met, and cite the provisions of the statute or ordinance relied upon. However, of course, conversely, a municipality may deny a land development plan if it does not meet the substantive and objective requirements of the applicable ordinances. For instance, there is case law where the court has upheld denial of the developer's plan because it did not comply with specific requirements. Therefore, while a by right land development plan must be approved if it meets all applicable requirements, it can be denied if it fails to comply with the objective standards set forth in the relevant ordinances. So tonight I ask on behalf of the board that all here tonight keep this proceeding civil and allow the board to receive public comment thoughtfully. Also, as this hearing and all public comment will be transcribed, please refrain from speaking over each other so the stenographer to my right may keep an accurate record. Tonight we have, I have to put my glasses back on, we have counsel for the applicant, Helen Gemmel. I'm sorry, there you are. It's hard to see with the lights. And counsel for a number of parties, William Clark. Attorney Clark represents 15 residents. And at some point, Attorney Clark, perhaps at the beginning of your case in chief, will have you list out your representative parties. There was also an individual, Olivia Bray, who I have not met. So Olivia, if you are here tonight, could you raise your hand? You're way in the back. Olivia, you're a party, so if you would like to come forward, I know you said you may only be asking questions if you feel questions haven't been asked that you're interested in. It's completely up to you, but you'll be given an opportunity once both counsel have presented their case to ask any questions. you wish to ask in cross-examination. So after they complete each portion of their case, you'll have an opportunity to ask those questions, okay? Okay. Then we are going to move forward with tonight's hearing. They're under rules that were adopted by the board last night, ratified by the board last night. Council and Ms. Bray are aware of those rules. I assume everyone has, I'm going to make the assumption everybody has read through them. And before we begin, which will begin with an overview from a 10-minute overview, up to 10-minute overview by the applicant, I understand Attorney Gemmell, you might want to note an objection you may have to the proceedings, so I'll give you that opportunity now.
Good evening, everyone. My name is Helen Gemmell with the law firm of McNeese, Wallace & Nerd. I represent the applicant here this evening, which has a very complicated name, but it is an affiliate of a company that's known as Panatone. So for ease of reference, we'll refer to the applicant as Panatone this evening. Appreciate the opportunity to be here. Appreciate that the public interest and the people that come out here, that you've made this facility available. That said, I did just want to lodge an objection to this process. As your solicitor has said, the MPC allows public hearings in the context of subdivision. We don't believe they're allowed in the context of land development. We also don't believe they're intended to be in this type of a format where you've got cross-examination of expert witnesses. I think that's an adversarial system that's not intended by the MPC. Although we appreciate that it is within your discretion to hear public comment, and we know how important it is for you to hear that this evening. But in terms of this being a formal process under the MPC, I just wanted to lodge that objection at the beginning, knowing that we are moving forward anyway.
Thank you, Attorney Gemmell. And if you would like to, in a moment, roll right into your client's 10-minute overview of the plan. I will also note that for the public, once the more formal part of this hearing is complete, the hearing does not end. There's an opportunity for comment by the public under the board's usual rules. So when you do have that opportunity, you'll need to come up to the podium, address the microphone, and we will need your name and address for the record. Okay, Attorney Gemmell, you may proceed.
Thank you very much. Make sure that this microphone is at the right location here to speak so that everyone can hear me. I appreciate the opportunity for an opening, which I will make very brief because I know you want to hear from the people who have much more knowledge than I have as the attorney with respect to this matter. Couple things I want to start by saying. I understand that there was some concern about the process that was discussed at last night's board meeting. Panatone did not get involved with this property. It got under contract in March of 2023. So to the extent that there were discussions and things going on before March of 2023 when Panatone had this under contract, it may have been with other developers, but what we've tried to do here is go through the process that is appropriate in order to get the feedback, the good faith back and forth discussion between township staff, our engineers, in order to be sure that we have a by right plan that complies with your ordinance, which is what we think that we have here this evening. And we're going to be putting on expert testimony that will be addressing that tonight so that you will see that we are meeting all the requirements of your ordinance. Again, this property, which we intend to develop the warehouse on, was zoned general industrial. That's the majority of the property. And that's the location where this warehouse will be. So this body, and perhaps a prior version of this body, had made a determination that this is the appropriate location for general industrial in your township. There is a small portion of the property that's also in the light industrial zone. We will not have the warehouse in that zone. The only uses in that zone will be uses that are accessory to the warehouse and uses that would separately be permitted to be in that zone. We also recognize that anytime you have a project of this size, this development, residents are not going to like it, and they're going to be unhappy with it, even if you determine that it is permitted under your ordinance. So, because we want to accommodate some of those concerns, we did submit some conditions of approval that I know that your council has looked at, and there's been some questions back and forth. Those conditions of approval, we believe, while not required under the ordinance, are intended to mitigate adverse effects to your community. And we encourage you to look at those as part of your decision. Those are things that we are voluntarily willing, on behalf of the applicant, to impose on ourselves and impose on tenants there down the road in order to address concerns that this board may have and this community may have. With that said, we're going to put on 3 witnesses this evening. I realize I have got 80 minutes in order to put this testimony on. For those of you who will be watching your clock and thinking I'm going to divide it evenly, the first witness will be much longer than the last 2. But I hope that we can get through all of this within that time period. We have a number of packets of our exhibits, and I will ask one of my witnesses over there, someone who is over there who has the ability to walk up onto the stage. All of the documents have been provided to you. I know you have all those available, but there are 13 specific exhibits that we will be dealing with this evening. I wanted you to have copies because when I came to see the room earlier, I realized that you could not see the screen. My colleague behind me will be showing these exhibits on the screen to the audience as we go through them so that they have the ability to follow along as well.
I'm good.
So with that said, as those are being handed out, again, we appreciate this opportunity to present the plan, present it in this forum, and are glad that we can be proceeding here. Solicitor Schultz, would you like all of our witnesses to be sworn in at once to begin with?
That would be most convenient, sure. So if you'll introduce them and if they'll stand.
We have 3 witnesses this evening: Greg Holtzman, Al Busher, and Jared Neal.
And if you'll please raise your right hand. Do you swear or affirm to tell the truth in the matter proceeding tonight?
I do.
Thank you. You're sworn.
Thank you, and we'll begin by calling Greg Holtzman.
Mr. Solicitor, hold on. Is this on? Mr. Solicitor, she said there's 13 exhibits. I don't know if my math is wrong, but what I got on the 19th from Ash was 6 exhibits.
Okay. Can we work to clarify what that might be?
Well, these are all exhibits that were, as my colleague, Mr. McCombie, said. He said we were using exhibits that were presented before this board. So these are all already part of the record before this board. Those are 13 exhibits. And I'm sorry, did someone take a copy over to Mr. Cluck?
There are perhaps portions of this that are part of the application.
Yes, they are part of the application. They are all things that are part of the public record. I don't think that there's nothing here that has not been previously provided that is part of the public record and that's been made available to you.
Okay. And that was clarified by email that anything that was part of the application was already part of the application in public record and would have been constructively received by your attorney Clark. If you identify anything in there that is an expert report, certainly that differs from what you had received.
How did I constructively receive documents?
There was an email exchange that we had perhaps a week and a half ago, that anything that was part of the application is a public record, and you have the ability to receive that. We had an email exchange, you'll recall, where you wanted to ensure that you had the latest versions of items.
Of certain documents, but the application has never been made public on the township's website.
It's subject to the right to know. It's subject to the right to know law.
Which I believe we still have outstanding requests. But the point I want to make is the proposed conditions that I did not see until yesterday. Do you consider them part of the application? She just said they're not required by the ordinance, and my position is if they're going to be an exhibit, they should have been produced a week ago with every other exhibit. It's not part of the public record. It hasn't been presented to the township. So I don't think the board should be considering these proposed conditions at this time.
Sure. Proposed exhibits, proposed conditions would typically be part of the application. In a typical land development proceeding, an applicant can bring those proposed exhibits the night of the hearing or meeting if they wish to. So we're going to proceed. We're going to proceed with this, and we of course do note that the final exchange of those conditions were pretty late in the game, and the board has not had an opportunity to fully consider them.
Just note my objection.
Thank you. Okay.
Thank you. I'll turn to Mr. Holtzman and ask you to please state your name and business address for the record.
Yes, hello, my name is Greg Holtzman with BL Companies. Our address is 2601 Marketplace, Suite 350, Harrisburg, PA 17110.
What is the nature of BL's business?
We are an architecture and engineering firm that provides consultant services.
What is your role with BL?
I'm a senior project manager.
As a senior project manager, what are your responsibilities?
I have three key focuses. One is the management, project management. One is a supervisory role, and the other is business development.
Can you tell us your educational background, your degree, the institution?
Yes, I'm a licensed landscape architect from Penn State University.
What does that mean to be a licensed landscape architect?
I went to schooling to sort of work with the built environment, to look at the architecture, the environment, all things that put together to a successful package.
How long have you worked in this industry as a landscape architect?
Over 20 years.
And have you been the project manager for industrial projects, including warehouses, previously?
I have.
Approximately how many warehouse projects have you worked on?
In the last year alone, I've either managed or co-managed over 20 projects.
And does that work where you have managed or co-managed the projects, does that include designing or overseeing the designs for the site layout, the parking, screening, and the other improvements?
It does.
When you do that work, do you review municipal ordinances?
I do.
And why do you do that?
To become familiar with the ordinance requirements.
Is the intention that you then create a compliant plan that complies with all the objective ordinance requirements?
Yes.
I'm going to ask my colleague to put exhibit A1 up on the screen, and if you, I know you also have a stack of those there as well. Can you identify what A1 is?
This is my resume.
And it is a 12-page document, but does it accurately describe your qualifications and your relevant work experience?
It does.
And did you apply that experience in working on this project and reviewing the municipal ordinances with respect to this particular project?
Yes.
Solicitor Schultz, we would offer Mr. Holtzman as an expert witness in site design for warehouses, distribution centers, and similar uses.
Attorney Clark, is there any objection?
I'd like to examine the witness on qualifications, if I may.
Sure, you may.
Okay. I'm sorry. Can I be heard if the mic is this far away from me?
The closer you are to the mic, the better.
Got it.
Yeah.
Greg, you have experience with warehouses. How many of them were proposed warehouses without the identity of a tenant?
At least half.
And in your work on behalf of warehouses, what is your experience with noise from warehouses?
I've worked with industry professionals.
Do you have any experience yourself with respect to noise studies?
I've worked with industry professionals that have provided me guidance.
What is your experience and qualification to testify about noise?
I have several projects that I have worked with industry professionals that have provided me guidance.
What is your experience with respect to lighting?
I have worked with multiple industry professionals internally and externally on lighting and design.
And do you have any academic or professional experience with respect to lighting design?
I've used lighting design software in the past.
What is your experience with respect to pollution from trucking operations?
I've been a part of many projects that this was a topic of discussion.
What is your basis for expertise on pollution from trucking operations?
I've coordinated and managed folks who have oversaw it.
Mr. Solicitor, I don't have a problem with him on warehouse or I think Helen used a distribution center design. I would object to any testimony from this person who's not an expert on noise, lighting, or pollution associated with trucking operations.
This is a hearing for public comment, and although we're trying to establish some expert qualifications, we will note that and we'll allow that testimony. Again, as I said in the beginning, this is not constraining any further development of a record or any objections that you may have if this were to be appealed to court. So thank you, Attorney.
I don't understand. What possibly could be established on an appeal? The question is this witness qualified under 702 of the Rules of Evidence? Are you saying the Rules of Evidence don't apply to them?
That's correct. Under the MPC 508, subsection 5 that I referred to earlier, this is a hearing for public comment. We formatted it this way to allow focused, really discussion and information from experts. We wanted to hear the experts' qualifications. Nothing suggested that formal rules of evidence apply to this. In fact, in the rules themselves, there in the beginning of those rules, it explains that the typical formality that you might have in court does not apply to this proceeding. The typical formality that you might have in court does not apply to conditional use proceedings, for that matter. Go ahead.
I'm sorry, I interrupted you. I'm sorry.
Go ahead.
Then what's the purpose in Rule 7 for cross-examining the credentials of witness if you're not going to pay any attention to it?
For you to establish any information that you need that you may need to refer to later in your closing or in your case in chief.
Thank you.
Okay, you're welcome.
And I'll also just note for the record in response to that objection that an expert witness is allowed to rely upon expertise of others in the course of his or her work. Mr. Holtzman, Panettone, is that the specific entity here? I may as well read it into the record once. It is PDC Northeast LPIDJH/IM LLC, which I'm referring to as Panettone. Is that your client?
Yes.
And where are their offices generally located?
So they have offices out west, and then they also have a local regional presence.
And the local regional presence, where is that person located?
I believe on the East Shore.
The East Shore, the Harrisburg side of the river?
Yes.
And can you describe this project for us?
Yes, as an overview, this project here consists of basically a 1.2 million square foot warehouse with the associated amenities.
And what are the types of goods that would be stored there?
This facility here, although it remains speculative, would have warehousing type of materials.
And when you say remain speculative, what do you mean by that?
So there's not a current tenant at this space, so this is a speculative building.
Will the warehouse also include administrative offices to support the operations?
It will. The breakdown is probably 9% for storage and warehousing, and then the remaining 10% will be devoted to offices.
Is refrigerated storage proposed?
No.
Will any explosives, flammable combustible materials or fluids, toxic chemicals, other than what you would find typically in a Target or a similar store for like home cleaners, radioactive material, biohazardous materials, municipal waste, bulk fertilizers, large quantities of pesticides or herbicides nuclear material, will any of those items be stored at the facility?
No.
Is any manufacturing, processing, or outdoor storage proposed?
No.
How frequent will products or materials be distributed or restocked? Trying to get to how long will they be stored there?
Sure. So this is designed as a 24/7 facility. So goods and services will be coming and going throughout there. The length of time that they are within the facility depends on the tenant.
Will some items have a more frequent turnover?
Yes.
And then the converse, that some items will have a less frequent turnover?
Yes.
Now, I know we're going to get into our traffic engineer later, so I won't get into with you on the details of the vehicle trips, but can you talk about damaged products? That something is damaged in the warehouse. How was that disposed of?
Sure. So there's, I guess, 3 scenarios. One, if it's slightly damaged, that can be repackaged and resold. If it is spoiled or something of that nature, it will be disposed of. And in the case that there is something that you would buy in a typical box store that is not hazardous, that will be removed in accordance with the guidelines and restrictions.
And those guidelines and restrictions, who imposes those guidelines and restrictions on dealing with that type of waste?
There's many different outside agencies.
And are those agency requirements what will be followed?
Yes.
I'm going to ask you to take a look at Exhibit A2. And these are some aerial images of the property that we're going to go through. There are 5 pages of them. So let's start with the first one. Can you first tell us where were these aerials taken from?
So this aerial imagery appears to be of a property that was taken from Net Online.
What is that?
It's a historical aerial photography site.
And I think those are the first 4 images. Do you know the last image? We'll get to that, but do you know where that one is from?
I believe it was from a Cumberland County tax mapper.
Okay, if you can describe in Exhibit A2, describe this first image that we have, which is, as you can see at the top, it's from 1984.
Yes, so the image that we're looking on site is of the subject property. You'll notice, and for ease of orientation, we'll just say at the top of the page is north. There we go, back on. Starting at the north of the property line, there is, you can see Texaco Road. Sort of to the right of that, this is predominantly farmland. As you move around to the right of our proposed site, it is existing farmland. To the south, you do have the existing railroad tracks, and beyond that is farmland. And then to the left, you do see evidence of industrial development.
And that evidence of industrial development, are those the round, almost look like marshmallows that we're seeing on the left side about halfway up?
Yes.
And then some buildings to the right of that?
That is correct.
Let's go down to the next exhibit, or the next page of that exhibit, from 1999. And tell us what 1999 this area appeared to based on the aerial.
Sure. So starting at the top of the page, with Texaco Road, there's more industrial development. To the right of the property, there is some infill from residential units. To the south, it is still predominantly farmland with some townhouse and residential development. And then to the left, you still have the existing railroad lines that would assume the overhead transmission lines.
We'll go to the next page, which is from 2010. What are we seeing here now, 11 years later?
What you're looking on at this exhibit here is the progression and development of, starting at the north again, more industrial development. I believe you see the start of Keener Drive. To the right, there was more sprawl and infill of residential units. To the south of the property is additional development for residential. The rail line is still there and the overhead transmission lines are there. And then to the left, more industrial development.
All right, we'll go to the next page of Exhibit A2 from 2017. And what is this page showing us?
So this page, again, is showing progression of development. So to the north of the property along Texaco Road, Keener is shown there with, to the right, you're seeing the continuation of residential development. The site to the south of the site is the continuation of, I believe, residential development. And to the left, you're still seeing those industrial uses.
All right, and let's go to the 5th page of Exhibit A2 and tell us what we're seeing here.
This is a modern aerial of the site. What you're seeing here, again, starting at the top of the page, is more industrial development, especially along Keener. Right and to the south is the fill for the residential, and then to the left is the, my mic keeps cutting out, is the existing industrial, and this still does show the rail line and overhead transmission lines to the south and left of the property.
So is it fair to say there was industrial and farmland and then the residential moved in?
Yes.
And what is the property currently zoned?
The property has 2 zoning designations. One to the right is I-1, which is light industrial, and to the left is I-2, which is general industrial.
And that small area that's east of Keener, behind some of the Stephen Drive residents, was the property always zoned that way?
I believe that property was rezoned from R1 to I-1.
And do you know when that was done?
If my memory serves me, 2022.
So the rezoning made most of the property the general industrial and part of it then was light industrial, is that correct?
Correct. So at that time it was, to the right was residential R1 and to the left was I1. And that was rezoned, the R1 was rezoned to I1 light industrial, and the remaining tract to the left, which was I1, was rezoned to G1 along with the properties to the north of it.
Can you describe the uses that are permitted in the light industrial portion of the zone?
Yes, and this is in accordance with the ordinance. I believe different types of shops, mechanical shops, automotive, recycling facilities. There's a gamut of industrial uses that are allowed.
Is manufacturing permitted?
Manufacturing is permitted.
If the entire property was still zoned LI or L1, however we call that, the light industrial side of that, would a 1.2 million square foot manufacturing plant have been permitted under the ordinance?
That is feasible.
We're going to get to the site plans in a little bit, but I want to talk specifically about how the light industrial portion of the property will be used, which is the property closest to Stevens Drive.
Sure, so I'm going to take a look here at the site plan.
Would it help if I moved on to Exhibit A3?
It would, yes.
Okay, thank you. Yes, we'll call that up. I think my colleague was ahead of me on that.
Okay, on this plan here, so the portion of the property that's in the I-1 is mostly employee parking, circulation associated with the building, and then there is stormwater management, and then there is some screening for the residential properties.
Is any development proposed south of Trindle Spring?
There is no development proposed south of Trindle Spring.
So the area closest to the residential uses, that's stormwater management basins and screening, is that correct?
That is correct.
And now that we have this up on the screen in front of us, can you just make sure we're looking at the right place? I know we don't have a pointer here, because I don't think anyone has a pointer. Can you kind of just by describing what you're looking at there in terms of where the light industrial is?
Sure, so on this exhibit here, the building itself is in the I-2 district, and the parking lot to the right of it by the number 5, that is in the light industrial district.
And just if you can just orient the board, generally what is this showing with respect to the development that is proposed on the property?
Yeah, so overall here, what you're looking at, again, is that 1.2 million square foot warehouse. It has up to 220 dock door positions. The orientation of the building is that there are loading docks to the north, which is the general industrial district, and to the south where that will be remaining undeveloped. Parking will be on the sides.
And so we're looking at the right place. Where's the LI area you mentioned? Is that where that number 5 is shown there?
That is correct.
And what is that where that number 5 is shown? Is that well, tell us what that is.
Sure. The left of the number 5 graphic, that is the employee parking lot. The number 5 is probably sitting on the exterior circulation lane. And then to the right of it, that shaded area there, that is a stormwater management facility. And then finally, along the property line is our screening.
And those stormwater management basin facilities, I know your colleague will get more into this later, but generally what is the purpose of those?
The purpose of those is to effectively manage the stormwater runoff from the site in accordance with the guidelines.
Is the proposed warehouse building within 200 feet of any residentially zoned land?
It is not within 200 feet.
And I think you mentioned this before, but I want to make sure that we're specific now that we're looking at this 1.2 million square feet. What's the floor space used for office as compared to actual storage?
Yeah, so again, it is typically 90%, so 90% would be for storage, and the remaining 10% is where your offices, your restrooms, and other things to support that operations.
Will you walk us through the access to the site?
Absolutely. Starting at the top of the page where it says not provided, on the right-hand side, yes, that is our main access point from Texaco Road, and that'll be Neil will there you go.
Can you repeat that? I realize your mic cut out there.
Oh, sorry about that. So starting at the top right corner there where it says not provided, that is the main entranceway from Texaco Road onto Keener. So that access from Keener connects to our site. When you meet our site, we have a circulation pattern that goes around the warehouse. And then finally looking all the way to the left, we provided provision for emergency access. And that's been in accordance with conversations with the township.
Are all the access drives onto the property proposed to be paved for a distance of at least 200 feet from the street right-of-way line?
Yes.
How many trailer spaces will be on the property?
For trailers, according to my chart here, I believe it was 254, if I recall correctly.
And how many parking spaces for personal vehicles?
So for personal spaces, and that graphics is low, so I'm going to go off of 214 to the left and 313 to the right for a total of 527.
And do those number of parking spaces comply with the township's ordinances?
They do.
How many employees are anticipated typically for, realize again this is a spec warehouse, but what do you typically anticipate for a warehouse of this size in terms of the number of employees?
With the spec building of this size, we anticipated up to 1,000 employees during the shift change.
What do you mean by during the shift change?
So we provide roughly 500 in 527 spaces, but we believe that it'll be 500 people working in this building.
At one time?
Correct.
And the plan is designed to provide parking in excess of what is needed for the employees, is that correct?
That is correct.
Do you know what the requirement for parking spaces under the ordinance is?
I do. The parking requirement, I'm going to just double check my chart here, is 1 space for 2 employees on the peak morning shift.
And are you providing in excess of that number of spaces?
I am. On our chart here, we estimated 500, and we're providing 527 spaces.
All right, thank you. We're going to go then to Exhibit A4. And this is a zoning determination letter. It's my firm's letterhead that my firm obtained from the township. Can you tell me how you use this zoning determination from the township in your analysis?
Yes, so this zoning determination is about the overall building height. So in the ordinance defines the height, and on our plans, what we're showing here is that over 35 feet will be uninhabitable.
And when you mean uninhabitable, what are you saying there?
That there will be no people that will be living up there, so this is an industrial use.
And this letter is dated July 7th, 2023, is that correct?
That is correct.
Do you know if it was obtained for this specific project or just for projects in general in Silver Spring Township?
My understanding was this was just an interpretation that will apply to all projects. But specifically, this does apply to our project.
And did this zoning determination letter provide clarity to you in terms of how the township's ordinances determine building height requirements?
Yes, it does.
And was this project designed to comply with those height requirements under the ordinance?
Yes, it was.
Let's also talk about screening. What screening is there? Let me know if there's a exhibit we need to go back to here.
We can go back to exhibit, not labeled, the overall land development plans. So specifically, there is a line of sight diagram. And just generally speaking, without something on here, we are providing screening along the perimeter of the site. That screening, there's a requirement for screening that at initial height, it's 6 foot within 2 years. It greatly diminishes the visibility of the warehouse. On the exhibit that you're seeing here is we went above and beyond and actually included a berm as part of this original development, in addition to the screening.
What's the ordinance requirement to make sure we're clear in terms of deciduous versus evergreen?
Yes, I believe there's a breakdown that it's mostly evergreen and there's a mix of deciduous. On our plans here, we are showing fully evergreen plants.
And how tall will the berm be?
This exhibit here shows it to be approximately 5 feet high. In addition to talks that if this is possible to make it higher, we will.
And is Panattoni willing to do that, make it even higher, up to 18 inches higher as a condition of approval?
That is my understanding.
How tall will the trees be at planting?
For evergreen trees, they're typically planting height typically starts at 6 to 7 feet. The trees probably within the internal parking lot, they're 2.5 to 3 inch caliber, so they could be anywhere from 8 to 12 feet.
How tall will they be when they are mature?
Speaking of just the evergreen trees, with the 3 that we provided, they will range from 40 to over 100 feet.
Okay. And sticking with this exhibit that we have up on the screen, which is our exhibit A5, how would you generally describe exhibit A5? What is this type of an exhibit?
So this is a non-ordinance required exhibit that we've provided early on to help visualize the line of sight. So the point of this exhibit was to show the various developments, residential developments around the site and the view sheds that they'll be seeing. So we've taken a person and have projected through existing vegetation, through the existing rail line, through proposed initial plantings and final plantings of what they may see.
All right, let's go back to page 1 of this exhibit, and I think this one is from the north. So what are we seeing here?
This exhibit, if it's from the north, is from Stephen Drive. And what this exhibit is showing is that at the time of initial planting, plus any of the existing vegetation, that the view of the existing warehouse will be severely diminished.
Is this similar to what you would also see from Cumberland Drive?
That is correct.
We'll go to page 2, which I think it shows the view from a property in Brook Meadow, where there's some townhouses, I believe, and from a property along Mulberry Drive. Can you describe what we'll be seeing there?
So the exhibits are all focused on the line of sight from a view or two of the proposed buildings. And again, you're seeing between a mix of existing vegetation and proposed vegetation that the view of the building will be severely diminished.
And will be even more diminished, block the view as time goes on and the trees grow larger?
That is correct.
Let's look at the final view. I believe that's from Evergreen, the south-southwest. Is that correct?
It's the third page, yes.
Yes, the third page.
And again, what you're seeing here is that this is a mix of existing tree lines, proposed infrastructure that's there, and even with new plantings, that the view of the proposed warehouse will be diminished.
So generally, will the warehouse be visible to residents in the area?
In my opinion, predominantly no.
We're going to pull away from the site design for a moment. I want to talk about the lease for whatever tenants are there. Will that lease include a no idling policy that's equivalent, consistent with applicable state and federal regulations?
It will.
And what is that no idling policy?
That's a policy to minimize emissions, so over a 60-minute time, the vehicle can only be idling for up to 5 minutes for that reason.
Will the leases for the tenants in the property also include property management requirements to address waste and litter?
It will. They will have a full-service firm that will take care of the maintenance and upkeep of the grounds.
And does the plan, I know we don't have the full plan in front of us, but Note 130, does that address site cleanup on the plan?
Note 130 does address site cleanup on the plan.
How is mud on vehicles addressed to make sure we keep it off public roads?
Sure, that's several ways. During initial construction, there's the guidelines that we're following for E&S. And once the facility is built, in the event that there is any tracking of mud debris, there is part of the maintenance upkeep. In addition, there will be a street sweeping requirement that is part of the stormwater management.
Now, I know we talked a little bit about this previously, about the other uses that would be permitted in the LI district. Drop lots, machine shops, I think you mentioned manufacturing. Could those uses also be 24/7 uses?
Yes, they can.
And have you worked on projects involving those types of uses?
Yes, I have.
So 24/7 operation, is that consistent with the uses that are permitted in both the general industrial zone and the light industrial districts?
That is correct.
And how is that 24/7 operation mitigated for township residents?
A lot of that is, the ordinance does a really great job there of putting in different guidelines and protections for the residents. So with the operations of a
24/7 facility?
that's where is that right? Yes.
Yes.
At a 24/7 facility, there will be different options for lighting, for operations, things of that nature that'll help guide that.
Are you familiar with the potential nuisances that are referenced by the zoning ordinance in section 304.24E and H3?
Is that such as like light, noise, air? Yes.
Litter, dust, and pollution?
Yes.
And let's address those. Are most of the operations inside?
Do you want to try to? Only 50% here. Good to go? Okay, so most of the operations are conducted inside the premises.
Is there any outdoor storage?
There is no outdoor storage.
I know you previously talked about the location of the loading bays, but again, where are the loading bays located?
On the plan, again, with north being up, the majority on the top of the docks are facing the general industrial district, and then on the opposite side of the building, they are facing towards Trindle Spring, which will remain undeveloped.
Have you determined the distance from the nearest home to the nearest dock door?
We have, and it's at least 400 feet.
And with the screening that you mentioned, the taller berms, the 100% evergreens, that start, does that also deal with that nuisance as well?
It does, yes.
And how will litter and waste be handled outside the facility?
There'll be a management company that will take care of the upkeep and maintenance of the facility.
Will dumpsters be enclosed?
Dumpsters will be enclosed.
And how do you pick up and remove the waste?
They will contract with a professional company to take care of their waste.
Will the leases have requirements with respect to how waste is handled outside the property?
That's my understanding.
Talk a little bit about the lighting.
Sure. So I believe that The lighting has provision that the lights can be within a certain distance of residential area, 35 feet. The lighting on this facility here is proposed at 30 feet. There's also, the ordinance does, again, as I mentioned earlier, have provisions for the welfare of the neighbors so that these lights will be dark sky compliant. They will be shielded. And when we did the layout, we focused all the heads, the fixtures inwards towards the facility.
Are any flicking lights proposed?
There's no flicking lights proposed, nor is there any uplighting or signage.
Talk about emissions, please.
Sure, so there's as we discussed earlier, the anti-idling policy that will limit them to 5 minutes.
Is there any industrial ventilation system that could possibly be putting emissions outside the facility?
There's no industrial ventilation systems proposed.
How about mobile sources of emissions, cars, trucks?
Yes, and those are all regulated through licensure and Pennsylvania regulations.
Will there be any outdoor servicing or refueling, washing, those types of things, so that you've got running vehicles outside that would create emissions?
No, there will be none of that.
The township zoning ordinance lists a few federal, state agencies and regulations to consider with respect to various things in terms of nuisance. As to noise pollution and vibration, does DEP generally regulate noise pollution and vibration?
No.
How are they being addressed on this property?
Through the site planning process, we also have additional screening in where the spatial layout of the building is in relationship to the property lines and adjacent uses.
Are warehouses generally heavy vibrations creators?
No.
And how about backup sounds and those types of things? How are those being handled?
The orientation of the docks was to the north, again, was through the general industrial district, and to the south would be towards Trindle Run, which is the unimproved area of the lot.
Are warehouses generally odorless?
No.
How about glare and heat? Does DEP regulate glare and heat?
No.
Okay. Are warehouses, do they generally create significant glare or heat?
No.
Does the design comply with the Clean Streams Law, although I recognize that your colleague will address that more later?
That is my understanding.
How about the mine reclamation and open pit setback law? Does that apply?
That does not apply.
Why not?
There is no mining of this facility in this property proposed.
Does the site plan comply with the ADA for access?
Yes.
Do the state federal farming regulations apply?
No.
Let's go to Exhibit A6. And this is the township engineer's final comment letter that's dated September 16, 2024.
Mr. Solicitor, I just want to place an objection on the record. We've never seen this document before. This would appear to be one of those instances where we don't have this. Are we considering HRG reviews letters as part of the application?
They would not be part of the application. They would be a record of the township, a public record of the township.
And is your position public records of the township are part of this process?
A comment letter from the township engineer would be part of this process, of course.
Okay,
As under the NPC, the township has an obligation to provide any comment on any deficiencies of the plan.
Okay, I just want to note the record, this is an example of the public doesn't know about this, they've never seen it, this is the first time we've seen it, and we have outstanding right to know requests that have yet to be responded to. So I think it's fundamentally unfair to expect the public to participate in a process where we are playing on a level playing field.
Understood, Attorney Clark. And
Thank
you also recognize that when you have requested documents and confirmation through me, we have provided that.
I was supposed to say, do we have all the comment letters from HRG?
That would be, well, I would suspect that you might, because it's a standard part of the process, but if you did not, you requested under a right to know request. I'm sorry, let me pause the time here. When was the right to know request submitted?
Numerous requests, numerous times by numerous people, is the best I can tell you at this point. Okay? Here's the point. We are playing on a level playing field. I object to the way the township is handling the public. I don't think this is fair. I understand when they submit dozens and dozens and dozens of documents and you don't make them automatically public or a controversial project, it places us at a disadvantage. It makes the public incur costs that they shouldn't have to incur because they're taxpayers and they're funding your salaries. And you're making us jump through hoops we shouldn't have to jump through.
Would of course be a separate policy decision that a municipality would need to make. Let's proceed.
We put on the screen Exhibit A6. Can you tell us what that comment letter is?
Yes, this is review letter 6 from HRG, and the basis of this is that we are technically complete and that we're just remaining with administrative comments.
Is this the typical process for all land development plans, that you get comment letters and then you respond back and forth with the township staff and engineer?
Yes, it is.
In your experience, would you call this a clean comment letter?
I would call this a clean comment letter.
Okay, and so we're clear, what does that mean that it is a clean comment letter?
So to me, a clean comment letter is technically clean in that the remaining items would be conditions of approval.
Now, are there a few waivers that you're requesting with respect to this project?
Yes, there are.
Let's walk through those. What's the first waiver? I think those are in that comment letter. If we can scroll down and maybe if my colleague can make it a little bit larger when we get to the waivers. There, that first waiver. Maybe a little bit larger there, a little bit down further where it says waiver. Yes, up. Yeah, you see under the heading waivers, number 1. If you can make that just a little bit larger so that people can see it. Can you tell us what that first waiver is?
Yes, this first waiver here has to do with preliminary final sets. So basically, this development here does not have any phases, so it's one land development.
And is it typical for that type of waiver to be granted?
This type of development, yes.
Let's go to the second waiver on sheet size. What is that waiver request?
Given the size of the property, there's a lot of information. To increase legibility, we've asked for a waiver to enlarge the plan sizes.
Let's go to the third waiver. What's that request?
This waiver here has to deal with sort of truck turning radius. So inside the facility, we do provide this, and it's meant through a combination of arcs versus one overall arc. So we are providing for not only our internal truck circulation, but also for fire.
And are there also stop signs and stop bars and line striping to assist with that?
Yes.
What's the next waiver?
The next waiver here is for the requirement for the basin bottoms to be above the 100-year floodplain.
And why is that request being made?
Our basin bottoms are below the 100-year floodplain. My colleague can go into that more, but basically they'll have a clay liner, and then above that will be vegetated.
The next waiver, with respect to the size of the stormwater management pipes, what's the purpose of that?
Yeah, so on this facility here, we're going to be dewatering with sort of a pump system. For the efficiency of the pumps, the pipe sizes will be are needed to be smaller than the general guidance in the ordinance.
And then the final one, the sixth one, with respect to gutter flow.
Right, this is a stormwater type request, and this has to deal with in the back of the trailer stalls that there will be some water that is spreading away from the curb line to the inlets, and we're looking for relief from that because it's not in a public road or street as this dictates.
Is it fair to say that this development, the project as it's planned, it offers basically a substantial equivalent to those subdivision requirements that you're not technically meeting?
It does.
And is there any additional benefit to actually complying with the specific things that you're seeking a waiver for as opposed to the way that you're addressing them?
I think it's our opinion that these are more beneficial.
Okay. And then would literal enforcement of these requirements basically frustrate the effect of the improvements that you're trying to make?
Yes.
Let's go to Exhibit A7, which is the Township Staff Final Letter. And how would you describe Exhibit A7?
From the comments here, there's a strikeout of the comments in that I do not see any technical comments remaining.
So again, would this basically be a clean letter?
Yes.
Did you also respond to this final comment letter to make sure that everything, that addressed what was being addressed there?
Yes.
Okay, let's get that up on the screen. I think that's A8. And in Exhibit A8, which again, I realize is a long document, but did that address all the comments, the final comments that were in Exhibit A7?
Yes.
Can you talk about what the plan is for the old farmhouse that's on the property?
Yes, so there's an existing farmhouse. It's a 19th century farmhouse. Originally, there was an attempt there to preserve it. However, upon further consultation and review by our other professionals, it was deemed that that building would be best to be demolished, and that a donation to the it's the HBFF Historic Barn and Farm Foundation be made, so that that other properties and other farms that are in disrepair can utilize that funds and preserve their piece of history.
Are there any other permits that you're responsible for getting?
Yes, I'm responsible for the GP5, which is a water line crossing, and I'm also responsible for the sewer module.
We'll start with the sewer module. What is that?
That is basically our way of having the township DEP recognize our facility and to say they have capacity to serve our city.
What's the status of that permit?
That is approved.
And then the DEP GP5, what's the status of that one?
That is also approved.
Are there any other outside approvals that are still required for this plan?
I believe there's two. One is going to be PennDOT, and I believe we'll receive the CLOMR-F.
And the CLOMR F. Well, we'll let your colleague get into what that acronym stands for. Let's go to Exhibit A9. And this is the conditions of approval that the applicant is offering in general. Again, I know that there are multiple pages here, but in general, what is being offered?
There are several line items here being offered. They range from enhancement of the screens to enforcing the anti-idling policy to making sure that there's programs in there for race, among other things.
Does it also involve putting funds into escrow to benefit the residents in the area?
It does.
All right, that is all I have for Mr. Holtzman.
Attorney Gillen, you have about 37 minutes and 5 seconds left for your remaining witnesses. I just want to clarify on Exhibit A9, there was an exchange of additional revision of this. Is this the latest?
It's my understanding it is the latest. I will take a quick look at it to be sure that it is the latest, but I believe it was just based on when I received it today. But I will confirm that for you. Thank you.
Okay, thank you. Attorney Clark, you may cross-examine the witness.
I think you want to do this one at a time. Fine. Exhibit A9, Greg? Do these require any revisions to the application to the site plan?
I would have to do a more thorough review before I can answer that.
I'll wait. Did you share the conditions with the township staff?
That would be a question for the attorney.
Do you know whether the township staff reviewed the conditions?
I'm not aware of that.
Attorney Clark, I'll clarify for you. The latest conditions were sent to me this afternoon as we were preparing for this hearing tonight. So staff has not had the opportunity to review the final revision, nor has the board of supervisors at this stage. And we'll be addressing that later on in the hearing.
Well, I think my question is, were the proposed conditions drafted with input from the staff of the township?
My understanding is that there was not.
So these were proposed by the applicant himself, period.
Yes.
Were they presented to the planning commission for review?
From my understanding, these are relatively new, so my understanding is I do not believe they were.
How much money is being proposed to give to the residents?
I'm more than happy to walk through these here to read it with you. So again, this is a newer document, so I need some time to review it here, but we can look through it.
Well, only because it was introduced and you were questioned about it, that's why I'm cross-examining. If you weren't questioned, I wouldn't have questioned you. But assuming, if you were questioned about it, I'm going to assume you have knowledge of it. And your testimony was there'll be money left over for the residents. How much and which residents?
So my understanding, and again, this is a newer document, that there was allocation of dollars that it was going to be into, it's number 18, and it says it will be into an escrow account, which will be held by an escrow agent agreed to between the township and PDC. So there's provisions here that go through here. As you go through those provisions, I'm looking at B right now.
Well, 18A says the developer is going to pay the township's legal fees if there's an appeal.
So 18A says first to pay litigation related to LD plan.
Is the developer going to pay the township's litigation fees if there's an appeal? Or are you saying if you have to defend the plan in an appeal, it's going to come out of this escrow account that's designed to benefit the residents?
I can read what's written here. First, to pay the litigation related to the LD plan and PDC's development of the PDC parcel, including for all related permits and approvals at PDC's sole discretion. Then, the condition on PDC securing final unappealable approval of the land development plan and all related permits and approvals, and not to exceed the amount of the mitigation and litigation funds, less any amounts PDC chooses to spend on litigation related to the LD plan and PDC's sole discretion. So then first, to pay the township's transportation impact fee and other township fees, or fees in lieu of improvements or dedication of the land, and then to be used for transportation and other improvements for the benefit of the owners of the residential parcels.
Which residents? The ones who are parties or the ones who are not parties?
I can look through this document more, but at this time I can't comment without further review.
Okay. I believe Ms. Gemmel, in her opening statement, says, I think she was talking about something about the rezoning, but she mentioned that, I think she said, March of 2023 is when a contract for equitable interest in these properties occurred. If I'm wrong, someone will correct me, but I wrote down March of 2023 is when they developed an interest in these properties. If you know the answer to that answer, if not, that's fine.
I don't recall if that's the exact date.
Do you know when BL was retained for services?
Without looking at the contract, I do not recall.
Okay. Looking at Exhibit A4, the McNeese letter. I believe your testimony was this was, I guess we'll call it a generic letter seeking an interpretation of inhabitable, uninhabitable. Isn't it interesting this letter is written after McNeese has an interest and the client has an interest in this property as a warehouse?
This letter here is a clarification of the ordinance.
Well, your testimony was it wasn't specific to this project. Am I recalling your direct exam correctly?
Although it can apply to this project.
That's not what I recall you said, but we don't need to dwell on that. Look at the last page of that document, page 3 of the exhibit A4. When did the zoning officer sign this letter?
You said the last page of A4?
A4, July 7th, McNeese letterhead. In my capacity as zoning officer of Silver Spring Township, I concur and make the determination. When did Chelsea Levy sign this letter?
I do not see a date next to her signature.
So it could have been yesterday.
I do not see a date next to her signature.
Yeah, I'm just trying to figure out when did the public become aware of a zoning officer's interpretation if they wish to appeal this determination?
I cannot answer that question with no date on the signature.
Understood. You were asked a lot of questions about the terms of a lease. Do you have a copy of that lease with you?
I do not have that with me.
Is there such a document?
I do not have that with me.
Does it exist?
There are elements that I have seen that are for that document.
And who is this document with? Is it with Penn and Tony?
That is as part of the lease agreements?
Yes.
Yes.
I mean, it's a speculative warehouse, but you seem to know not enough knowledge to tell us about lease provisions, but you can't tell us what the use is going to be. So I want to start asking some questions about what's the authority to testify about a lease that's not in evidence, that's not part of the application, that hasn't been in the back and forth between HRG and TPD about this project.
I'm not qualified to go through lease agreements.
And why were you qualified to testify about a maintenance agreement, at least a dozen topics?
The items that I've made aware of that apply to this project that are in the benefit for the health, safety, and welfare, I can testify to.
How do you know it's not going to have refrigeration?
My understanding is that with a typical warehouse, it will not have refrigeration.
This is a typical warehouse?
A spec warehouse is not designed with refrigeration. There's different elements that would have been proposed if it was for refrigeration.
And what if they decide to have refrigeration? What do they have to do with the Board of Supervisors?
I would believe they would have to consult with the township and go through a process.
I don't know that I heard this. You were asked about I-1, the light industrial zoning. Did you testify a warehouse is allowed in an I-1 zoning district?
I believe it was mentioned a warehouse is not permitted in the I-1, is permitted in the I-2.
I just want to clarify that. That's why I started with, I don't know that I heard that. Okay, so I-1 does not allow a warehouse. Is a warehouse allowed in the floodplain?
Per the ordinance, a warehouse is not allowed in the floodplain.
Almost done, Sean. The waivers. I'm sorry, Helen, which exhibit was the waiver letter?
I believe that's A6.
Yeah, where they say. Hold on, I got it somewhere. John, you know, you said it's typical to have back and forth with the township staff, the township consultants, right?
That is correct.
How many of your warehouse projects had four traffic review letters from HRG? How many of the projects you've been involved in have had 4 review letters just on traffic? If you know.
I cannot recall off my head, but traffic review letters with the township is common.
Okay. Floodplain. How many of your projects had 4 separate review letters just on the floodplain?
Coordination with the township on the floodplain is also not uncommon.
I'm sorry, it's not in.
It's not uncommon. I have other projects that we're coordinating with floodplain.
Well, I understand it's typical to go back and forth. 4 times? Is that typical?
It can be.
Subdivision land development, 5 review letters. Why did it take 5 review letters to get it right when it should have been right on the original application?
As the plan progressed, what we were striving for was a clean letter. And to get that clean letter, we've had subsequent reviews and meetings with the township.
All right. A6, the so-called clean letter on waivers dated September 16. Let's look at waiver number 3. What provision of the ordinance are you seeking a waiver from with respect to waiver number 3, if you know?
What's written is the applicant is requesting that...
No. What provision? Not the content. What section? What number? What subsection?
On the letter I have here, it is not written.
Did you request the waivers with BL? Did you request waivers?
Yes, we requested the waivers.
Were they all part of the application?
So the saldo that you asked for was 602.18.G3. I'm sorry, .3.G.
And what is unreasonable about that provision of the ordinance that you could not meet?
We have a unique situation that we're actually providing something, in our opinion, better.
What's the undue hardship from that?
So if we met that requirement, that may have an impact on circulation.
And that's something created by the site plan, isn't it?
That's a mix between the site plan and also the vehicles that are intended to use the site.
And you said, I think your testimony was the benefit, it's disproportionate to any benefit. And I think you said the benefit was greater than the hardship?
Having relief from that requirement there will be more beneficial to this development in terms of circulation for both our internal vehicles and also fire and emergency services.
I'm still waiting here. What was unreasonable about this standard?
Having that standard would have an impact on our circulation.
And what kind of impact would that have been?
That would influence the use of the drive aisles for emergency and vehicular traffic.
Emergency and vehicular, or just emergency?
It's emergency and our vehicles that are using our site.
Same question for waiver request number 4. What's the provision of the ordinance and what's the undue hardship?
So that waiver number 4, I'm looking at the site plan here, was for the facility bottom elevation.
Yes, sir.
Could you repeat your question, please?
What's the provision of the ordinance you're seeking to be waived? And what is the unreasonableness of the standard? And what's the undue hardship?
So in our application here, we're requesting a waiver of the requirement of the basin bottoms to be above the 100-year floodplain. The applicant is proposing basin bottoms lower than the 100-year floodplain elevation to maintain the general drainage pattern of the large stormwater pipes when it reaches the basin bottom. The basins are designed to be lined with a 12-inch clay liner. Additionally, the basins include a clay core embankment to limit the potential of any groundwater entering the proposed basins. The stormwater management design also includes check valves at the outlets of the proposed basins to prevent backflow and excess capacity in the event of back-to-back storms.
So you cannot articulate what is unreasonable about the standard that you're seeking a waiver.
In our particular development, we are looking to have our basin bottoms below the 100-year elevation.
When was this waiver requested?
There is not a date of when what's written here and when it was applied for.
Was it part of the February 2024 original application?
I do not have a copy of that application.
Did you submit the application on behalf of your client?
Applications were submitted, however, I do not recall what was written on that application.
Do you believe all waivers should have been included in the application and not sent in piecemeal?
I believe that as a project progresses and as we have more conversations with the townships, waivers can be brought to light.
Waiver number 5 and exhibit number 6, what's the undue hardship or what's the unreasonableness about the standard seeking waiver?
Would you like me to read 5 and 6?
No, I can read it, everybody can read it. I want to know what was the undue hardship. And if you're telling me it's in there, then show me where in that comment from HRG that BL is making a comment on why it's an undue hardship.
So 5 has to deal with basically the stormwater pipe size of 15 inches to be partially waived. So it is a partial waiver. And that is only for a specific piece of this overall stormwater management facility.
Are you able to articulate the unreasonableness about that standard?
I can recite what's written here and I can read off what's written here.
Okay. Other than that, no other information was provided as part of the application process demonstrating the unreasonableness of the standard that's being sought to be waived?
I do not recall if that was provided.
You talked about pollution. And I think your testimony was mobile sources. They're not regulated, are they?
I'd have to, give me, what document are you referring to?
Your testimony, you were asked about mobile sources for air pollution, I think.
Are you referring to like employee vehicles?
No, I'm talking about your direct examination. I took some notes. You were asked about whether DEP regulates noise. You were asked about whether mobile sources were regulated. And I'm going to ask you questions about that. Are you able to testify about mobile sources?
I've worked with professionals in the industry and I do have an understanding of this.
Okay. Does DEP regulate mobile sources?
To the extent of those regulations, I believe I'd have to, I'm trying to find my exhibit here. that passage, you said you were taking notes. Can you read that back to me during our testimony?
Yeah, Helen asked you the questions. Are mobile sources regulated? Answer. No. Do I need to find your comment to an HRG letter asking for how you comply with 324.304E about expert evidence about noise and pollution and litter, and the fact that your response was boilerplate garbage, but you've now been qualified as an expert. So I'm going to assume you're the expert providing the evidence for how they meet 324.304. Talk to me about pollution and mobile sources.
My answer was referring to, I believe, cars and trucks that are regulated by EPA.
What's cars and trucks?
So that
Oh, cars and trucks. I'm
Yes,
sorry.
okay.
My apology. Cars are regulated by EPA.
There's emissions, yes.
And what's the regulation on emissions associated with cars and trucks at a warehouse?
I think this is generally speaking, so with emissions, you get an emission sticker.
Okay. Let's just cut this case. Permits are not required, correct?
It's my understanding.
Right. Do trucks emit diesel fumes?
Yes.
Do automobiles emit pollutants when they're not electric vehicles?
Yes.
Will there be an electric vehicle charging station at this warehouse?
There's none currently proposed.
If one was going to be proposed, should it be in this land development plan?
I can't comment on speculation.
How many children live within a quarter mile of the proposed warehouse?
I do not know that answer.
How many senior citizens live within a quarter mile of the proposed warehouse?
I do not know that answer.
Have you read any studies on air pollution associated with warehousing operations and their adverse impact on children and senior citizens?
I work with design professionals that have.
And what's the conclusion from those studies of the professionals you work with?
I don't recall.
I think you said there'd be sweeping of the parking lot is part of the plan.
That is correct.
Is that part of the lease?
That'll be an item that will be asked to be part of the lease.
That's what I mean to read.
Yes.
And how frequently will they be swept?
That will all be part of the post-construction stormwater management plan.
Is there such a document?
A post-construction stormwater management plan?
Yes, sir.
That is part of our package.
And what does it say?
That street sweeping will be provided at certain intervals.
What intervals?
I do not have that document in front of me.
What type of street sweeping? Are we talking about broom? Or are we talking about a vehicle pushing that? Or are we going to wash down the pavement?
I do not recall if that's specifically illustrated in our documents.
Do you have a copy of the post-construction stormwater management narrative on pages 13 and 14?
Of the land development set?
No, of the post-construction stormwater management plan. 422 pages, dated July 15, 2024.
I do not have that in front of me.
Okay. Does it address oil?
I do not have that document in front of me.
How does oil find its way into the environment from vehicles and trucks at a warehouse?
Is there a differentiation between a warehouse and everywhere else?
I'm talking about this warehouse and pollutants at this warehouse and how you're going to manage pollution. That's one of the requirements of the ordinance, and I'm asking you to talk to me about oil. Where does oil come from that ends up on the pavement, that ends up on the floor of the warehouse? How does it get into the storm drains, and where does it go?
If I had to speculate, if there was an accident, there are provisions on site for booms and things of that nature to mitigate any oil spills.
Hydraulic fluid.
If there was an accident, there's provisions in this package here to provide options to mitigate that.
Transmission fluid.
Same,
Radiator fluid.
same.
Solvents.
Where would solvents be in a vehicle?
Would solvents be stored at the warehouse? Aren't they used for cleaning purposes?
Your answer is, are they used for cleaning purposes? I do not have a document from the management company to see if they're going to be using solvents or environmentally friendly products.
How are they going to handle ice? Are they going to use road salt?
That is an option.
Is there going to be grease? Here's my question. You have an exceptional value wetland on the property. You have watersheds that are deemed impaired that require a total maximum daily load. You've got a proposed warehouse where you seem to be giving the perception to the public it's going to be lickety-split clean. You're supposed to have a pollution prevention plan, and I'm referring to the stormwater management plan, post-construction plan, pages 13 and 14, that don't meet the EPA requirements. And I'm now asking you specific questions. What are you going to do? How are you going to handle it? And your answers are not responsive. How are these supervisors supposed to determine whether you meet or your client meets the requirements of the ordinance when you can't provide any expert testimony?
To address your question, the expert to address this will be the next presenter.
You were qualified as an expert. You were asked questions on direct. You are now deferring to a different witness. Mr. Solicitor, I move to strike his entire testimony with respect to the topics of noise, pollution, and pollution prevention because he wasn't qualified, but you allowed him to testify. This is not expert testimony that's necessary to meet the ordinance. He's not qualified, and he can't respond to questions.
This is a hearing for public comment. We don't even need to have people sworn in at this hearing. We've done that, and we have provided this hearing at your request, although it came at the planning commission, the last planning commission meeting. So we don't strike testimony in a public comment hearing. That's something that you would be able to develop if there's an appeal to the court.
Let me be clear. We are much appreciative. We are thankful to the Board of Supervisors giving us an equal opportunity to participate in the process. Your ordinance requires expert evidence. In order to meet a standard for expert evidence, you need an expert who's qualified. He's not qualified. It's not a question of public comment. It's a question of he doesn't meet the standard for you to approve this plan.
And I think that's why he deferred to a subsequent witness that can come forward.
Then,
that would be for Attorney Gemmell to deal with that issue with the next witness.
That's all I have. Thank you for your indulgence. Greg, thank you for your time.
Thank you.
Ms. Broy, do you have any questions? You'll need to, if you do have some. I can't hear you from back there. Can you shake your head? No question. Okay, thank you. Okay. All right, Attorney Gemmell, you may proceed, and you have 37 minutes.
I do, and I'm just going to have one question on the redirect. Mr. Holtzman, are you familiar with Section 305 of the Township's subdivision land development ordinance with respect to waiver requests that says that a waiver request can either remove or reduce an unreasonable standard or undue hardship as it applies to the particular property, which is grossly proportionate to any benefit derived from the standard, or when an alternative standard provides equal or better results. Are you familiar with those requirements for when you can get a waiver?
Yes,
Yes. And is it your testimony that what you're providing does provide an alternative standard that is of equal or better results?
it does.
Thank you. We'll call our next witness then.
I'd like recross.
Go.
Greg, are you familiar with the municipal planning code?
I'm not an expert in the municipal planning code.
Familiar with the provision regarding waivers and what's required to meet a waiver under state law?
I would need to revisit that documentation.
Okay, that's all.
Thank you. We'd now like to call Al Busher. Would you please state your name and business address for our record?
Alaric Busher, BL Companies, 2601 Marketplace, Suite 350, Harrisburg, Pennsylvania.
What is your role with BL?
I'm a principal engineer.
And what are your responsibilities with BL?
I provide technical oversight, guidance, review of land development plans.
What is your degree in and from what institution?
Bachelor of Science from Penn State University.
How long have you worked in the industry?
Over 25 years.
Are you a professional engineer?
I am.
Have you been the principal engineer for industrial projects, including warehouses?
I have.
Approximately how many?
Over the last 4 or 5 years, about 15.
When you do that work, do you review the applicable municipal ordinances to create a compliant design?
I do.
And do you also design and work with consultants on securing permits and approvals from state and federal agencies related to stormwater management and floodplains?
Yes.
Do those agencies include FEMA and DEP?
Yes.
Okay, we'll put up on the screen Exhibit 10, which is your resume. And I realize this is one that we had pulled off a little bit earlier. Actually, I'll pause for a moment and address Solicitor Schultz's comment from earlier. That is my error. I did not include the most recent version of the condition, so that is an older one. But obviously, you'll have the most recent one, which is the one that we were proposing. So that was my error. Exhibit 810, is that your current resume, except for one change because I pulled a slightly older version?
Yes, that is my resume, and the one correction would be the reference to my registrations. The Certified Professional Erosion and Sediment Control CPES certification is a certification I no longer use and is expired.
Okay. And other than that, does this resume reflect your current qualifications?
It does.
And does it accurately describe your work experience?
It does.
What was your role with respect to this particular application?
I was the principal engineer on it, the engineer record, specifically oversight of stormwater management, erosion sediment control design, and working with the sub-consultant on the FEMA floodplain permitting.
Okay, if you can slow down a little bit, I'm sure our court reporter would appreciate that as you're speaking a little bit quickly here. In designing this project, did you review the provisions of the township's ordinances that are applicable to the project and the proposed use?
We did.
Okay. We would offer Mr. Busher as an expert in site planning and design, including for stormwater management controls for warehouses, distribution centers, and similar uses.
Any questions to the witness at 10 o'clock?
I know. Site planning, design, stormwater management.
Site planning, design, including stormwater management controls.
Controls. Mr. Bushner, did you draft what's called the no-rise study?
I did not.
Do you know what a HEC-RAS is? HEC-RAS.
Yes.
What is it?
It's a piece of software that's used to analyze stream flow.
Do you have any experience working with HEC-RAS?
I've used it in my past.
Where on your resume would I find that experience?
It's not significant, and that's why we hired SWCA to perform that part of the analysis and design.
I don't have any objection other than I don't believe this witness will be able to testify about the no-rise study or the HECRAS aspect of it, HECRAS, HEC-RAS.
Okay, thank you.
Mr. Bushner, part of your role in this project was to address the floodplain, is that correct?
That is correct, through the sub-consultant.
And do you often use sub-consultants with respect to these areas?
We do, again, not an area of personal expertise, but I work with multiple HECRAS analyses.
And how then do you use what that sub-consultant provides to you in terms of what you present to the municipality?
We take the results of their analysis, their expert opinion, their professional opinion, and we use that to inform the rest of the design.
Does the township's ordinance here permit warehouses in the floodplain?
It does not.
And how does the township ordinance define what floodplain is?
In our case, it's based off of the FEMA floodplain.
So it's based on the FEMA map that determines where the floodplain is located?
Yes,
And FEMA is the federal agency, is that correct?
correct.
Okay. What was your approach to dealing with the floodplain in this case?
So in certain circumstances, FEMA will allow for a floodplain to be remapped, to be adjusted, whether it's by a natural kind of evolution of a watershed or by proposed improvements.
And did you propose improvements to be made here?
Yes, that was part of the application. We worked with SWCA to develop a plan and approach where if we placed Bill on what is currently a floodplain and adjusted the calculations and accounted for that, it would result in a no rise, which is the focus of the report, and show that there were no detrimental impacts to adjoining properties or rise of elevation on our property.
So if the data that the technical people put together demonstrate that there is no rise and no detrimental effect on other properties, then FEMA has the authority to approve a map revision, is
I'll
that
object
correct?
to the testimony. This is exactly what I objected to with respect to qualifications. He's now about to testify about the content of the no-rise study. They're not here. He's not qualified. This is inappropriate testimony.
It would be under civil rules, perhaps, but that's not what we're working under, and we'll continue to note your objections.
I will ask the board to vote on my objection. I think this is a critical issue. They have not presented the report. They've not presented a witness to testify the report. I think the board should make the decision whether they want to hear this testimony. It's not up to the solicitor. You're the board. You make the rules.
This is a hearing for public comment again, and I think I want to clarify that once again. Please. This is a hearing for public comment. It is not a conditional use hearing. It is not a court proceeding. Certainly the board can entertain that if it wishes. I would pass it back to the chairman, but this is an opportunity for public comment. Again, we would not have to have witnesses under oath. We chose to do that in part due to your request, Attorney Clark, at the Planning Commission to have the opportunity to cross-examine witnesses, which would not be required under Section 508, a Section 508 hearing. So I suppose Chairman Mocker, if you would like to entertain a motion to precisely strike or not allow further testimony on this subject. I think we're going to have to narrow down in terms of exactly the scope of that request.
The no-rise study, period. Or anything he's going to talk about, HEC-RAS. He already testified in it. He said you can have warehouses in the floodplain. He's wrong.
I did not say that.
Yes, you did. We all heard it. Did you miss? Well, hold on. I'm sorry.
I believe there was testimony earlier that you may not have warehouses in a floodplain.
That's not what he said.
Okay. So you made an objection. Okay. Chairman Mocker.
Yeah, Attorney Clark, and I guess more importantly for the board to consider where my thought process is, had we had our normal board meeting, had we had the normal process, this is a slight detour in what would have been a normal process last week. This type of testimony would certainly have been allowed. It would have been part of a normal process and a normal application. I'm speaking to the board on that, where my head's at. I don't think we're really in a format to formally strike a part of a record. I don't really understand what that would gain. I think, again, the board would normally hear this type of testimony from an engineer such as this. So I'm open to a motion if the board so wishes. I just don't know that we're really accomplishing anything by doing that. Any other comment or any other questions or comments from the board?
I will say, Attorney Clark, we have people come in multiple times. I've been a supervisor approximately 15 years. I weigh their credibility. If they say things that I deem to be not credible nature, that plays into my decision. So whether we do it or not, and I don't know how anybody else up here on the board operates, but I will say that we've had people before come in and I question either, their knowledge and or motive. In my mind, I discredit what they say. So for me, emotion or not, I'm taking everything in right now that it plays into it. So if they do things that are of not credible nature, it impacts my decision. I will say that. So motion or not, because we normally don't have that comes into play in my mind on how I make a decision. Thank you.
I would concur with Mr. Blanker.
Yeah, hearing no motion, I'll turn it back to Mr. Schultz. We'll continue with the testimony.
I want to go back just a moment because I think maybe I asked the question incorrectly with a double negative or something like that. So let me try this again, be sure that we are clear. Does the township ordinance permit a warehouse in the floodplain?
It's my understanding that the township ordinance does not permit a warehouse in the floodplain.
And how does the township's ordinance determine where the floodplain is located?
By the FEMA floodplain mapping.
Does FEMA have the authority to change its mapping?
It does.
And what process was followed here with FEMA with respect to the location of the floodplain?
The applicant applied for and received a conditional letter of map revision for fill, Clover F, as it's called.
And what is that?
That is essentially, FEMA has evaluated the engineering analysis and the application, deemed it to be acceptable, and agrees that if the plan, the project is built as described in the application, the first floor elevation of the building will be outside of the base flood elevation, above the base flood elevation.
And BL, under your authority, did you hire a subcontractor with expertise in this area to prepare a no-rise certification?
BL did hire SWCA to do that.
And did SWCA provide the no-rise certification?
They provided the no-rise certification.
Was that also provided to FEMA?
It was.
And FEMA had the opportunity to review and comment upon it?
Yes,
Was that also submitted to the township?
it was.
Let me ask us to look at Exhibit A11. Is A11 HRG's fourth review letter that addresses the no-rise study?
It is.
Were all of HRG's comments addressed per the letter?
It says we offer no additional comments, so yes.
So then, with HRG, the township engineer, not having additional comments, is the application then sent to FEMA for their determination?
It was then sent to FEMA, yes.
What did FEMA determine?
FEMA took no exception to the application and they granted the CLORAF.
So FEMA has issued the conditional letter of map revision to change the location of the floodplain.
They issued the conditional letter of map revision for fill in the flood.
Fill, yes, I'm sorry, I missed the F's. Thank you for that clarification. So what does that mean in terms of what the project can do now that we have that conditional letter of map revision fill?
From FEMA's perspective, they're okay with moving forward, and at the end of the process, at the end of construction, the client, the applicant will be required to submit some as-built surveys and some supporting documentation to show that it was built in accordance with that original submission.
And if it is built in accordance with that original submission, what do you then get from FEMA?
You apply for a loan or a letter of map revision, which officially changes the floodplain location.
And you can't get that, though, until you actually finish the project and provide the as-built surveys. Is that correct?
That's my understanding, yes.
Okay. But you have that conditional ability to move forward.
That's my understanding, yes.
Were you also responsible for stormwater management?
I was, yes.
How is stormwater being handled on the site?
Stormwater runoff is collected in your typical storm drain system, conveyed to two stormwater management basins, dry detention basins. From there, it is discharged through level spreaders, which spreads out the flow of the discharge over a riparian forest buffer and into receiving waters.
Okay. The basins, what are they designed to handle?
They're designed to handle a 100-year storm.
Were those designs reviewed by the township engineer?
They were.
And I know we had looked at Exhibit A6 before, that's their comment letter. Per your review of the letter, did HRG have any existing comments related to how stormwater management was being handled?
I believe there may have been some references to outstanding agency approvals, but otherwise it was the resolution of the operations and maintenance agreement, which is a fairly standard administrative comment, conditional.
So in other words, HRG determined that the land development plan complies with the township's ordinances as to stormwater management. Is that correct?
Yes.
Exhibit A7, the Silver Spring Township staff letter. Are there any remaining comments in that letter related to stormwater management?
No.
Does that mean to you and that the township staff understood and took the position that you adequately addressed stormwater management?
Yes.
Are there any outside agencies that review the stormwater management on the site?
DEP will review the stormwater management and it's often delegated to the conservation district.
And was that done here?
It was.
And were any permits obtained?
Yes, the NPDES permit was obtained, which includes the stormwater management design.
Okay. Was a post-construction stormwater management permit also obtained?
The post-construction stormwater management approvals are a specific part of the NPDES approval.
Okay, so as part of NPDES, you get your PCSM permit.
Yes.
Did you also work on securing the ENS permit?
I did.
What's the ENS permit?
The erosion and sedimentation portion of the design is also part of the NPDES permit. So it basically describes how we are treating runoff during construction.
And what agencies review and approve those plans?
DEP, the County Conservation District.
Have you received an ENS permit for this project?
Yes, as part of the NPDES permit.
Okay. And when was that approved?
June 10th, I believe.
Of 2024?
Of 2024, yes.
So you were in charge of the ENS permit, PCSM permit, compliance with the township's stormwater management ordinance, and securing the Clomber F to address the floodplain. Is that correct?
Yes.
And for each of these permits, did the township engineer sign off to say that you had satisfied all the requirements?
Based off of the comment letters, yes.
And then the final permit to close out your work will be the final map change from FEMA. Is that correct?
That's my understanding, yes.
That's all I had for Mr. Busher.
Turn the clock.
What was contained, what was submitted to FEMA and when?
There was a no-rise study. There was a part of that included the application for the Cumberland F, and I believe there was a community acknowledgement form.
Do you remember the date?
I do not remember the date, so
Was it after August 5?
was it after August?
Well, you were asked about Exhibit A11 on direct. Exhibit A11 is dated August 5. It's HRG's fourth review letter that says no additional comments. It's dated August 5, and I recall Helen asked you, and thereafter, this was submitted to FEMA, correct?
I probably did say that, yeah. So I guess maybe if I could backtrack on that, I would say that the application was submitted to FEMA. I don't know when it was submitted to FEMA, this
What?
letter.
Why'd you testify on direct that it was after August 5?
I guess in my haste to answer the question.
Oh. Where's the no impact certification demonstrating a detailed hydraulic analysis that the proposed project will not increase base flood elevations or affect floodway widths? That's called a no impact certification. Where's that?
I don't know.
Well, you're the stormwater expert. You're the one that worked with FWCA on the no-rise study.
We worked
You're the
with
one that just talked about FEMA. Where's that certification?
We worked with SWCA. I've talked to them about this application. I have a general understanding of the application enough that I feel I can speak to this group. I don't know the application or the documents inside and out.
What was the date of the no-rise study?
I believe the date was July, sometime July.
We have one that's sealed dated July 9. We also have a letter after July 9 saying that BL responded to comments and submitted a revised no-rise study. Where's the revised no-rise study?
The revised no-rise study was sent to the township. In speaking to SWCA about that specific item, it's my understanding that the remaining comments were administrative in nature, some narrative changes, nothing that impacted the results.
So the July 9 no-rise, in fact, was not the final version of the no-rise study, and therefore the solicitor misinformed us on whether we have the last version. Is that your understanding, Mr.?
I don't know that to be true or false.
You just testified it was. You said there's something after July 9.
I don't know when the solicitor, what the solicitor provided.
We specifically wrote to the solicitor, and graciously he said, I have the last versions. What I identified is the July 9 no-rise, the last version, and he said, yes. You're now contradicting him. Okay. Let the record show there's no response to the question. Did FEMA provide any responsive comments to the application, or was it just the September 12th letter?
The only thing I'm aware of is the September 12th letter.
If they provided comments, would your sub-consultant have been required to tell you?
I believe so.
So it's your understanding, since no one told you there was comments, it must be true there were no comments.
I don't know, it must be true. I would assume that they would tell us if there were.
The conditional letter of map revision based on fill comment document. Excuse me, strike that. The property information form was prepared by a Matt Pierce. He's with SWCA.
That's my understanding.
It's dated June the 12th. Are you familiar with that?
I understand that it's part of the application. I don't know the document inside and out.
He sealed it on June the 13th. You don't know whether that's true or not?
I don't have it in front of me.
When did the township manager sign off on the community acknowledgement form?
I don't know.
In completing a community acknowledgement form, what's your understanding of the requirement for the local government in that part of this process?
I don't know. That's why we hired SWCA to help manage that.
And that's why they're not here to testify, right? They're not here to present their report. They're not here for cross-examination. They're not here for the board to ask them questions. They weren't at the planning commission for the planning commission to ask them questions. Mr. Palmer, the township manager, in his designated capacity as an acting floodplain manager, July 29, signed off on the community acknowledgement form without any input from this community. You're not aware of that, are you?
No.
The FEMA letter of February 12th, did that change the floodplain?
The FEMA letter of February 12th.
Excuse me, did I finish February? Getting late. September 12th.
It did not change the floodplain.
So, your testimony is you cannot locate a warehouse in a floodplain, and FEMA did not change the floodplain, correct?
The floodplain will not be changed officially until the final letter of map revision is submitted and approved.
And what hoops do you have to go through to get that?
I would rely on SWC to manage that process.
So you don't know. Any of the proposed conditions address this issue?
Excuse me?
Are you familiar with the exhibit of proposed conditions presented to the Board of Supervisors?
I am not.
Okay. How many acres of fill are going to be required to construct this warehouse?
I've not done that calculation, but based on what I've seen from your experts' testimony, that you believe it's 25-ish acres.
Is he right?
I didn't check it, no.
Did you read his report?
We did.
Did he get anything wrong?
I would disagree with a number of his professional opinions.
Okay. Give me an example.
Specifically, the one that comes to mind is he stated that we completely ignored the local development requirements within the ordinance.
Sorry, the mic dropped out. What did he ignore?
There was a statement in the report, I believe, if I remember correctly, that said we completely ignored the low-impact development requirements. I would disagree with that. We are proposing street sweeping as a stormwater management control that is specifically listed in the DEP BMP manual as a source control, low-impact development BMP.
So that would go towards the pollution prevention aspects of stormwater management?
Yes.
And you're relying on DEP's guidance document about street sweeping?
It's a technical design manual that's pretty strictly enforced.
And is that the MS4 program?
It's through the 102 MPDS permit program.
Why not the EPA program?
The applicable regulations are the MPDS, the 102 regulations.
Applicable where?
Applicable to getting the MPDS permit.
Yeah, but I'm talking about land development plan. You just said, you said you disagreed with his opinion about the land development plan. The stormwater management plan is part of the land development plan. And I went through a series of questions about oils and hydraulic fluids and all kinds of pollutions that can occur that are not addressed in your pollution prevention plan. And all you're telling me is you're addressing street sweeping.
I would say that the street sweeping will pick up a good percentage of the total suspended solids, which will have any number of pollutants attached to them. It will be a significant portion of the pollution reduction part of this design.
And the discharge goes to exceptional value wetland?
After it's then going through a different treatment train of the extended dry detention basin, the level spreader for erosion reduction, and the riparian forest buffer.
And what pollutants are addressed by that treatment train?
The accepted pollutants that you can claim on the 102 application for the MPDS, the stormwater, are the total suspended solids, the nitrates, nitrites, and the phosphorus.
Not hydraulic oil, not transmission fluid, not gasoline, correct?
Those are not specific pollutants that are accounted for in the 102 process.
Okay. What other opinions of Mr. Hay do you disagree with? Because you weren't able to testify about your own proposal, but I want to know what's wrong with my expert's report. Let's save some time.
I don't understand your question.
Did you read it? Yes.
Yes.
What are the issues you have? What did you disagree with?
I
And you said a number.
don't have his report in front of me to read through that.
Would you like it?
No.
How objective, because that goes beyond the scope of the direct examination.
Well, the rule of evidence don't apply. This is public comment. This member of the public wants to know.
They're trying to move this matter forward, and he has his experts still to put on to testify to their report.
Right. Go ahead and talk. Please be mindful, we also want to allow all the public who are here wish to provide public comment to do that before they begin to fall asleep. Okay.
Well, it's your process. Don't worry, guys. I'm done. Thank you.
Let me just finish.
Yes.
Okay, thank you. I don't have anything further for this witness.
Okay. You have one more
I
witness.
have one more witness.
You have 23 minutes on the notice.
Thank you. Mr. Neal?
Ms. Roy, Mr. Busher, before you step away, Ms. Roy, come on down.
Just one, it's very important.
Ms. Roy, make sure you talk right into that microphone so that the stenographer can hear.
Can you hear me now? Everybody hear me? My question is for the diesel fuel, the transmission fluid, all the other pollutants that you seem to not know what to do to preserve our land and our water. Those of us that have wells are very concerned about what you're putting in place to prevent the pollution in our homes.
So the stormwater regulations provide a set of guidelines to develop a stormwater management program, including stormwater quality controls that address the typical pollutants that are generated by, it would include vehicle traffic.
Typical pollutants, though.
Typical pollutants for traffic, we're talking about.
For 500 employees at a time, right next door.
I can say we work within the guidelines of the township. We work with the township to develop a stormwater management plan. We work with DEP and the Conservation District to develop a stormwater management plan that they felt was adequate.
It doesn't sound adequate. It doesn't sound like you have put an effort into making sure that our land and our water is safe.
I would disagree with you there. I think we've done a pretty good job.
I think you need to do more. That's all I have.
No, I don't have anything further. I'll redirect that.
Mr. Neal is next.
Yes, thank you. Would you please state your business, address, and name for the record?
Sure. Jared Neal, Traffic Planning and Design, 4000 Crumbs Mill Road, Suite 102, Harrisburg, Pennsylvania, 17112.
What is your role with the company Traffic Planning and Design, which I know is often referred to as TPD?
Yes, thank you. The Senior Project Manager and Shareholder of the company.
And what are your responsibilities in that role?
Generally, management of the planning aspect of the projects as well as the design. And in this situation, we are doing both. We are looking at the project from its inception through planning and the design of roadway improvements.
What is your degree in and from which institution?
A bachelor's in civil engineering from the college.
And how long have you worked in the industry?
17 years.
Have you designed traffic improvements for warehouse projects previously?
Yes, I have.
Approximately how many?
Yeah, I would say over my career, probably about 40 projects.
When you do that work, do you review the applicable municipal ordinances along with the PennDOT requirements to create a compliant design?
Yes.
We're going to put up on the screen Exhibit A12. Is that your resume?
Yes, it is.
Does it accurately describe your qualifications and relevant work experience?
It does.
We would offer Mr. Neal as an expert in transportation planning and design for warehouses, distribution centers, and similar uses.
No objection.
Mr. Neal, what was your role with respect to this particular application?
So with this one, with this project, I oversaw it from its planning perspective, and then oversaw again the design of any roadway improvements that were being implemented.
And did you review the provisions of the township's ordinances in your design that are applicable to the projected traffic created by the use proposed by the application?
Yes, I did.
Okay. In your expert opinion, does your plan and approach comply with the requirements of the township's subdivision and land development ordinance?
Yes.
Okay. Now, you did a transportation impact study, is that correct?
Yeah, we did, yes.
Okay. Well, what is that?
Well, and I'll even maybe take a step before the traffic study. So typically on a project like this, or really any time that we have land development plans, when a traffic study is required, we will submit a scoping application or a scoping memo to the township. That memo is really, it's our understanding of what the ordinance is, and that's submitted for review by the township's traffic engineer. They take a look at what we provided. They can make adjustments or suggestions. Usually it's suggestions that we incorporate back into a revised memo or move forward with the traffic study. But that really outlines really the game plan or the basis for what the study is based on.
And are there particular intersections or areas that are scoped with respect to the project?
There are. Trip generation is one of them. The number of study area intersections as well as trip distribution. For this specific project, when we initially submitted the scoping memo, we had suggested 3 intersections. The township came back and said, we like that, but we'd like you to add a few more. So with that, the study was comprised based on township's input, looking at Locust Point and Texaco Road, Texaco Road and State, Texaco and Keener, Texaco and 114, 114 in Mulberry, 114 in Woods, and 114 in Carlisle Pike.
Okay. And then after you've got that approved scoping, what do you do next?
Yeah, so then from that point we move forward with completing the traffic study, and really that's based on looking at existing conditions. So we send technicians out to count the intersections to get real data as to how these intersections are operating. Our technicians also conduct geometric reviews of these intersections. We request signal plans from PennDOT if we need them, and then really start moving forward through the process. We look at 3 different scenarios. One is existing conditions, which is using our analysis and our software to kind of calibrate our system to reflect existing conditions. From there, based on input from the township, we will add any background growth. We'll add any nearby developments. Again, if there's a development that was approved, we'll add that into our traffic volumes. We'll also use historic data from PennDOT to say, hey, what over the last 9-10 years, what has happened in this area, and how much volume can we project to be added to this at our full build-out year. That's called our base condition. So it's how are all these intersections going to look without our development. Then we use the Institute of Transportation Engineers, so it's ITE. We use a land use code based on that institution to really project what this development is going to generate. We add that to base conditions, and then we compare them.
And how did you select the land use code that you used here? And what was that code?
Yeah, so we use land use code 150, which is warehousing. If you go through the ITE manual, there's about 5 different land use codes for warehousing. Some include cold storage, some include mini storage. There's a general warehousing, which we used. Then there's parcels, different ones. So there's various different ones. But really, what we do is we try to get feedback from the client based on what's their target tenant. And a lot of times you can see that based simply on the land development plan. So typically in these scenarios, and Greg from BL and I have worked on this together, many times I'll call them and say, hey, based on the configuration of this site, based on how the docks are loaded, based on the number of parking spaces, what do we feel this is going to be? So based on that, we used Land Use Code 150, which is a general warehousing. In addition to that, we also referenced Publication 282. So there's a recent strike-off letter issued by PennDOT, I believe it was July 24th, 2024, which gave a little bit more information on how you direct or how you accurately represent these projected trips. That is gives you a 13-page document, kind of walks you down through a flow chart, says, hey, here's what you should do. Interesting enough, Land Use Code 154 is actually, it says, hey, this is what you should use, but it actually shows 86% of the volume that I'm showing, so it's less. So we used 150 in order to be conservative. So again, just another check, but that's how we used 150. That's why we used 150.
And so by using that code, when you say you're being more conservative, that means that you're expecting more traffic impacts?
By the analysis, yes. And maybe just to as a caveat here as well, if we feel we were conservative in our analysis and what we're saying is going to generate. If it's not, there was a recommended condition by the township to say, hey, if this use isn't exactly as we feel, or there's other issues, maybe there's the potential for an updated traffic study. And that's almost a standard with PennDOT as well. So they require that if you use Land Use Code 150 as well. So no issues there.
So then if it turns out to be a different type of a warehouse, then you're required to go back and then redo the analysis, is that correct?
Yeah, if the township wants us to, we can go back and evaluate it.
When was the traffic transportation impact study submitted to the township?
So after that scope was reviewed, we submitted the finalized document in January of 24, had a series of meetings and back and forth and response letters, and we submitted the finalized approved copy July 15th of 24.
And we say finalized approved copy, did the township approve the transportation impact study?
They did. Their traffic engineer issued a letter, I believe it was August 6th, 24, approving the traffic study.
Where are you now in this process?
So now that we have kind of ironed out all the roadway improvements, so again, the planning document says, hey, this is what the impact's going to be. Hey, right here, you're degrading this, or you need this improvement. That's really what the planning document says. From there, we will design those improvements. So the traffic study goes through and says that at the access, Keener Drive and Texaco Road, based on some of PennDOT's criteria and guidelines that the township follows, we're required to install a 100-foot left turn lane. So looking at the site plan, or the roadway, if you're heading west on Texaco Road, you'll enter into a left turn lane and turn on the Keener Drive. We're working through design and review of those improvements. So that's kind of where those stand. We also have a few modifications we're going to make at the intersection of 114 and Texaco. An existing condition, there is an eastbound 150-foot left turn lane. We're going to lengthen that to accommodate the additional queue of truck traffic, as well as modify the location of that stop bar and that stop bar on the left turn lane, and then associated retiming. So all of those design elements are currently being completed and reviewed.
And that design element, if we pull up Exhibit A13, which is sheet 18 of the land development plan, is this what you are discussing with respect to those improvements at Keener and Texaco?
It is, and we have a separate plan set, but this generally gives you the graphical information. So Texaco Road will be widened for the 100-foot left turn lane and associated taper. Then the opposite side, as you head west through the intersection, there'll be the lane transition taper, bringing that back down But yes, this is one of the intersections that we're showing improvements at.
Can you explain to the board the level of traffic that's anticipated for this project?
Yeah, I can. So again, looking at ITEs that use 150, and the way that what ITE is, it's a when we do counts, we submit this information to ITE, and they group it together. So it's empirical data rates and based on real life situations. So they take that information, they put it into different codes, and then from there there's various different variables. Following all that kind of process, we're looking at this during the peak hours. So I think one of the important things to remember is the purpose of our study is to see how this is going to impact the surrounding roadway network when it matters. So what is the peak hour? When these roads are the busiest, what's going to happen during that time? So we looked at the AM peak hour as well as the PM peak hour. So when the adjacent street is peaking, what kind of impact are we going to have? Because that's generally what we want to mitigate. So during the AM peak hour, total trips 168. So a trip is one entering, one exiting. So a vehicle would be considered two trips. So you're going to see about during the AM about 129 vehicles entering, about 39 exiting. During the PM, pretty much just the inverse of that, 123 and 48. During that peak hour, 12 in AM during that AM peak period, 12 trucks during the AM, and then 19 trucks during the PM. Also interesting, like we have hourly variations, which kind of shows. You may look at that and be like, well, that doesn't sound like very much traffic or trucks. So there's hourly variations that you can look over the course of the day as to when warehouses peak and when they don't peak. Interesting thing about warehouses, they're very different from any type of retail establishment or office building, where you're going to see kind of a very linear flow throughout the day. And looking at the truck traffic, it actually peaks about 11% of volume at 11 a.m. And then your vehicles right around 3 or 4. So what you have is not this huge push of volumes during those peak hours, but it's spread out over the day.
Thank you. That's all I have, Commissioner Neal.
Jared, was the HOP approved?
So an HOP will not be required for this project because Texaco in this area is not a state road. It only needs to be submitted to the township. Those plans are currently under review. They have not been approved by the township yet.
When was the traffic counts? When did they occur for purposes of this study?
August 29th of 23, all the counts were done at the same time.
Was school in session?
Yes,
What day of the week?
Tuesday.
Let's talk about the proposed roundabout. Are you proposing a roundabout?
We're not.
Is a roundabout being proposed on 114 or Texaco Road?
There are discussions about that improvement being implemented.
If that improvement occurs, what's the impact on the truck traffic for the proposed warehouse?
It would be a benefit.
How so?
Just simply because a roundabout are designed to accommodate trucks. And I'm sure whoever's designing that will evaluate that as well. But, roundabouts are great in the fact that they add capacity to standard intersections, so I think it would be a benefit.
Will there be double-sized trailers using this warehouse?
So the largest vehicle in Pennsylvania is allowed to be a WB67. That has the largest wheelbase and the turning circumference, so that's generally what our design at Keener and Texaco is being based on. I would assume that they're using that as well for the roundabout.
What information were you provided regarding the proposed use of the warehouse? You said you were in discussions, I guess, with BL to get an understanding of which land use code to use?
Yeah, I mean, pretty much the site plan. I lean on them to look into what's being proposed. And we have conversations really based on the parking layout. If there's stalls for trucks and for passenger vehicles, we can generally assume it's a certain type of use. If we're seeing runners, then it's going to be a third type of vehicle. If you have excessive parking, then I would assume it's a different type. So those types of things kind of are indicators to us as to what type of use is being targeted here.
Is this a sort facility?
Not to my knowledge.
What information would you need to determine if it was a sort facility?
Probably what I do have, and I would say based on the layout of the parking, to me this doesn't feel like a sort facility, a hub, any of those additional land uses.
I guess this is TBD's response to comments. As the development does not have known tenants, you're proposing trip generation using ITE Land Use Code 150. If actual development is more intensive, there's a more intensive alternate land use supplemental analysis and associated improvements may be required. What would be a more intensive alternate use?
Yeah, so I think it's exactly what the approval letter, HRG commented, the last bullet point in that letter. It says if a use goes in there that is outside of what is essentially defined in our traffic study, then the township can say, hey, you guys need to look at this again, you need to reevaluate and see if additional improvements are needed. But again, based on what we're seeing, we just don't believe that's the case.
But my question is, what would trigger that?
I guess it could be something between if the building permits, maybe it looks different than what was initially discussed. I think if there's major traffic impacts, there's probably going to be a discussion.
What about the nature of the tenant, the type of use? What type of use would trigger a different land use?
Yeah, all I can say is, again, based on what we understand, what the definition of 150 is, that's what we believe it's going to be, and it's going to. So if we deviate from that, and there are substantial impacts that are identified, then we'll do more. But at this point, the township did review what we had proposed as part of the scope, as part of the traffic study, approved it. Then they just said as a caveat, hey, if we feel more is needed, we will ask for it.
It says if the township feels it needs to be revised, or whether the developer needs to have it revised.
The township.
That's all I have.
I have no redirect, but I don't know if you've got someone coming up first.
Could you explain a little bit about the Mulberry Drive and 114 intersection, how you'll be using that?
Well, technically, in my study, we won't be. So what we're reviewing is Keener Drive in Texaco.
So go ahead.
Yeah, so Keener Drive in Texaco is currently what's proposed as the access point. So we are showing 100% of the daily volume coming in and out of that access point.
So you wouldn't be using Mulberry and 114 at all?
No.
And how can we be assured that it won't be used.
Well,
If I can jump in, Ms. Barrett, I want to make sure your questions are fairly answered. When you say used, can you clarify what you mean by that?
For our trucks and cars for this business establishment,
yeah, I mean, I guess I could answer that the land development plan does not show or propose an access point to that road, so therefore it's not going to be constructed.
it's very important because there is a park
Understood.
right down the street, and there is a bicycle path and walk path that our children use on a daily basis. So it's imperative that there's not 18-wheelers in excess
Yeah,
on that road.
and I would say that's a significant change. If the access point was going to be shifted or another one was going to be added, that plan would have to go back through and be updated. It's not something that we could just construct.
And also, earlier, the first gentleman stated that there would be 500 vehicles at a time on the premises, on and off the premises, and then you stated 200. Are you referring to in addition to the 500?
Yeah, so I know this can get a little technical, but so the way that the land development plan was created was understanding what the shifts are and the fact that there might be overlap. When I look at it, I look at a bunch of different things. So one, there's a peak hour of the generator. So what is the peak period, which is what he's looking at for parking, is what is the peak period when this facility is going to generate its most. I then look at that and say, is that the same as the peak hour of the adjacent street? In this case, it is not. So therefore, I went back to IT and I looked at the peak hour of the adjacent street. What will this generate at that time? So those numbers aren't going to align because it's apples and oranges, but they were both taken into consideration.
So you're saying that as a whole?
So I look at, again, the purpose of what I do is to make sure that the surrounding public and the surrounding roadway networks, if there's an impact, it's mitigated. So I would be doing you a disservice if I said, well, we peak at 11 a.m. and we're going to go count the intersections at 11 a.m. It's not helpful to anybody. So I count them from 6 a.m. to 9 a.m., 3 p.m. to 6 p.m. and then I find out what the peak is and then I overlay the traffic on that. But that's not the same as how they look at the peak parking, which is going to be the peak parking demand of the generator.
I'm here just to speak on the children's behalf.
Understood.
Because those same peak hours are the peak hours of when children are getting off of buses and going to and from their homes or whatever they have going on for the day. So,
Understood.
thank you.
Thank you.
I don't have any redirect based on those questions, so we have completed our testimony, hopefully within our 80 minutes.
You have 9.5 minutes to spare.
You're fine, thank you.
Okay. Attorney Clark.
While I distribute the PowerPoint, can we take a 5-minute break for facility use?
The board might appreciate that too. Is that amenable? Yeah, let's make it 10. Well, many people may need to use them.
Well, we went to find the other one. Earlier. Did you guys find the back? Yeah. Yeah, it's like a mile away. I know. Or is it worth traveling the distance? I'm gonna go. I said I wasn't gonna go. We got 10 minutes. Wait, let's see. Are they going? We'll follow them. Let's go that way. giant out at the gas station at the same time that night. So I haven't really. Yeah, I gotta look too. I know I probably should have set it up that way.
What I figured.
Yeah, I wrote it down though. Appreciate it.
Sure.
Because I was wondering who she was.
Yeah, she's one of the other part of that.
Yeah, yeah.
So,
At least we only have one, right?
Yeah, he's representing like 15.
Yeah, yeah.
But, yeah.
Yeah, I'll need all those names, I guess, right? Because he's going to say them.
Yeah, or he might hand out a packet like that we did.
Oh, well, he gave me this one example.
Oh.
So,
okay, but I'll get it. I probably might have it even in an email somewhere.
What, this one?
The names of whoever he's called. Yeah.
I think it's John Dodd.
Okay. Now it's cold here. I was fine till.
Oh, I was cold sitting here. Yes, we don't need a fan.
No.
Well, there's some air from somewhere.
I feel it right here. Yes.
But it's not noisy though. So I don't really like it. battery.
Oh, I'm plugged in. Do you want me to plug you in?
I don't think it'll reach. It's like a really short. So
I have an extension cord.
give it a shot.
I might if you move it over a little bit.
Yeah, so I can move over towards her. Okay, perfect. Okay.
And I could even give you a few more inches if you need.
Oh, no, I can...
I don't want to plug you. You know, I left that run. I guess it's okay.
Oh, of course.
It's on the other side.
Just like yours.
Well, that's got a cord on it.
Okay.
That stretches.
It's good. I'm good.
Do you want to switch?
No, I have some battery. I'm just afraid it won't.
Well, you could probably put it up there.
Do you want me to put it up?
I don't want to disturb your stuff.
Well, I think my cords are long enough, but...
Are they? Are you okay? You alright? Okay.
Everything's good?
Yeah, just so you know that it's still I don't want to stop it.
You don't need to feel like you need to give me things tomorrow. I mean,
Okay.
like Monday, Tuesday, whatever.
All right.
She's sleeping in tomorrow.
Well, I'm not going to get to this probably till sometime next week anyway, so...
I think I have the names of both of his experts, so I'll be sure when he says it.
Well, those bathrooms worked out really well here today. I mean, they're big. I mean, there's no line anymore.
Oh, really?
Yeah. I was surprised. I was expecting like a line.
Well, I know they're really big.
Yeah.
You know what? I'm going to make sure everyone...
Jeff Cummings. 6 or 8 clubs.
Yeah, that's good.
We got a big, just remember that there's a big orange, there was a big orange extension cord over there.
Oh, with the attorney.
Yeah. But I don't know if it's still there. Because the other attorney Clark was there, but he's moved over there, so I don't know.
We'll
We'll have it for extension's orange.
Yeah, we'll find it.
Law.
And if they use it, oh well.
We'll find it.
I know, but thank you. Appreciate it. Worst case. I'm just trying to think about water.
Yeah, but I was thinking
I know, but
let's get that. Everybody back? Well, she's just sitting there.
I had some of my wallet, but I can just write down my, you're just taking information here.
She's sitting right there.
that's okay. No, yes. Thank you.
She was right there, right at that very end seat. She was right there. She's not here.
Oh, I have, I can't see with these glasses that like the bright lights.
And just like I said, I don't know. You see what I'm talking about.
Your patience, folks. We're just about to come back to order. Thank you very much.
Everything here about that.
Thank you. Good evening, board. Let me be crystal clear about this. I and my clients truly appreciate the unprecedented nature of this proceeding. I am not aware anybody anywhere has ever done this. We appreciate it. We think it should be done in the future for other jurisdictions when it's a complex project. With that, first thing I want to do is put into the record We transmitted last Thursday all of our proposed exhibits. Helen, you have a copy of them. I apologize for not having a separately marked copy. We're going to start with Exhibit O-1 is our traffic expert, John Nawn. But before he starts, I want to put on the record who are the people who requested party status and to provide that list. There's a cover letter, which I didn't bother to date, that I sent to Sean Schultz last week. And I'm going to identify the 15 members of my group that I represent this evening. And Sean, if you want them to stand, they can stand and stretch their legs and wave. William and Jessica Kissel at 31 Keswick Drive. You're here tonight? They're hiding in the back. If I get anybody's address wrong, please speak up. Or if I get your name wrong. Tyler Wilson, 355 Mulberry Drive. Susan Jones, 357 Mulberry Drive. Christine and Patrick Glinsky, 37 Keswick Drive. Mark Pottinger, 44 Texaco Road. Kai Kell Manish, 407 Brook Meadow Drive. Jonathan and Victoria Greenberg, 35 Keswick Drive. Jim Pottinger, 200 Drury Lane. Jeremy and Erica Berrus, B-E-R-R-U-S, 33 Keswick Drive. Gary Stonemetz, 200 Drury Lane. Gaig, G-A-I-G Scott at 202 Drury Lane. Fred Fike, F-I-K-E, 31 Texaco Drive. Denise Baylor, 32 Texaco Road. Happy birthday, Denise. And Barry Smith at 38 Texaco Road. And finally, Anita Ackery at 7 Keswick Drive. If the court reporter needs this, you can use this for reference on spelling if necessary.
Thank you.
With that, I move, if they're necessary, for the board to grant party status to these individuals.
Attorney Buck, we did that for the convenience of organizing this, so they're granted to the extent that has any significance under 508. So you can go ahead.
It may for purposes of a potential appeal. Now, Mr. Nawn, I have presented to the board Exhibit O-1. O-1 was the cover letter dated September 17, 2024. If you turn to the last 3 pages, Mr. Nawn's CV is located there. John Nawn has 38 years experience in civil and structural engineering. He specializes in traffic and transportation engineering, highway, bridge, and street design and construction, transit facility design, etc., etc. He is a professional engineer in a number of states, including Pennsylvania. His education is from Drexel University, a BS in civil engineering, an MS in civil engineering, and at Northwestern, John, traffic crash reconstruction. What's that?
Exactly what it says.
Exactly what it says. He has a number of awards you can see on his CV, and he's an adjunct professor and a former past board member of the local government in Delaware County. I move for his admission as an expert in transportation analysis and engineering.
I'll just have one question. Mr. Nawn, have you ever prepared traffic impact studies or transportation impact studies?
Yes.
Okay. We don't have any objection.
We have prepared, particularly for the audience today, a PowerPoint presentation. We are not moving the PowerPoint as an exhibit. We're not moving it into evidence. We are relying on his September 17 letter. We trust that the board and opposing counsel have read the letter, and if they have questions about that, we encourage them. John, what I'm going to do is turn to the next slide, and I'm going to let you speak rather than Q&A. Let's cut it short and say what you want to say, use whatever slides you want to use, and we have 80 minutes as the timekeeper starts. You don't have 80 minutes.
Well, good, because I don't think I can fill 80 minutes. Thank you for having us here tonight. Appreciate the opportunity. I've been in your shoes before. I don't envy you sitting in this type of environment. We never did this in my town, so you guys are a leading edge there. We're talking about the Trindle Spring Trade Center. It's a 1.2 million square foot warehouse. This is a pretty big building. It's 27 plus acres on the roof. We're talking about almost 21 football fields, so this is not a small building. It has a 40-foot pipe. And as we've heard this evening, per the application, there's no specific or defined use or user for the facility. Generally, you can look at an office building, say it's an office building. You can look at a restaurant, say it's a restaurant. But when it comes to warehouses, there's distinct differences between the types of warehouses and the types of uses. So, new vehicle trips were generated by the applicant in accordance with the Institute of Transportation Engineers trip generation manual. Great. We don't disagree with that. Current edition is the 11th edition. It is literally the standard of the industry. So we're fine with that. I take no issue with the generated trips that they did. And what I wanted to do is just at least read the warehouse definition to you from the IT Trip Generation Manual. This is for Land Use Code 150. A warehouse is primarily devoted to the storage of materials, but it may also include office and maintenance areas. Okay, so that's the definition of a warehouse. Storage of materials. Doesn't say anything about moving materials in and out on a 24/7 basis or anything like that. The definition from ITE also references a high-Q transload short-term warehouse, and it references Land Use 154, which we've heard, Land Use 155, which is that dreaded fulfillment center, Land Use 156, which is a personal hub warehouse, we'll talk about all those, and Land Use 157, the cold storage warehouse, which we've heard is not going to be, and that's fine. Now, I want to point out that when you're using the warehouse code, Land Use 150, the average warehouse size from the ITE database is 292,000 square feet. Okay, a lot less than what we're proposing here. And if you have the slides, I threw up a graph there on the screen. Hopefully you have it in front of you. You can see from that graph, along the x-axis is 1 million, 2 million, 3 million square feet. Up on the y-axis is the trips. You can see how all the data, with the exception of one data point, is all hovered around 500,000 square feet or less. So what we're doing here is what the applicant's doing is saying, we're going to have a 1.2 million square foot warehouse, but we're using a trip generation code that is based on 292,000 square foot average size. Okay? Now, again, staying with the trip generation manual, they define a high-Q warehouse as a building that typically has at least 200,000 square feet and a ceiling height of 24 feet or more. Okay, well, that's kind of what we have here, right? We got a 1.2 million square foot warehouse with a ceiling height of 40 feet. So this warehouse that's shown on the paper in their application is not a, quote, warehouse. And let's be clear, there's no such thing as generic or general warehouse. The ITE doesn't have a definition for general warehouse. We hear that term that, well, it's undefined, so we're just using general warehouse. No. We went over the definition of what a warehouse is. If it's not that, it's one of these high-cube warehouses. Well, this is, in fact, a high-cube warehouse. It's a big box, 40 feet high. So to try to generate trips other than a high-cube warehouse doesn't really meet the criteria of ITE. So, again, not all warehouses are the same. One of the things that we need when we're generating trips for warehouses is to know what's going to be in them, know how they're going to be used. And I appreciate that they're building us in spec, but the ITE says that you should have what's called the North American Industrial Classification System Code, the NIAX Industrial Code. That's a series of codes for every industry known to man that tells you exactly what's going to be. They also talk about knowing the commodity type, the retail, manufacturing, whatever else is going to be there. Now, your own county planning commission, in their February 22nd, 2024 letter, noted the following: the township should verify that the applicant has provided a detailed description of the on-site activities and operations, materials stored, the general scale of the operation, etc., etc. Well, none of that's been done or offered, at least that I've heard. So we still don't know what's going in there. They want to maintain that this is a spec warehouse. And that's fine if that's what they want to do. There it goes. So what I got next is the definitions of the high cube warehouse, the fulfillment center, the high cube parcel hub. Okay? I left out the cold storage warehouse because I think we're all agreeing that we're not talking about cold storage warehouse. It doesn't have all the features that would be there, such as all the refrigeration and things like that. So, high cube transload warehouse, that's that land use code 154. Okay? That's where you're bringing large pallet loads of material and transfer it from truck to truck and move it somewhere else. Fulfillment centers are where you're bringing lots of stuff, break it down into small packages and deliver it. A fulfillment center, a sort fulfillment center, is essentially an Amazon warehouse, as an example. A parcel hub, well, that's exactly what it says. USPS, that's the Postal Service. UPS, FedEx, that's a parcel hub warehouse. They get lots of product in and they send it back out. So there's nothing that's been presented that would preclude any of these uses in that building. In fact, that building that they're proposing could certainly support any of these uses. So I prepared a little table here, which references the average daily trips for a warehouse, a 150 warehouse, a 154 high cube transload short-term warehouse, a 155 non-sort warehouse, a 155 sort warehouse, and a 156 parcel hub warehouse. Now, under the applicant's proposed use of the land use 150 in the warehouse, it's 1,943 daily trips. Now, if we look at a fulfillment warehouse, a sort facility, it's 7,760 trips, a 400% increase over what the applicant is proposing. So, we have a building that the applicant's asking to be built on spec, so he can put whatever he wants in there. Okay, that's fine, that's what he wants to do. But he's generating the trips based on one of the most minimal uses that you can have. If he wants to have a warehouse that's open to anything, and he's designed and shown on a plan a warehouse that could be used for any of these uses, well then we should be generating the traffic trips that reflect that possible use, not other stuff. If he wants to have a 150 warehouse, then maybe a condition, and we'll talk about that in a minute, would be then restricted to that type of use. That would solve that problem too. So, one of the things that kind of tells me that we're probably not looking at a warehouse use is also the fact about the parking spaces. And I know we've heard testimony, and I don't disagree, that they provide the parking spaces as required by the ordinance. Well, the ordinance doesn't say thou shalt provide these parking, you can only provide less. ITE provides a parking generation manual too, just like they do trip generation manual. Now, it doesn't cover every land use, okay, but they do have a trip generation, a parking generation for land use 150, the generic warehouse. And they say, according to ITE, if you're going to build a warehouse, 150, you need 446 parking spaces. Well, if that's what the applicant wants to use and says that's what he needs, well, then why is he proposing to build 772 parking spaces? So that kind of tells me that, again, we're trying to keep our options open and have this generic warehouse for whatever it is that we want to do with it. You guys have a traffic fee impact ordinance too, an Act 209 study. And I think it's, I guess it's $2,097 per PM peak hour trip. According to the applicant's numbers, which I don't disagree with, you're going to have 171 PM peak hour trips, which is $358,587. Well, if it turns out that this is actually going to be a fulfillment warehouse, it's 1,446 peak hour trips, which is $3,032,262. There's a big difference in those numbers. I guess as a board, I don't know why you wouldn't be saying, hey, generate this as a 155 and give us a traffic impact fee, because you're leaving, I don't know, over $2.5 million on the table here. So, this warehouse, as proposed, is a high cube warehouse based on the ITE definition. Okay, there's no question about it. This is a high cube warehouse. Okay, but the applicants for generating traffic based on the generic, as he calls it, warehouse. There's no such thing, but he's just using the warehouse code. Okay, so he's to use the apple and oranges analogy that I heard earlier tonight, he's showing you an apple, but he's generating trips based on an orange. We really should be on the same page. If it's just going to be a warehouse, then fine. Make it less than 200,000 square feet and lower than 24 feet. All right, and then we got a warehouse. But when we're at 1.2 million square feet and 40 feet high, we've got a high-cube warehouse. Okay, so in the absence of any specified user, anything like that, you really have to be looking at what is the maximum amount of traffic that could be expected with this warehouse. I mean, it's nice that he's proposing, and I saw conditions talking about the proposed improvements associated that they're willing to do. Well, that's great, but it doesn't matter if the traffic is actually 400% more than what he's saying it is. We don't know that those improvements that he's proposing could handle that 400% increase in traffic. So, you know, I was town supervisor for 10 years, including 6 years as chairman. Okay, as a township supervisor, under the second-class township code, we have a responsibility to keep the public roads, and I'll quote, in repair and reasonably clear of all impediments to easy and convenient travel. So, if you approve a land use that they've underestimated the traffic from, you're not really meeting that burden that's in the second-class township code, because you are, you know, creating impediments, in other words, on the roads. The idea is to figure out what the actual traffic will be, and then, you know, talk about those improvements. Now, under the municipality's planning code, as you know, you can impose whatever conditions you want to. So, I'm not standing here saying that this warehouse should be built. I'm not saying that the warehouse size should be changed. I'm not saying anything about the warehouse. What I'm saying is that if the applicant wants this warehouse, where he's spec warehouse, where anything possibly can go in there, then you should condition it. If he's not going to generate traffic based on 155, then condition it to what he says it's going to be. We've heard lots of testimony, it's going to be 150. Well then, write a condition. You have the definition, you can write a condition that says it shall only be used for this, based on your testimony and application. And that way, if it actually becomes fulfilling, he needs to come back to you, and then you can talk about traffic improvements. Now, the problem with traffic improvements is that, great, he's proposed them, he's going to do them, and they're always done before he occupies the warehouse and gets a certificate of occupancy and things like that. Well, if the proposal is to come back and recount the cars and see what traffic is now, well, it's a little bit, the cat's already out of the barn by now, right? I mean, unless that comes with the fact that, okay, if the traffic's more, we will vacate the warehouse and not do any more business in there until such time as we do the next improvements that are needed to meet the extra traffic. So once you approve it, you really got to know what that maximum traffic's going to be, because otherwise there's no mechanism to come back and approve it again. So that's what I got. Thank you.
Do I have your letter report?
I do.
If you could turn to page 6. This is exhibit O-1.
Yes, page 6.
You note the proposed development has no meaningful frontage on any public roadways. Could you provide a little explanation about this issue?
Sure. Your ordinance, I think it's section 415-12 of the zoning code, talks about lot width. What it says is the horizontal distance, blah, 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 talks about how much width you have to have. Well, they don't have any width on a public road. They have the driveways that come out to Texaco Road, but there's no actually, there's just the width of the driveway and whatever right-of-way is associated with it. They need at least, I believe it's 100 or 200 feet, depending on whether we're in the I-1 or the I-2 zone. But they don't have 100 to 200 feet of frontage on Texaco Road or any other road. So they don't really meet the provision of the zoning code regarding lot width, because they don't have any lot width that fronts on a public roadway.
And finally, on page 7, you listed your professional opinions to a reasonable degree of professional engineering certainty. Why don't you, just for the record, read into the record the 5 bullet points, and then I'll be done with my direct exam.
Sure. Number 1, the proposed land use is a high-cube warehouse as defined by the Institute of Transportation Engineers. Number 2, the applicant failed to provide a transportation impact study utilizing the proper Institute of Transportation Engineers land use code to define the proposed land use and accordingly traffic impacts associated with the proposed land use. Number 3, by failing to use the proper land use code to reflect the actual use of the warehouse, Silver Spring Township could be costing itself and the constituents as much as $2,673,675 in traffic impact fees. The applicant's transportation impact study does not provide sufficient information to determine whether the proposed land use will support easy and convenient travel and or degrade the quality of life of the community and adversely impact public health, safety, and welfare. And next one's on the next page. The applicant's transportation impact study does not provide sufficient information to determine whether the peak traffic generated by the proposed use can be accommodated without degradation to easy and convenient travel on the township roadways.
Thank you, John. That's the end of my direct examination. Sean, I turn the witness over to Helen for cross, and if the board has any questions.
Good evening, Mr. Don. Just a few questions for you here. First, your report on page 3 has the definition of a high-cube warehouse, and it says it's a building that typically has at least 200,000 gross square feet and a ceiling a height of 24 feet or more. That is typically what is known as a high-cube distribution warehouse, correct?
Known as a high-cube warehouse, yes.
Yes. But you can also have a warehouse that meets those characterizations without being a high-cube warehouse because it does not have the automation and logistics that enable highly efficient processing of goods that's also contained within that definition. Is that correct?
No, I would agree with that to the extent that most high-cube warehouses are set up to allow for that automation. I mean, if you're telling me, I guess I don't know why you would be building a 40-foot high warehouse unless you needed to put in some type of automation or something like that.
But you could have a 45-foot high warehouse with 1.2 million square feet that is not a high-cube warehouse without that automation. You could build that. Is that correct?
You could build, if it's above 24 feet and greater than 200,000 square feet, is a high-cube warehouse by definition in the ITD.
That's how you construe that definition that you've got in your report?
That's, yes.
Does your report contain a definition of warehouse?
Yes.
And where is that definition of warehouse in your report, sir? Is that on page 2?
Page 2, it says description. A warehouse is primarily devoted to storage of materials, but may also include office and maintenance area.
And a facility that is 1.2 million square feet with heights of 40-foot ceilings that is primarily devoted to the storage of materials, which may also include office and maintenance areas, is defined as a warehouse.
The definition does not give any size, but from the IT data, it does talk about it in the IQ warehouse definition, yes.
Okay, now turning to the ITE data, you contained in your PowerPoint a slide that you had that showed the sort of the data points for ITE code 150.
Yes.
And if I look on page 3 of your report, you indicate that says that based on those studies, the largest size warehouse that comprises the data set was 560,000 square feet. Is that what you say in your report?
Yes.
And that's incorrect because if you look at the slide that you have up there, it actually has a data point up to the far right, an X there, that looks like it's about 3.3 million square feet. Isn't that correct?
Yes, that's one out of the 31 data points. Yes.
Understood, but that is one of those data points that's being treated as a code 150 warehouse and under that code. Is that correct?
Well, that would be statistically insignificant, but yes, it's all correct there.
So you can have a 3.3 million square foot facility that is appropriately under code 150.
I wouldn't say that's appropriate at all.
And you earlier heard a testimony with respect to PennDOT publication 282 that came out in June of this year. Are you familiar with that publication?
Well, what came out in June of this year was strike-off letter 424-24-2. It is a supplement to publication 282, yes.
Yes.
I'm familiar with that.
And you're familiar with that then tells you for a warehouse that you are to use really only two options, 150 or 154?
No, I would agree with that's what it says. It does provide on page 10 of the document does provide a flow chart, but it doesn't say that that's what you have to use.
And
In
if
fact,
you-
it has language that tells you that you might have to use other codes.
And if you use code 154, you would actually be less conservative than the code that was used here, which was ITE code 150. Is that correct?
Yeah, I think that was on that slide I had in there. Yeah, it's 86% of the traffic that use number 150.
And you also acknowledge that if the use of this changes from a basic warehouse to what would fall within the definition of a fulfillment center or cold storage facility, then the township could condition it that you would have the obligation to come back in and do further traffic studies.
Well, I think that the condition should be that you can't use it for those uses unless you come back to the township first.
I think that's what I was suggesting. Maybe I didn't say it that clearly, but that's what I'm suggesting, that that's the condition. And even what the township has already said, that if this is not your, just a warehouse of this size, sort of a spec warehouse, if you get a particular tenant that would be doing the things in this facility that would meet the qualifications of a fulfillment center, then the applicant would need to come back and do those additional traffic studies.
Under the assumption that whatever is going on in the warehouse would cease, the warehouse would be vacated, so you could then make the proper improvements that might be necessary before you have the fulfillment center occupied.
And I certainly was not suggesting that the occupancy would occur before the opportunity for those traffic studies to occur.
Attorney Gamble, if you could just pause for a moment, with a little piece of housekeeping. We're gonna swear in Mr. Nahn in reverse. We get the opportunity to do that. Do you swear or affirm that the testimony you have provided and that you will be providing this evening is true and accurate?
I do.
Okay. And then also, Mr. Nahn, you're drifting a little bit away from the mic at times. If you can, just so everybody, I think everybody in the back can still hear you, but we want to make sure that it can.
Okay, thank you.
That's all I had. But thank you for getting him sworn in.
I picked the right note. Any redress? No. Okay. Thank you, Mr. Nahn. How many more witnesses? I'll have 2 more in. Okay. And could you introduce them to the board?
Yes, Sean, before we start, I want to let John be able to do his 2-hour drive back. Do you need him to stay?
I was going to have the board ask all of its questions at the end of your case in chief. If you need him to be able to leave, we can do that.
No, he's fine. We're good.
Okay, so you have, how many more witnesses do you have?
2.
Attorney Clark, okay. And they are?
Andrew Weaver, who's standing in front of you. We have 2 exhibits. We have 02 and 03. We have a PowerPoint presentation to hand up to you unless you want to step out here. I don't have copies for everybody. Thank you. I don't need a PowerPoint. Hold on.
And Mr. Weaver, while you're standing there, do you swear or affirm that you will tell the truth in the matter proceedings?
I do.
Okay. Oh, right on. Oh, she needs this is address and I have that.
Let me introduce our next witness, Mr. Andrew Weaver. He's been sworn. We have as an exhibit 02 is his CV and 03 is his September 18 expert letter report, both of which have been transmitted a week ago Thursday. To the board and opposing counsel. He has a PowerPoint presentation which was just distributed, and I gave a copy to Helen. And let me qualify Mr. Weaver. He is a Professional engineer in Pennsylvania. He's also admitted as a professional engineer in Delaware and Maryland. He is what is known as an ASFPM certified floodplain manager. Andrew, what is ASFPM?
American Society of Floodplain Managers.
He has a BS in civil engineering from Drexel with an emphasis on hydraulics and hydrology. He has written a journal paper on the reanalysis of a flood of record using HEC, HEC-2, HEC-RAS, and USGS gauge data that was published in the ASCE Journal of Hydraulic Engineering. We move for the admission of Andrew C. Weaver, professional engineer, as an expert in floodplain management, HEC-RAS, hydraulics, and hydrology.
Thank you.
No objection.
Thank you. And what we're going to do is, I hope everybody's read his letter report, and we're going to sort of just get to the chase. We have a PowerPoint. I'm going to let Mr. Weaver go right ahead and do his presentation, and I hope that saves some time. Sean, how am I doing on time?
You have just about 57 minutes.
Thank you.
Okay, I'm only probably going to take about 10 of those, so I'm hoping. So, starting in 1986, I had a starter job, about 8 years, nothing much to say there. In 1995, I was hired by the Lancaster County Engineers Office as their third of 3 assistant county engineers. My main assignment was to work on the County Act 167 watershed plans, which I will describe on the next slide. I assisted with 3 watershed plans. I'm not going to name them, but the 4th watershed plan, I ran that, basically ran the show on that one. After that, we got a grant for $200,000 to do a countywide Act 167 plan. What happened was DEP, these were all sponsored by DEP with grant money. DEP decided or realized that they were never going to get all the watersheds in the state to have their watershed plans. If they did it piecemeal, they decided at that time in about 2009 to go to countywide plans. So Lancaster County worked on a countywide plan, which I worked on. Cumberland County also did one. They have a watershed plan that was approved in 2010. So I'll talk about that a little bit later. The grant money dried up in 2008 or thereabouts because of the Great Recession. So I next found myself at 2 engineering, 2 associates, worked on numerous flood studies for bridge placements up in the northern part of the state. That was related to Marcellus shale drilling due to trucks trying to access sites on substandard bridges. Did a lot of floodplain studies. At that time, I became a certified floodplain manager. Where 2 sent me to a class in Scranton that was 3 or 4 day class that FEMA runs for the purpose of certifying people in floodplain management. After the gas drilling, gas was over-drilled, price plummeted. Where 2 started doing layoffs. Next thing I knew, I was founding my own business. So that was in 2015. And since that time, I've done numerous projects. The ones that are more relevant to this hearing tonight are, I did a dam breach analysis, which is basically the dam breaks and the water comes out, and you got to figure out what happens next. I did a few smaller flood studies. I also did a Lomar and Claymore F in Lancaster County, and also Lomar breakdown 114 at the south end of Mechanicsburg borough. So that's my background. Next slide is on just a brief description of Act 167. That is officially the Pennsylvania Stormwater Management Act of 1978. What happened was DEP administers it. They realized that looking at individual sites and isolation was resulting in problems. They said We need to look at the entire watershed, so they can range from, it's big picture stuff, it's 60 square miles to maybe 120 square mile watersheds, and you have to look at the entirety of it. Goals are shown in the slide: prevent flooding, or probably reduce flooding, water supply drought problems. Water quality entered into it the early 2000s. They had that had been kind of not really addressed until a lawsuit forced DEP to require water quality, which is now part of the mix. So basically what I want to talk about is two things: Act 167, which I already mentioned, and regional storage, which is a part of that. And then also I'd like to talk about something a little nerdy: steady versus unsteady flow, which hopefully you'll see the relevance of that at the end of towards the end. So with Act 167, regional storage is part of that approach. And so when I became involved with this project, one of the first things I did was I was thinking big picture. I went to the FEMA flood profiles. What I saw there was a very flat profile. Unfortunately, you can't see the pointer, but on the left side of that profile, there's actually I had two profiles that I had to cut and paste together. Unfortunately, a lot of the numbers got dropped from the bottom. On the extreme left, you have Route 114, a 6-foot culvert underneath. About a mile upstream, on the far right, you have railroad tracks. And then in between, you have Mulberry Drive, which was recently rebuilt to put the surface above the 500-year flood, and the access drive to the site, which may or may not be improved. I didn't get into that part of this project. One quick thing I want to mention is I did not get into the nitty-gritty details of the flood study, stormwater management plan. That is for the last witness. So my approach was more big picture, as I keep saying. So when I see a flat flood profile like that, I'm thinking it's a dam. We have a 10-year profile, 50, 100, and 500 year. They're all kind of packed in there together. But when you see something like that, it means that water is being impounded, like either behind a dam or in a big detention basin. So the next thing I looked at was the inundation area of the 100-year storm. So we have Route 114 in the upper right corner of that slide. We have the railroad tracks in the lower left corner of the slide. And got a couple numbers on there. The railroad tracks, we have a 100-year flow as per FEMA. 1,400 cubic feet per second. A little further north, we have a 100-acre plus area coming across Texaco Road and joining into Trindle Spring Run. And right downstream of that, FEMA increased the flow to 2,000 CFS, which reflects the additional water coming in from the north. And so that flow of 2,000 CFS then carries downstream. I'm not sure how far they don't change the flow all that often. Every couple thousand feet maybe. And right at Route 114, we have a 6-foot culvert that can pass roughly 350 cubic feet per second. So to summarize this, we have 2,000 cubic feet per second coming in, we have 350 cubic feet per second going out. And what that tells me is we have a big regional detention basin there. The area in gray is the 100-year flood inundation. That is about 125 acres. Depths vary from 5 or 6 feet in the water course to maybe a foot or two at the fringes, but talking a lot of storage there. It's basically enough to store a 100-year flood. Now, there was some talk about replacing the culvert under 114. That's not part of my report. If anyone wants to discuss or question that, I can give my opinion on that, but otherwise I'm not going to get into that. Okay, so I mentioned that each county had to do a stormwater management plan for the entire county. These were run by the County Planning Commission. In Lancaster County's case, the engineer's office, we had an in-house engineering staff. We did our own plan. Cumberland County's plan was done in 2010. And in the narrative part of the plan, in yellow, there's mention of promoting regional stormwater management that benefits all county watersheds. And right below that, basically the same sentence, maybe it was written with AI, probably not in 2010, but basically the same statement, but to promote regional stormwater management benefiting all county watersheds. The goal of the whole countywide stormwater plan is to control accelerated runoff, erosion, sedimentation, water quality is now, it's not listed there, but water quality is definitely part of that. Protecting public health, safety, and welfare. So, Cumberland County's plan promotes regional storage. What you have right there at the site is a regional storage basin. Whether by default or by de facto, that's what it is. Lastly, the text from the Stormwater Management Act, it does spells out the purpose of the act in that the duty of persons engaged in development is to manage the runoff rate. I'm not going to get into this too deeply. It does allow civil remedies, which is something new in 1978. Before that, if you were a downstream township and the upstream township was causing flooding problems, there was really nothing you could do. The Act of 1978, Act 167, provided for downstream municipalities to bring suit to abate violation of this act. And so that applies to counties, municipalities, or any aggrieved person. The implications being that if the regional storage is reduced by development, there could be impacts to downstream counties, municipalities, or persons. So the second part of my discussion here is on steady versus unsteady flow. I'll try not to make this too technical, but basically unsteady flow is pretty much a flood wave. So I took a gauge, there's a gauge on Cumberland, I'm going to say this wrong, I apologize. Cumberland Creek? What do you say? I'm not going to try, but it starts with a base flow. Start with a base flow, you get a big rainstorm, you reach a peak. As we all know, the peak then recedes, in this case, over about 10 days back to the base flow. So that is an unsteady flow. So the area under the blue line in this graph represents the volume of a given flood. This is not a 100-year flood, but the concept is the same. If this amount of water volume could be stored in the regional basin that is formed by Route 114 and the railroad tracks, then you really only have the flow that can be released by the 6-foot diameter culvert, and everything's hunky-dory. If that culvert was replaced or replaced or storage is removed by the process of development, there could be effects on the downstream flows. Now what FEMA uses on the next slide is that same graph with a red dotted line across the top. That is basically what FEMA does when they do a flood study. It's steady flow. They take the peak of the flood, and then that's the flow that is used at all time in all cross sections at the exact same time downstream That's how they do their flood studies. I have notes here, that's why I keep going back. So what USGS has to say about the difference between unsteady flow, well, unsteady flow could be used for detention basin design. That's basically your hydrograph. All the stormwater people know how to use that. Dam breach analysis, which I mentioned, where the peak flow is as soon as the dam breaches and then it tapers off. That's also unsteady flow, or the passage of a flood wave, which is what we're talking about in this case. And what USGS says is that the changes in the ability of the stream to store water are not considered in steady flow analysis, such as what FEMA does. The changes resulting from storage may be large in some cases, which does appear to be the case for Trindle Spring Run, where FEMA has a 2,000 cubic feet per second peak coming in, leaving 114 is about 350. So a large, that's basically an order of magnitude reduction. The best part of this is the conclusion is already here. So in conclusion, the area between Route 114 and the railroad tracks is basically a de facto regional stormwater basin. Reducing the storage within this area runs the risk of increasing flows and volumes and causing problems to downstream areas or municipalities. The FEMA steady flow floodplain mapping does not include the effects of this regional storage. And my recommendation would be that an unsteady flow analysis should be done to determine the effects of any proposed fill as a result of this project, which the next witness will discuss whether that is the case or not. I did not analyze that myself, but that's my presentation.
Andrew?
Yes.
Yeah, I have a few questions. Do you have a, it's me.
Oh. It's getting late, isn't it?
Do you have a copy of your letter report?
Yes, I do.
All right, if you look at the first page.
Okay.
I want to review the two full paragraphs above capital letter A.
All right.
Would you read in the Silver Spring Board of Supervisors should reject the no-rise study? Why?
Because the applicant has not demonstrated that it meets the requirements of either the Cumberland County Stormwater Management Plan dated September 2010 or the Pennsylvania Stormwater Management Act, Act 167. Go on.
Well, what was the purpose of the no-rise study?
The no-rise study was basically to get FEMA approval, in my opinion, which FEMA runs a flood insurance program. It doesn't address water quality, it doesn't address volume, it does more or less address, it does address the rate, except in a case where you have regional storage, in which case all bets are off, I would say.
So did the no-rise study was based on steady flow?
Yes, I believe it was. That's my understanding.
And what would an analysis based on unsteady flow, what would that tell the board?
That is kind of conjecture. It could show that the 100-year flood level is lower than FEMA calculated, or it could show that there will be overtopping of Route 114. It depends on how much storage is removed, and it's very difficult to just say what would be the effect without actually doing the work.
So the no-rise study and the FEMA determination, which I'll note has not been subject to public notice and comment. FEMA did not seek any comment from anybody. They just accepted what was presented to them. But it doesn't address the environmental risks of development on this property. Just because they have a no-rise study, they haven't analyzed runoff volumes, hydrology, groundwater recharge, et cetera, right?
Correct. Right. The Township Stormwater Management Ordinance and the Cumberland County Act 167 plan are also concerned with preserving natural drainage systems, managing stormwater runoff close to the source, runoff volumes, water quality, groundwater recharge, preventing scour and erosion of stream banks and stream beds. That could be relevant if anything is changed on Route 114 or if regional storage is reduced by development.
So in essence, the no-rise study really adds nothing to the land development application other than their suggestion that they can do something in the floodplain.
I would say that's correct.
Okay. I have no further questions. Thank you.
Mr. Weaver, good evening. So FEMA is the federal body that creates the floodplain maps, is that correct?
Yes, it is correct.
And that's not something that a municipality can change because they do that on their own. They say either the line's here or the line's there, and FEMA makes that decision. Is that correct?
A municipality could have it changed if they thought the line was wrong, but normally it would be a developer, someone who wants to do work.
And you're aware that in Silver Spring Township, the determination of where the floodplain is based on what FEMA says. So where FEMA says this is the floodplain line under their ordinance, that's where it is, correct?
Correct.
So when FEMA makes a change in its map and says the floodplain line was, I'm pointing to the right, but now they say now it's to the left, that is the new location of the floodplain. Is that correct?
That is correct.
And when FEMA makes that determination, they review all the documentation that is provided to them, correct? They don't just go, oh, you asked for it, we're going to give it to you. They look at it because they care about these things, correct?
If the developer wants to change the line, then yes, they do review it based on their standards.
Okay. And then based on their standards, they make a determination as to where the line can possibly be. And in here, they issued a Colmar F, which is a conditional letter of map revision fill. Is that correct?
That, as far as I know, yes, that's my understanding.
And then what FEMA does is they say, okay, now we're saying the line is here if you build and do the things that you told us you were going to do.
That is correct, yes.
Okay. And then you go back to FEMA after you build those things and you do those things, and FEMA then looks at it and says, yep, you did what you told us you were going to do, and now we are going to officially issue our letter of map revision, and now the floodplain line is somewhere different. Is that also correct?
Yes, that's correct.
And that is what is happening here, because a warehouse cannot be in a floodplain, but with the changes that FEMA has approved, the warehouse can be constructed at the location that's proposed, and under the conditional level, conditional letter of map revision, FEMA says you will no longer be in the floodplain.
That is correct, yes. If they approve that, then yes.
Thank you, that's all I have.
Read the rest. The Clomar letter, it didn't change the floodplain, did it?
It does in a sense because it allows fill for the proposed warehouse.
The letter says modifications to the National Flood Insurance Program regulatory floodway must be accepted by both FEMA and the community involved. Are you aware of any request for the community to be involved in this process?
I'm not.
Have you seen any communications from the community to the Board of Supervisors requesting the floodplain be changed?
I have not.
Have you seen anybody asking the input from the community what they think about a 1.2 million square foot warehouse using 25 acres of fill to hopefully build it as speculated in order to not be in the floodplain?
To my knowledge, I have not.
That's all I have.
Nothing further.
Thank you, Andrew. Yes, sir. Yes. Okay. Thank you. Oh, yeah, you have that?
Oh, mine was round.
Anybody want to copy of the PowerPoint? They're up here. Oh. Exhibit 4, swear the witness, please.
Please introduce your witness for us.
Oh, I thought you want to swear him before we introduce him?
Well, I want to know who I'm swearing in.
Oh, you can't see the slide. You have no
I
handout.
haven't seen the slide.
You have a handout?
Well, he's got the handout in front of him. Sean, this is Bruce Haig. Am I pronouncing that correctly?
Yeah, you are.
It's a hard name.
Yeah, I'm good.
Bruce W. Haig, professional engineer. We are going to present him as our expert on stormwater and HECRAS and everything else in this witness.
Mr. Haig, please raise your right hand. You swear or affirm to tell the truth in the matter proceeding.
I swear to tell the truth, matter of proceeding.
Thank you, Mr. Haig.
It's late, so,
Hold on.
you got to qualify.
That's right. Okay. Exhibit 4 is a copy of his CV. Bruce is a leading expert with a significant amount of experience. In particular, he has broad-based experience in NPDES permitting, HECRAS, HEC-RAS, and he's going to explain so you finally figure out what that is, but this is beyond my game. In HECRAS modeling, in the use of HydroCAD, he's an expert in stormwater management. He has reviewed hundreds of stormwater plans, and in particular, the post-construction stormwater management here. He has his own business, Whitmore and Haig Engineering, out of Mount Joy, which he's been doing for at least the last 20-some years. As you can see from his CV, it's lengthy. He's got a lot of experience. He's qualified. I don't need to waste everybody's time. I present Bruce Haig for cross-examination on his qualifications.
No objection to his qualification.
Good evening. It's my pleasure being here tonight. I sit on the same table, same size of table as you do. I'm on the Mount Joy Borough Council. 2 years before that, I sat on the zoning hearing board. I've been dealing with stormwater since about 1966 when I took the invitation from the U.S. government to join the Army and go to that sunny place called Vietnam for 21 months. And then like an idiot after I went to undergraduate school, I went back for another 12 months. I've been dealing with stormwater for 57 years. We're going to try to shorten this briefing, so I'm going to skip some slides because I think there's some facts that have already been established. So we're going to skip them. Over to slide number 2, I think we've established the fact that the FEMA map, the study that's September 7th, 2023, is the official floodplain. That's the official map. And I think we've established the fact that under the township zoning ordinance, that is the floodplain that you are regulating, not any proposed. That's also been determined by DEP on slide 3 and also by FEMA themselves. DEP actually told the applicant, take the proposed floodplain off of your post-construction stormwater management for your Chapter 102, take it off your ENS, township engineer told him to put it on, and then DEP told him to take it off. So it's not on the grading and drainage plans. You've all seen on slide 4, where the warehouse is, the basins are left and right, and then we have the floodplain and the floodway that was shown before. If you go down into then slide number 7, so we've skipped a couple. I have neuropathy of the leg, so I apologize for the stomach. It's not that I've been dipping at the local bar. The township, this applicant requires 5 variances to your zoning ordinance. And I'll explain those quickly. 219A1 is the general purpose of the zoning ordinance. There's 7 or 8 things in there. I'm not going to go belaboring what they are, but they talk about preserving natural resources, et cetera, et cetera, et cetera. 215C. Your township engineer asked the applicant to define the amount of impervious cover because the zoning ordinance under chapter 215 says you can't have more than 60%. Well, he came back and he gave a number. What he forgot to include is the 2 detention basins are lined. They're lined detention basins, they're impervious cover. Under your stormwater ordinance, open water is considered impervious. FEMA considers the floodway, not the floodplain, but the floodway, as open water. So in essence, he exceeds the 60%. We'll let your township engineer determine how you're going to interpret that. He's got fill in the floodplain. Not the floodway, the floodplain. We've already determined that's not authorized. We've determined that there's an inadequate drainage structure. His discharge from his basins go to a level spreader. That level spreader is below the 100-year floodplain level. It's slightly above the 2-year. It's not going to properly discharge. And then, of course, there's the old zoning ordinance 304.24E, which talks about expert witnesses. There's been no expert witness tonight from the applicant to talk about the SWCA no-rise study. Next slide, you've already seen that from Andy. This next slide on page 9 is from the USGS HEC-RAS or 3D viewer. And what that shows is where your warehouse is, your basin 1, basin 2, and also the evergreen detention basin, which is on the other side of the railroad tracks. If you look at all that blue, that's what the HEC-RAS model is telling you is floodwaters. I'm saying now floodwaters from Trindle Spring Run. We got 25.5 acres of fill in the regulated floodplain. I'm down on page 10. The primary responsibility of a floodplain is groundwater recharge. He's doing no groundwater recharge, none whatsoever. He's doing evapotranspiration by a riparian buffer. And oh, by the way, the riparian buffer, he's got it as 150 feet. Your ordinance says the riparian buffer extends the full extent of the floodplain. He's got 150 feet. And in the post-development, he decided that he wasn't going to do any stormwater infiltration, even though his geotechnical report said it was possible. Andy went over the next slide, but basically, between the upstream and the downstream, you're missing 589 cubic feet per second of flow. Coming in at 1,400, going out at 2,000. Where's that flow coming from? FEMA says it's there. If you look on slide number 12, this is from the U.S. Geological Survey. They do mapping of drainage areas. Now, I will caution you on one thing. The area north of Texaco Road is heavily wooded, and it is very difficult to properly do LIDAR, which is low intensity direct aerial radar surveying in a wooded area. USGS is saying that the area north of the property is 147.2 acres. The post-construction stormwater management report has it at about 40. There's a big disparity between what USGS is saying is stormwater coming from north to south. There is an unnamed tributary to Trindle Spring Run that runs right through the middle of the warehouse. He's putting fill in that unnamed tributary. And if DEP would determine that was actually a regulated unnamed tributary, then he needs another permit, most likely a Chapter 105 permit. Now, as I said, I'll caution you, USGS, when they do surveying, they do an aerial, and sometimes it's not totally accurate. But clearly, what he's showing as runoff coming onto the site is not right. So we're missing between what he's telling us in his pre-development runoff from off-site and what FEMA's saying. We're missing 472 cubic feet per second of runoff coming onto the site. That totally impacts his stormwater report, post-construction. We asked, what is the date of the stormwater report? Is it the last one? We're not sure it is, and I'll tell you the reason why we're not sure is it's not signed and it's not sealed. And professional engineers, when they submit a report for the copy we have, not signed, not sealed, professional engineers are required when they submit it for final review or to a regulatory agency, have it signed and sealed. Now, maybe the one that went to DEP for the Chapter 102 was signed and sealed, not the copy we have. If you go back, look now on slide 17. Okay, where is this 472 missing? There's two places that I think it's coming from. I think there's stormwater runoff coming from south of Texaco Road. You've got 3 detention basins up there that drain to the north into the detention basin, but the detention basin then drains back south. The other place this extra stormwater is coming from is that next to the Evergreen detention basin, there is a drainage channel that goes under the railroad tracks, and it then comes down along the east side of the railroad tracks, just past where the original contour was. But I will tell you right now, I'm convinced that the amount of stormwater pre and post that he has to manage is significantly more than what is in the post-construction stormwater management narrative and calculations. Slide 18. The only thing I want to mention here is what Andy mentioned. You've got a big reservoir. All right, the no-rise study. I want to get into this in a little bit detail because there's some things that disturb me about it. First of all, the application to FEMA was signed and sealed by SWCA on the 13th of June. But the no-rise study is dated the 9th of July. The height of the fill in the application is at height 414 for the lowest elevation. The letter back from FEMA says it's at 410.8. So what went to FEMA? Nobody knows what went to FEMA. How many times after July was the report revised? There was comments from the township engineer to make revisions to the report that were after the date of 9 July. In his report, he says emphatically there will be no rise to the flood levels in the floodplain. But yet in his report, he calculates the amount of existing fill and the amount of cut. We call it cut and fill. First of all, he says the number is 48.46 acre feet to his advantage. In other words, he's taken out 48 acre feet of material in the floodplain in excess of what he's filling. Well, what did he do? He looked at the property and he counted in his calculations the cut of the 2 detention bases that were never in the floodplain. He had somebody go to AutoCAD and calculate. I had to review everything in 18 days using PDF files. And let me tell you, I got no sleep. In reality, the cut-fill balance is not 46 acres or 68 acres because his math is wrong. The cut-fill balance is that he is placing 20.63 acre-feet of fill. That's a plus. That's a decrease in available storage capacity. Now that's the quality of the no-rise study. Okay. Go on to page now 21. We all agree that the September 7, 2023, no HECRAS is Hydrologic Engineering Center River Analysis System. It's by the U.S. Army Corps of Engineers. I spent 24 years in the Corps of Engineers. My last job was at Buffalo District, the Deputy Commander of Buffalo District Corps of Engineers, the Deputy Engineer. And our drainage area was everything in Pennsylvania, New York, and Ohio that drained into Lake Ontario, the Niagara River, Lake Erie, or the St. Lawrence Seaway. Fairly big drainage area. I've done flood control projects in Pennsylvania. I've done flood control projects in New York and Ohio. As Andy mentioned, steady flow analysis, which was what FEMA does not give you accurate results of what happens in that floodplain. You have to use unsteady flow. Now, the only thing FEMA uses that for is to determine if I put a building on fill, can I get it high enough out of the ground or out of the floodplain that I can get insurance? FEMA does not look at velocities in the floodplain or in the floodway. They don't look at water quality. They don't look at erosion, bed damage, or anything else. They don't look at your next door neighbor. That's the responsibility of the elected officials. They don't look at any other impacts. They're basically saying, if you put fill in the floodplain and you move the building 2 feet above the floodplain, then you're eligible for insurance. The first decision has to be made by this township board of supervisors. Is it in the best interest of the board of supervisors in this community to put any fill in the floodplain? Because your ordinance right now says no. It says warehouses are not a permitted use, and fill in the floodplain is not a permitted use.
Amen.
FEMA requires that if you're going to do a study for a LOMER, or a CLONR fill, you're supposed to physically inspect all structures in line in that floodway. The Mulberry Drive culvert was replaced in 2018. This study was done in 2024. And he's got the old culverts in that study. Now, how much effort did the engineer that did the study, who was stationed out of Pittsburgh, actually do on site? Check things out. If you go down now, we're going to skip over slide 25. This is where it gets interesting. In the study, there was no plan view. They said he had a map that showed some cross sections, but it didn't show where the floodplain was. In fact, the floodplain shown on all the drawings is the existing floodplain. It goes all the way through the building up to Texaco Road. There is no proposed condition floodplain shown on any drawings, either in the subdivision and land development plans, and I guess it's not in the Chapter 102 application because he was told by DEP to take it out. First slide is just west of the site. The dark blue is Trindle Spring Run. And then you got the railroad tracks to the left, and you do have a little drainage swale that's on the east side of the railroad tracks that has what we call flow. But that left one, which says Evergreen Detention Basin, the HECRES study is telling you that floodwaters from Trindle Springs Run are getting over here into the detention basin. We know that's not true. It's also telling him a warning that says, you have divided flow. Now he blocked the warehouse, you'll see on the next slide, but he didn't block the Evergreen Detention Basin. Next slide is where he blocked the warehouse. This is slide number 26. But the study is telling you there's floodwaters in basin number 1, which is to the west of the warehouse. That's for stormwater. That's not for floodwaters from Trindle Springs Run. Slide 27. This is the warehouse, and now we have floodwaters north of the warehouse in that unnamed tributary. Slide 28. That's basin number 2. Last one is Route 114. The only reason why I show it is because under the HECRES study, it shows the floodwaters going over. All floodwaters. 10, 20, 10, 5, 5, 10, 25, 50, and 100. Going over 114. Hurricane Lee was a 200-year storm. And I'm told it never overtopped Route 114. So what I'm telling you is that if you're going to rely for your zoning purposes for this land development plan on this no-rise study, it's not telling you what you need to know. And wrap it up with that. Was I fast enough?
You were terrific. The only comment I want to make is I encourage the board to take the time to read his rather thick report. I told Bruce, cut it short, it's late, get to the major point. But there is significant information that goes into more detail than his overview tonight. Bruce, do you hold all your opinions to a reasonable degree of engineering certainty?
I do.
I presented for cross-examination.
I will say one thing before cross-examination. Our reports were due on the 18th of September. Your township engineer issued his last review letter on the 16th. He never had an opportunity to look at any of our engineering reports, whether those be John Nons on transportation, Andy Weaver's on the issue of, as a certified floodplain manager, or mine. And the applicant has not presented any expert witnesses or expert testimony here tonight to dispute anything that Andy or I have said. Okay, no.
A couple questions for you to start. That page that you had, page 14 of your slide with the USGS stream stats. Is it correct that those stream stats are based just on contours and things that can be seen from, I think you said LiDAR, but does not necessarily reflect what is actually on the ground?
To answer your direct question, and I'll qualify this, USGS stream stats is aerial. What you have to do, and I mentioned this, you have to go out there and actually take and walk the field. I will tell you, I walked the edge of Texaco Road. Under the smaller storm events, there is a significant amount of what we call depressed storage on the north side of Texaco Road. But an engineer that he's doing a design, he's got to not only look at stream stats, he's not only going to look at topo or aerials, he's going to get out in the field and walk. And I strongly dispute that at least stormwater that is, he has included all the stormwater south of Texaco Road, and I'm convinced it comes to the south.
And to your knowledge, you don't know what the engineer did in terms of putting boots on the ground and walking where stream stats show a stream might be and determining that no stream is actually there for making their calculations.
I know that he didn't use stream stats in his report, because if he had, he would have included it.
And because he didn't use it, is that because he did boots on the ground and walked to see, is there actually a stream there where stream stats says it is?
Please respond, please respond.
Sure. To your knowledge, you don't know if the engineer walked the ground to determine that where stream stats said there was a stream, and the engineer found that there was no stream physically existing.
DEP uses stream stats. Stream stats shows an unnamed tributary in that area. Do I know whether he walked the site? No.
Did you walk the site, sir, to see if that unnamed tributary exists at the location?
Yes, I walked the site in the area between Texaco Road and the property. I did not go on the property.
And isn't it true, sir, that that unnamed tributary does not exist on the ground?
It is probably an intermittent tributary, but whether it is running all the time or dry, it is a tributary.
Now, sir, you testified that you are currently a member of a governing body and that you previously served as a zoning hearing board member. In that capacity, do you rely on the analysis and reports of the professional staff that's employed by the municipality?
I certainly have questioned the status of the reports of the engineers that service that body.
And then you also rely on the governing agencies that make the determinations to issue the permits, such as the post-construction stormwater management permit that was issued here?
If I believe their analysis is correct. If I know something that they don't know, then yes, I won't rely upon it.
And they have the professionals who are supposed to be doing the same analysis that you have done and looking at these things and determining whether or not what the experts on behalf of the applicant is providing are accurate or not accurate. Isn't that correct? That's what the professionals do.
That's what they're supposed to do.
And people can have different opinions, but you have to meet the requirements of an ordinance. Is that also correct?
That's correct.
And if the requirement of the ordinance is only that you look to see where the floodplain is based on the FEMA map, then that's all that needs to be met. And if the map changes, then you satisfy the ordinance.
If the township agrees to allow fill in the floodplain, then the applicant will have the authority to request the LOMA, and then, and only then, after he builds the site, surveys the site, submits as-built, and submits a LOMA request to FEMA, will he get authorization for insurance.
Understood, but we're looking at what the township ordinance says, and at this point we've got a conditional letter of map revision that all the applicant has to do is build according to the plan, and he has the new map location. Is that correct?
No, because he does not have township board of supervisors approval to put fill in the floodplain. You have to get that first. He doesn't have that.
Let me ask you, with respect to the changes that you talked about that were made between the time that the consultant signed off and provided the certification and the changes that the township suggested, did you determine whether any of those changes were substantive in nature or were they just administrative?
We can't, because we don't know right now what was submitted to FEMA.
Okay.
I mean, all we know is that there's a no-rush study dated July 7th, I think it is, or July 9th, 2023 to 2024. But we've already heard testimony that from your experts that there may have been changes made after that.
And you also went through a number of zoning ordinance provisions that you said that variances were required from those provisions.
My opinion.
Did the township engineer or the township staff ever identify to the applicant that any of those zoning changes or variances were required?
Township engineer referenced two zoning variances. That's all he referenced.
And none of those things that you indicated were required by the township engineer?
Doesn't mean the township engineer is right. When the ordinance says that, you have to have a proper discharge, and he has the discharge going to a level spreader that's buried under the 100-year floodplain, that to me means you got to have a variance.
And I think you also said in your testimony that the township engineer is the one that makes that determination under the ordinance. Isn't that correct?
That's what he's supposed to do, and make
All right.
a recommendation to the township supervisor.
Thank you. That's all I had for Mr. Haig.
Thank you.
Thank you, Mr. Mayor. Mr. Brewer, you didn't stand up, so no questions back there. Okay.
Do we have any time left?
You have 18 minutes.
There you go, Helen, I beat you.
I assume that means no more witnesses.
No, that's it, we rest our case.
I'll let you, well, let me give the supervisors an opportunity to ask any questions of any witnesses that have presented tonight. Give you a moment to gather your thoughts, and whoever wants to go first, give us a hand again.
I'd like to call the engineer, Howard Busher. I have a couple of questions. This might be better here. Is it typical, or how often is this type of stormwater retention used, with the fact that there's pumps being used and the fact that it's going to be like a retention held, and either a doubt through infiltration because of being clay lined, but mainly evaporation? How often have you seen that type of retention used on a site like this?
We're fortunate in Pennsylvania to have a fair amount of grade. This site is flat. It's commonplace out west. It's commonplace in Florida. The technology of using pumps to manage stormwater is fairly common. Just not in this area. We don't see it a whole lot because of the available grade.
Okay. Question would be, when the pumps cut out, how much water, or maybe to what depth, will there be a stagnant amount of water sit there to either evaporate or possibly slowly infiltrate?
Yes, so the basins are designed with a slope across the bottom. They're intended to drain dry. The pumps are set in a well that has a sump in it, so if they're staying water will be inside the pump well, inside the pump chamber.
So it won't be the whole length of the pond, so we won't see standing water for mosquitoes or any other.
That's the intent of the design, yes.
Okay. The water that's in the sump, how long will that retain, and what's the size of the sump?
I'd have to check the detail. I think it's around like a 10 by 10 vault or a 12 by 12 vault, something there.
Okay. All right, I have questions for Jared then.
Thank you.
Thanks for your answers, then, sir. Let me know when you're ready. Go ahead, thank you. Okay, first question, what percentage of the traffic do you have in your study going west on Texaco Road? can you delineate between cars and truck, or do you have it all commingled?
No, I can actually pull that out here. So coming out of Keener, you want to look at going west. Yeah, so the way that, I guess we'll start with the truck traffic. So leaving the site, about 25% heading out Texaco and for the truck traffic. And the remainder of that 75% heading out to 114.
What about the passenger car?
Passenger cars. 20% of it, if you're leaving the site, 20% heading to the west, 80% heading to 114, and the negative split up again.
Okay. How many intersections fail or end up being degraded because of the traffic, especially going eastbound once they enter Texaco Road off of Keener? What do you have for, especially Texaco and 114?
I'm sorry, is the question, is the intersection failing with our traffic?
Yeah, or did it degrade any level of service?
Right, so based on, and this is part of looking over the subdivision land development, the ordinance section says what we can and cannot do here. So overall intersection level of service is what we evaluated. We're required to make that D or better. So under this scenario here, we do not degrade that beyond that grade.
Is there any consideration taken for either queuing or stacking between the 114 Texaco intersection and the Woods Drive 114 intersection, mainly because on peak hours, there's a failure at that point where it's stacked intersection to intersection, and I'm sure that with the potential of more truck traffic, that's going to magnify.
Part of our study, not only does it look at level of service, which is the available capacity at an intersection, but also does look at queuing. So we look at queuing a variety of different ways. There's the 50th percentile queue by synchro, the 95th by synchro, and HCM's 95th percentile. So we evaluate those three different ways. We also look at Hub 46, which is an equation that shows us what that queue or the available storage should be. So based on the analysis that was done here, we are showing that improvements need to be made heading eastbound on Texaco. Now, your question was on 114, but also when I modify that left turn lane, I can move green timings and green time and then effectively give more time to where it may be seeing a deficient. But we were able to pull those queues back to where they need to be and within the level of service of the ordinance.
Okay, question for you. I think we're going through the process right now of having adaptive signal, that those two intersections tied in with a computer system down at 114, 11 in the works.
Correct.
How, you can't really massage timing there too much because the computer ultimately controls that, correct?
So it depends. So like we have we can look at splits, we can modify the splits, the cycle length may be something that we're kind of tied to, but we're not showing modifying this timing such that we're changing the cycle length of that intersection. It's more how we're dividing up the splits of each movement.
Okay, and the other thing would be the township, and I don't know if the applicant's been involved. There is a desire there due to safety with the Pfeiffer Lane left turn, which would be 114 eastbound, and the 114 westbound left turn onto Texaco West. Currently, it is a green light only. You have to yield till there is an opening to proceed. That creates challenges currently right now. How is that going to affect the intersection? Because ultimately that changes timing there. You're shortening the amount of time you have green either on 114 and or Texaco Pike for lane green light. How will that play into the timing that you're proposing?
Just so we're clear, I think coming out of Piper, so heading westbound, your question is the left leaving on, essentially heading southbound on 114?
Yeah, if you're, and technically it's always north and south to me, but the PennDOT has it classified east and west.
Yes.
So if you're heading eastbound, which would be south, and you're looking to turn left on Piper Lane, there is no dedicated movement there with an arrow.
Mm-hmm.
That's
a green ball, essentially.
Yeah. But have you taken that into consideration? Like, because that'll affect the timing on the light itself because you have a dedicated movement when necessary there.
Yeah, and we look at a conflict factor to determine when you can install that. The green arrow is essentially what you're asking for. And we are limited to when we can install it. So if you think about it, anytime there's a green arrow, that means there's a red somewhere else. So it's essentially, you're adding lost time and delay by those. So although we can't just put up a green arrow for those people, we are evaluating that and making sure we do fall within the level of service.
No, but what I'm saying, we as a township have discussed that, and that is going to be occurring. That's going to affect that movement at that intersection.
Oh, so you're saying you are implementing?
Yeah, last year we had looked at that. It's in the process with the other development in the area. That is something that's going to occur, whether it be through development aspect of it or the township. So that has to be taken into consideration because that's going to affect traffic movement there because it's going to give you less time either on the 114 cycle and or Texaco cycle for green, so it's going to affect traffic movements, I would think, with the amount of green time you have on here.
Yeah, so we do have in here as part of, just looking back through here, other improvements by others. They are proposing a flashing yellow arrow, which is pretty involved with the green arrow, but you have a bit more flexibility with what you can do. Yeah, I mean, understood. Every time you add another phase or you add that does limit to, but not to the point where we're not going to be able to mitigate our impact.
Okay, another question. Keener at Texaco, we're planning on improvements to Texaco there for turning movement, correct?
That's correct.
There's going to be, you go west of Keener, we're planning on live Texaco there as well.
We'll have to shadow that left turn lane that's been installed.
Okay. The old Driver farmhouse is there, which sits immediately west of Keener. The garage for that sits in the right of way. Is that going to create an issue? The road is widened there. Have you looked at that?
Yeah, that design's done, and we don't see any impact from that garage.
There was the comment made that, and I'm not sure where it came from, so I don't know if it came either from applicant side, residents, representatives side, that township had not approved the traffic counts. Is there clarification here through your team or Aaron, that's been cooperated, right, that the traffic count has been established?
Jared, I'll let you take first. Study? Yeah, I'm sorry, like the traffic study has been approved? Yeah, August 6th, 2024, we received a letter from HRG indicating that comments have been addressed.
I will note that, Sean, do I need to be sworn in? Okay. I will note that as a matter of, technical detail, we don't approve the studies. We just have to see if the comments are fulfilled or not, and then that's ultimately up to the board for approval.
Okay, the traffic count flows for Texaco. What discussions has the applicant made with the HSS group that is in the process developing the HEP tract in regards to the roundabout at State HEP Texaco intersection pertaining to?
There's been no discussion.
Okay. I have a question then for Mr. Weaver, for the other in the community, and/or this might be for either you or Attorney Clark. There was a comment made on the Clomar, and there was a statement made that the community and need to be made known about it or make comment. And I'm going to either look for clarification from you and/or our township solicitor for everybody here. Would the community aspect be the municipality or the governing body of that area, or is that pertaining to the community itself? Can you answer that, Mr. Clark, Mr. Weaver, or we need to talk to our solicitor here? I heard that said.
Andy, do you want to answer it? If you don't know, I'll answer it.
I'm kind of at a loss, actually. I was not aware of any, my answer was truthful that I was not aware of community input. You have anything to add, Attorney?
Yeah, I don't think there's anything that would prohibit the township from requesting community involvement rather than just having the township manager sign a document.
Yes, I understand, but it was made to believe that the community had a right to that.
I do have some input on that. Is in the Lomars that I did, I had to get the names and addresses of the neighboring property owners and send them a notification. There was also a notification that had to be advertised in the newspaper of record. I believe it was twice. Whether it applies to a Clomar F, I'm not entirely sure. I can't answer that. I'm only aware for Lomar that it is does require notification.
Attorney General, is that so? That they have to notify the neighbors and/or what else you stated in that?
It's my understanding that happens after the process when you're getting the LOMAR itself, but not as part of the conditional LOMAR.
That may be what I was kind of alluding to, is that I can't say for sure about the Clomar F.
Okay. I just wanted to get clarification because I'm sure there's people in the public that were kind of on my page on that. I wanted to get a statement there on that.
I'll just add that I think we got to the answer there that the regulations when it talks about community means the governing body, so that was an accurate statement by Mr. Lenker. And of course, Mr. Cluck's statement too is that a municipality could choose to do something beyond the minimum of that.
Great, I have a question for Bruce Hay.
Here.
Can you come up? I have a few questions here. I want to get clarification and it might require from the applicant. You had stated that the buffer fell short of what was required. Is there, and maybe and/or Aaron, is that a case where they're not meeting the ordinance on the buffer for the riparian buffer?
You want me to answer that, or?
Yeah, somebody, because that comment was made.
I'll answer as my comment. In a floodplain, the riparian buffer extends the full. In a floodplain, under your ordinance, a riparian buffer extends the full extent of the floodplain.
The ordinance also says, except as required by chapter 102, and through their MPDS permitting, it was a 150 foot on each side.
Understand that, but he has to comply with both your ordinance and the chapter 102.
And the ordinance says, except as required, so there's an exception built in there.
Okay, this would be probably for the applicant, and maybe would address, there was an issue where there was a discrepancy in water flow. There is multiple sinkholes in that run within the bounds of that property. Is there any corrective measures that are going to be taken during construction to remediate those? Because, I mean, there's also, that's going to affect flow to water, because when a normal, when we're not in a period of heavy rain, a lot of the water doesn't flow, the run runs dry. When you have higher volumes of water, significant rain events, then the run flows. Is there going to be any corrective measures taken to correct those sinkholes within run bed or not?
DEP asked that we not correct any of the sinkholes or mitigate any of the sinkholes in the street channel.
Okay, but you didn't check on that then?
We asked if they want us to do that, if that would be part of the requirements.
Aaron, is that something we can require or not as a township, or is that out of our head?
I'd have to look deeper. As part of a DEP permit, no, but as part of our requirements, I can look into that, Dave.
Because that would be an issue. I've seen kids over the years in the run, and I worry someday you have water flow, somebody doesn't know it's there, be down in it.
I understand that, and I also think we need to consider what that would do to the flow conditions that that street channel would be experiencing in the real world. I can be that sick.
There was a comment made about the tributary on that property that cut through it. I have experience on that property. I've never seen that tributary flow. I can say that honestly to everybody in this room. I've never seen water run through where they've said that tributary is. So first-hand knowledge and my knowledge for that property is well over 25 years. I've never seen water flow on a consistent basis there. I want to make that statement.
And we have wetland scientists out there doing field studies who know, how an intermittent stream is defined, and they've decided, DEP has taken no exception, or not pushed back at all, that there is no stream there.
Okay, I just wanted to make that to the public, so that it's coming from a neutral party, I've seen that there is no unnamed tributary there that I've ever seen flow. There was a comment made about a final copy of a report or something that was not sealed and signed by an engineer. Which was that, and is that an accurate statement that was made that there was something submitted without a seal?
I believe he was speaking about the post-construction stormwater management report. It's possible that it was not signed and sealed. Typically, that's in like the last things that we do once everything is signed off on and approved, that we submit a final version that has the signatures and seals.
So that had nothing, that had any bearing on the Clomar F law?
No, the PCSO was not the
Okay, I just wanted to make sure. There was a comment made about the significant flow from the railroad. Is it the applicant, your professionals that you had, did they confirm that there is a significant flow coming from the railroad culvert across the property or not?
We've delineated the offsite drainage areas to what we believe them to be. We've coordinated them. If there's any flows coming from the other side of the railroad track, that's not in our analysis that I'm aware of, that I remember.
Okay. There was also a comment made, I believe by Bruce, that the cut fill maybe is inaccurate, skewed, or not calculated correctly. Is that something that you as a group are confident that you have correct numbers?
I believe the SWCA believes that that's the correct number for the analysis, yeah.
May I say something? That cut and fill number is in the SWCA report. It's not in the post-construction stormwater management.
Right, and that's why I answered it that way.
Okay, and there was also a comment made, and Aaron, can you correct this or clarify that the floodplain, floodway, and tension area is classified as impervious? Is that such?
I don't believe that's correct by the definition in the zoning ordinance. The zoning ordinance bases it on coverage with vegetation, and other than the stream itself, that might have some basis, but for the floodway and the basins, their surface coverage is vegetated.
Okay. The comment was also made that fill was not permitted in the floodplain. With the Clomar coming back, would that nullify that comment that was made because correcting the area that you're impacting with more capacities?
I think that's more of a legal question than an engineering question, but I'm not quite sure I'd let John answer it.
I'll address the sequences that Clomar, I think it's been touched on a bit. And the catch-22 is that in order for the Clomar to proceed to the Lomar, the plan would need to be approved. I think Attorney Gamble touched on that. And the building, the development would need to go forward for them to get the Lomar. So what happens then is that conditionally it's been approved that that's not going to be floodplain anymore, and then fill would not be going into the floodplain. It may not feel like that at this point, but they have to build to those specifications that they provided in the Clomar once they've done that and would receive their Lomar as long as they construct everything properly. And that, as was described earlier, the line moves, and then that fill is not hitting the floodplain.
Okay, there was a comment also made by Bruce, and this would be for, I guess, the professional staff, the applicant, that said that the old Mulberry culvert was used. They didn't have the new culvert in their calculation, I guess. Would that be a negative impact on your numbers, or would it be more favorable?
Yeah, I can't speak to the SWCA ECRAS analysis, but I can, the results for what that would change, but I can say that they used the same conditions on those existing culverts that were used in the study that was approved last year in 2023.
Aaron, would that be more favorable, or would that be a detriment to them? Because wasn't that designed for more water flow when we install that?
I'd have to look at the data, Dave, to give you an accurate answer. I don't want to misspeak on the record.
Right. There was a comment to, I think Bruce had alluded that it showed that flood water would be in the west pond. In the one analysis, is that so that?
Yeah, again, part of the SWC analysis report, my understanding of that as someone who's been working with them on this is that the HECRAS analysis basically projects an elevation across the entire surface that cross-section cuts through, and that's what that's showing.
Aaron, does that affect anything in a negative way with what they're doing?
It could. I don't want to say definitively without looking at the data and especially understanding FEMA's reasoning, because there's often cases when we provide either commentary or suggestions to FEMA where they reject our suggestions in cases like this. So I'd have to look and see the data on that.
Is that something that we need to govern, or is that an issue that FEMA was okay with it, have to abide by that?
By the granting of the Clomar F, I'm assuming FEMA is okay with it. Now, whether we have to abide by it, it depends on what issue we're discussing. If it's for delineation of a floodplain boundary or what is within the floodplain, we likely do have to abide by it. Our zoning ordinance references a special flood hazard area that FEMA delineates, and the Clomar essentially says that this is no longer part of it. So I would say it's unlikely that we can do anything about it.
Okay, another question, Aaron. There was a comment made, Bruce had disclosed that there's a discharge pipe that is below, I think, water grade. That's so, and if it is, does that impact their ability with the stormwater to keep it contained?
Yeah, so their primary discharge is 2 level spreaders, and both of those are below the 100-year floodplain elevation. There are redundant systems as well, but the primary outlet structure is there.
Okay, question, and an individual that was sitting here that had left brought it up and actually was on my list. Keener Drive has a dog leg to it. You come in off of Texaco. This might be for Jared. Did you do any sort of template there to see if there's 2, say, combination vehicles, 53-foot trailers at the same time there with their movement there? Is that going to be a conflict point? And if so, is there going to be corrective measures taken to Keener to eliminate that that conflict?
So as part of our design for Keener and Texaco, we did run truck turning templates specifically at the intersection of the turning movements. We didn't take those back into the site. Now, given that there's existing industrial uses there that do have trucks, we feel that there is sufficient width.
Yeah, I'm just going to be honest, I question that because the uses back there are light industrial. I know the one's a machine shop, they don't utilize a lot of combination, and so does the water treatment there. The company that stores the trailers, they have smaller combination. We're talking probably 75-foot long with combination type trucks that are coming in and out of there. That road's, what, 36 foot wide?
We
We could certainly run, we can extend we already have it done for the intersection, so we can extend our templates back to just confirm if that's something you want to see.
I strongly, that's something I strongly recommend. I think a whole combination, I think that could become an issue. Another question, there's a 16-foot right-of-way to that property that runs from Texaco Road back to the main parcel. What is the plan for that 16-foot right-of-way between the property owners to the east and the west? What is going to become of that?
Hello, Greg Holtzman. I believe what you're referring to is on the existing conditions. It is to the back of the residential lots that comes up into Keener. There are no plans for that piece of ground at this time.
All right, would that be something you would disposition to the people that live on Stevens Drive? All right, because really, when you get out to that curve, that's where that comes out. That is I think, like for using for any sort of trail connection or whatever, I think it's a dangerous point where it comes out. There's no real value. I didn't know if that would be something that you would consider as a goodwill gesture to the individuals on Stevens Drive.
My understanding is our group is open to discussions.
Okay. All right, I'm just putting that out there. At no point are you planning on a rail connection to the railroad, or is that still a feasible possibility?
With the layout that we have shown, we're not proposing a rail connection.
There's no impact to the sewer outfall from Mechanicsburg that runs parallel to the stream bed there. There's a right of way. There will be no impact to that with what you're planning and going.
My understanding is that was a closed system that early on we cannot connect to that, and that our improvements will be outside of that, so we will not negatively impact that system.
Yeah, I'm talking as far as conflicts. Have you checked the elevation of it for with your discharge points into the Trindle Spring run? That you're aware of that being what I'm asking.
Yes, we're aware that there's the sewer system that goes through there. The only improvement would be the water line crossing that would be in that vicinity, and we can verify that there are no conflicts.
Okay, what's the plan for the 16-acre tract on the southeast portion of the property where the property meets Mulberry Drive there to turn? Is that going to be open space? Is it going to be continuing to be farmed? What's the overall plan with that? Because I know it's not being used for the development.
We have no intentions of developing that at this time. The plans call for low-growing wildflower and grass mix.
Okay. You're planning no improvements to Texaco Road other than the widening at Keener, correct?
I have to defer to Chair on that.
Texaco at 114 is being modified.
Yeah, but I mean, as far as the rest of the road, you're just doing widening at Keener and that's it, correct?
That's correct. So we're installing the dedicated left turn lane, and then at 114 in Keener, extending that left turn lane, and then modifying the location of the stop bar to improve flow.
Do you have a current MPDS plan now that you have your Lomar, your current MPDS plan?
We have an NPDS permit that includes the post-construction stormwater management and the ES plans.
in its current.
As far as I know.
There was discussion on the money that be left in escrow. Who determines how those funds are to be spent?
Playing a little musical chairs. I mean, that's obviously a condition that we are proposing. It's something that we can negotiate, obviously, with the board and make a determination with respect to how those funds would be spent. We made the proposal to you as a condition that we would accept and certainly want to have that interaction with you so that we understand how you want those funds to be used. And obviously, we're going to obviously look at that condition as well to determine, based on negotiation, we'll come to something hopefully agreeable.
Now, or now.
Very good.
Okay, I have a question for Mr. Hartman. And I guess I'm gonna have, it's a mix and max question on my opinion. After reading all the information that we got from the community and listening to the presentations and everything, the one thing I was concerned about when you talked about a 24/7 operation, as a teenager I worked in a warehouse, Kenny's Warehouse in Shermanstown, and our operation was 7.5 hours. And I remember the noise and the traffic and everything else. And as I was reading through all the letters and everything, and I saw practically the same thing that I saw when I was a teenager working in the warehouse. And I see the 24/7, I'm thinking to myself, the people that are living around that area, you're going to have trucks coming in, the lights are going to shine in their homes and everything, and then you're going to have, 500 to 1,000 employees? Is that true? I mean, that's...
The parking lot, that was, so on the shift change, we had for overall parking, we have 527 spaces. So there will be a shift change that you'll have a larger amount of people coming and going, but this facility here is planned up to 500 people.
And do you have any plans as far as, people might go through the development and stuff versus where they're supposed to come in, the entrance to the warehouse? Do you have any plans to manipulate that so that they're not coming through the neighborhood?
As of now, the main traffic, which has been modeled, is coming through Keener Drive into the facility. So we do not intend to have traffic on Stephen Drive. Our intent is to have that traffic on Keener Drive.
Well, I guess the thing is, the one committee that I'm a liaison with is the New Kingston Division, and they have problems with trucks and warehouses and everything, and this one individual seems to have a problem. This one warehouse back of their development, they seem to be running their tractor trailers all the time, and I think it's probably because they have goods in there that they need to run the tractor trailer for some reason. But they're supposed to come in one way and set up the trailers and everything, but that doesn't always happen. Then they come in other ways, and when you talk to them, it's like talking to thin air. You don't really listen to what you say. So I'm just wondering if there's any safeguards for the people. And I'm thinking about the safety part and the quality of life that, you know, that's in the development and stuff. And I'm thinking, you know, are there any plans for, you know, making it so that there's a safety measure there, that they're not running through the neighborhood with trucks and cars?
Yes, in my experience, I've done a lot of different facilities, even package handling facilities. It's not advantageous for tractor trailers to try to cut through neighborhoods. So in this situation for our tractor trailer use here, the main access would be coming off of Texaco through Keener Drive into the facility. There are options through signage, there are ways to help mitigate, to do traffic control, and then some users do have, for instance, if they're a union, they do have the ability to dictate to their drivers where they go and where they cannot. So depending, there's options out there that can help alleviate some of these concerns.
And I can almost guarantee you that that won't happen because that's driving all over the place. And they're supposed to be coming in one drive and they're going someplace else. But the other question that I had was, and no one can tell me, and I would like to know that what's going to be in this warehouse. It's like, I have this warehouse and in that warehouse.
At this time, we're designing a spec warehouse. We do not have, to the best of my knowledge, an intended user, so I cannot provide you that information at this time.
And I know when you all came to the planning commission, there was one individual in the planning commission that voted against the warehouse. And I guess the person that voted against the warehouse asked a question, and they said, well, have you talked to the residents? Were you able to negotiate with the residents on anything, or have you talked to them? And what was said was, well, we only talked to a couple of people. And I think talking to some of the residents, you can get a feel, and maybe it would be good to negotiate some things with the residents, to have a meeting with them, to find out what they really need.
Hello, good evening. My name is Ash Magombi. I'm an attorney with McNeese, Wallace & Nerick, and I've been working on this project since the start. Excuse me. We have reached out to several neighbors and had conversations with groups, and that's where a lot of the conditions that we recommended, or as conditions of approval, came from. You had asked some questions about, what might happen along Stephen Drive. We have suggested in the proposed conditions of approval that flexible delineators and different things be put in to limit right turns coming out of it. We have suggested that the applicant is willing to fund a speed study along Texaco Road to see if it would make sense to reduce the speed limit there. We've also offered to work with the residents in the area there to see what signage might make sense. But we're certainly open to other things. The other part that was offered was the money that Supervisor Lenker had mentioned, that's intended to be used for other types of improvements that might benefit those residents that are right at that intersection of Keener and Texaco. Some of them live on Texaco, some of them live on Stephen Drive. But the idea is with that money for them and us to work with the board to come up with potential solutions to help mitigate what they're dealing with. But we certainly spoke with many of the residents that live right near that intersection.
So are there any plans in the future to get the community, not just a couple, but the community together and discuss some things that maybe would benefit the community?
because they are part of the township. And according to whoever wants to move into the warehouse, wants to be a part of the community also. So, and I'm concerned about safety things for like there's children there.
Sure.
And environmental things. And, you know, we've got a problem with tractor trailer, period. And we've got a problem with warehouses in the township. And it's great to have businesses and homes because it helps to offset the budget and everything. But I think we need to do it safe and really greatly forward by having, you know, having the business partners talk and have a meeting with the community so that we can all be on the same page.
Now, I can appreciate where you're coming from, Supervisor, and I think some of that, you know, when it was zoned to general industrial to permit the warehouse, you know, the township, you know, made a decision at that time that this use was generally appropriate in that zoning district, in that zoning area. And so our focus has been on the individuals that are right at the access point, you know, who are probably going to be most affected, if anyone is going to be, and that's why we've you know, kind of focused our outreach there, as opposed to the residents. I know there's residents in, you know, down in the Mulberry area, across the railroad tracks, you know, that they're not going to have the vehicles that you're talking about coming there because the vehicles will all be going out to Texaco. But that's why we focused our interactions in the area that we did.
Well, I would like to hear more of that, where you're going out to the community and expressing things or asking them to express maybe the things that they need.
Yeah, no, sure. We received a lot of feedback during the planning commission meetings and this evening, so I think we have a pretty good handle on what their concerns are. Mr. Clark's presentation did a good job of expressing that as well, and so at this point, you know, we believe we put forward a plan that's compliant, that's been reviewed by the other professionals and meets the ordinance requirements, and you know, are ready to move forward with it.
And I would hope that you would take a good of what Supervisor Lanker has said tonight, because we do have a problem with traffic. And you know, when you're a growing community like we are, you do have that problem with traffic, but we have a lot of problems with truck traffic. And you have the tank farm up the street from where the warehouse is going to be. A lot of those trucks come in Texaco Drive there, off of Hemp Road and everything else, and then some come in off of 114. So it's going to be a problem moving down the road. And I would hope that this is what Supervisor Lanker expressed, and you take that as part.
Absolutely.
Thank you.
Thank you.
I think a lot of my questions have been covered, but this would be for the applicant's traffic engineer. This will be for the applicant's traffic engineer. Let me see here. When you're doing a traffic study, I have a question. For instance, do you ever look at how long it would take to get a tractor trailer from Keener Drive to the entrance of 81? Do you do that sort of thing in a study?
So, I guess the answer to that would be yes, but maybe not the way that you would interpret it. So we do look at available routes, and I guess duration, where the access points are, how the site's laid out. All those do play into our distributions and the routes that the vehicles are going to be taking.
But you can't tell me how long that would take.
I didn't calculate that for this project. I have for others, but for this specific one, I haven't calculated how long it takes for the tractor trailer to get from the access point to 81.
Well, it just seems to me if I were in the trucking business, time is money, and I just can't imagine taking a tractor trailer from Keener Drive out to, let's say, 114, turning left, sitting there for a while to be able to turn left at the light, then going out 114 to 81. And that's a long trip with an awful lot of red lights, and I can't imagine why anybody in that business would pick a location that far from 81 and with that complicated a route. It isn't an easy drive in a car, let alone if you're hauling a trailer. But I think that's worth looking into. The other thing another question I have has to do with the traffic counts. And I don't understand how you can establish a traffic count if you don't know what the uses of the building is. It doesn't make it makes no sense to me. I mean, I don't get the logic.
I mean, we could probably go back over this again, but we feel we do understand what this tenant is going to be, not specifically a brand name, but we know what the intended, we know what the target audience is. So based on that information, we can pick a land use code, we can generate trips, and we can prepare a traffic study.
But that doesn't make any sense. If you have a sense of who it is, why can't you share what percent? And my other question, again about traffic, do you, in a traffic study, make recommendations? For instance, there should be a traffic light here, or this should only be a left turn out, or do you do that kind of thing in the traffic study?
Yes.
But did you come up with anything in particular for this project?
Yeah, we did. I mean, as I had indicated in my testimony, we identified what the improvements were. So coming out of Keener Drive on Texaco Road, the implementation of dedicated left turn lane has been a help progression on Texaco Road. Texaco and 114, as we approach 114, we're widening and lengthening the left turn lane. That was based on a Q analysis that indicated that needed to be done. So we're adding 100 feet of additional storage there. Also, as part of our turn lane templates and the meeting that we had out on the field with township staff indicated that we need to adjust the location of the stop bar for the eastbound left turn lane. So that's being pulled back to accommodate the truck traffic. So yeah, we did run through this analysis. We did take the findings of the study and we're implementing those into our design.
For instance, you didn't see a need for a light coming out of Keener Drive.
I wouldn't look at that. I mean, the level of service indicates that there's no need. The level of service is acceptable, and signals are owned by the municipalities but controlled by PennDOT. PennDOT would also not allow a traffic light to go in there. Traffic lights can be good, but they also come with their problems. So you can see increased rear end collisions. There's a plethora of different things that can happen with the traffic signal. So it is controlled by PennDOT, Federal Highway Administration, as to where you can put those. And one is not warranted at Texaco.
Well, how long would you foresee I'd have to sit there in my truck before I could turn on to Texaco on a given busy day?
Here, so Keener, 10 seconds. I'm sorry, you said Keener and Texaco, right?
Keener and Texaco, I'm at the warehouse and I want to bring my truck out with half a dozen other people who want to bring their trucks out. How long is that going to take?
It's less than, the average delay is less than 10 seconds based on the volume on Texaco and the volume of Keener.
Wow. Okay, thank you.
Welcome.
Derek, my question should be directed to you, I think, as well. Can you clarify for me the trigger this was discussed earlier, what was the trigger that would indicate a second impact, traffic impact study?
I'm sorry, what was that again?
There was discussion, I think, in the context of the land use code, coming into it, maybe it's coded 150. What was the trigger that would initiate an additional study after the fact or at a change of use?
Right, so the way that the HRG letter was structured was that the township has the ability to indicate if they feel that the use that's identified is consistent with our traffic study, they have the ability for us to revise it. So if something would come in that fits a different land use code, you'll see that as part of the building permits, then at that point the traffic study would be updated to identify any additional improvements would be needed.
And Carl, if I can interject on this note, I forget who it was, someone had mentioned that there needs to be a trigger for when this occurs. I think the proper time for doing that would be prior to occupancy of the building. Like Jared said, at the time of building permit, that would give the township an opportunity to ensure those improvements are constructed prior to opening, so that if there is enhanced traffic, it is not going through underdeveloped intersections.
And from the applicant's perspective, we interpreted that being at the township's discretion. So if that were a condition of approval, it would be necessary at whatever point the township tells us it's necessary. We're okay with that.
This question was asked, I didn't understand the answer. 527 spaces, 500 employees per shift. How do you manage the stacking? Shifts you're going to have overlap, right? There's a period of time until employees were to leave, and then a period of time ahead of that employees are going to be trying to enter. How do you square 500 per shift with 527 spaces?
Yeah, so I think as Greg had, and maybe I'll start here if he wants to add anything, but what he was indicating was that there is going to be that overlap, and based on that overlap is why they added the additional parking beyond what they felt was needed. But you will have that time period when you do have people coming in and leaving, so that was the need for the additional the additional parking. In terms of queuing, the site's designed to allow to look at the geometry of the layout to minimize the queuing. And then again, the traffic study based on ITE, the capacity analysis, queue analysis does address the queue lengths.
Your AM and PM peak trips, do you break that out by truck and passenger vehicle?
We do, yes.
What are the truck peak AM and PM?
So starting with the AM peak hour, for total trucks, we'll have 12 entering, 12 exiting. For the PM peak hour, for truck traffic, 17 exiting, 19 entering.
I think I heard you say you added 100 feet, probably in both intersections, being Keener and Texaco and 114.
So, yeah, 100-foot left turn lane heading westbound on Texaco, turning on Keener, and then currently 150-foot eastbound left turn lane from Texaco to 114, we're extending that to 250.
So 250. Okay, so the 100, you're lucky to get two trucks able to stack there realistically.
Yeah, I would say, about a 50-foot trailer, you're going to have an additional 100 feet to give you approximately 2 tractor trailers. But that's taken into consideration in our analysis. We adjust the truck percentages, and then again, we look at the pump 46 analysis as well.
What was the level of service at 114 in Texaco pre-development? You said it was a D post. What was the pre-grade?
And this was, sorry, did you say Texaco and 114?
Yes.
Did you have a specific peak hour?
Well, you said you grade AM or PM. Sorry.
AM or PM?
I'd like both.
Sure. Yep. Let's do that. Looking at the projected conditions, so the eastbound left is going to be that movement, the eastbound left movement under base condition. So that's looking at the design year 2026, what happens without our development. So just generally based on what's already planned for this area and the growth that's added, that'll operate at a level service D. With the development, that will remain a D. And then really the same, I mean, we can talk about other eastbound movements as a C to a C, westbound as a C to a C. And for the PM peak hour, it's pretty much the same. D, eastbound left is a D, maintains a D. Eastbound through right, D. And then again, that's what the subdivision and development ordinance indicates is required.
So your pre always matches your post.
That's the goal. And if not, then we're required to implement improvements, and honestly, that's why we're extending that left turn lane and retiming the signal.
The AM, PM peak, I think you said it was somewhere in the range of 129 and 123 ballpark entering, I believe. How does the trip manual suggest for you to square that with what we know will be 500 employees per shift?
Yeah, I think that's again the hourly variation that we had talked about, as well as the difference between the peak hour of the adjacent street and the peak hour of the generator. So I think when we were talking about those two really don't align because we're looking at different things. So I'm looking at the peak hour of the adjacent street, which is mostly impacted by, or mostly concerned by the public, like what happens when schools are letting out. You have the busiest time on 114 in Texaco. That's where I'm overlaying my trip gen, which isn't necessarily consistent with the peak hour of the generator.
This question was touched on a few times, and it was brought up as a county recommendation. You might recall it was in reference to 304-24H. Some of the criteria there, I'd like you to explain to us how we should objectively judge this. Our job, one of our jobs is to square the plan and the application with the ordinances that are written. It reads in part, on-site activities, operations, materials stored, general scale of the operation determines the market area. You might recall this: employees, environmental impacts, and traffic study. I mean, my estimation, we arguably have traffic study. I think that's the only one. How would you say that you've squared up with the rest of those requirements in that section?
The requirements you're referring to about what's going to be stored, how's the facility going to be used?
It's the general concept of that.
Yeah, and I think Greg may have testified to that to some extent at the beginning when we're talking about it not being refrigerated, as a spec building. And a little background on spec buildings. In other parts of the country, you're able to get a building permit for a building like this in a few months. In Pennsylvania, you're not able to do that because of the land development process and many of the things that we have in place that make it a little longer. And so buildings end up being built to spec, much like residential homes around here are often built to spec because the builders know that potential tenants are going to want them, even if it takes longer to build. And so a potential tenant, when they're ready to move in, is not able to say, well, we'll take the building in 18 months. They need to be able to say, we'll take the building in, 2 months, 3 months, 4 months, whatever it is. And so that's how you end up with spec around here. The users know that, we are close to 81, 78, 80, the turnpike, and 60% of the population in the U.S. within a day's trip. And so there's a big desire to be here, and that's what makes spec possible. As a result, though, you don't always know who's going to be moving in or what's going to be moving in. And so what we're able to do is limit that. I believe Greg testified that, there won't be any explosives, flammable, combustible materials or fluid, toxic chemicals, all those types of things. It'll be your consumer products, your consumer goods that are going to be stored at the facility. In addition, it won't be manufacturing or processing or outdoor storage.
I have a few other questions. I'm going to hold on. I know we have residents that I think would like to speak, so I'll hold on to the rest of my questions. Thank you.
Thank you.
Laura, any questions?
I just really wanted to know about the fill adding. Sorry. I've heard that there is going to be 7 feet of fill lifting the warehouse up. Is that correct?
I'd have to take a second look at the grading plan, but that sounds about right.
Okay. And someone had said to me it wasn't going to be uniform across the entire, obviously you're going to want to have it even, but what I'm wondering is looking at these the views plan, are you accounting for that lifting of the warehouse when you're looking at the berms and what the trees are planted and everything like that?
That is correct. There's a lot of sites that you've seen do account for the finished elevations of the floor, and then it does account using like LiDAR information what the neighboring properties are. And then at that time that we modeled that was with a 5-foot berm, and there's discussions to increase that to be even higher.
Okay, so that was discussed about higher berm.
Yes.
And is that part of the plan now, or just discussed?
That was offered as a condition of approval.
Okay. All right, that's what
What is shown on the plan is what's required by the ordinance, and then we offer it as a condition to make it higher.
Okay, all right, thank you.
So was that any other questions from the supervisors? Mr. Lunkin, take a little break. So.
I do have one more question. Looking at section 215, the general industrial zone, I-2, there's a lot of other things that you probably could put there instead of a warehouse. What about a commercial daycare facility or something like that? There's a whole list of them other than a warehouse.
Yeah, there are several other things in that list, and what's proposed and what's before you this evening is the warehouse. But in addition to a commercial daycare, both the LI district and the GI district also permit manufacturing and processing, and any of those buildings can be 1.2 million square feet. I think one thing that is different in this case is the building is limited to the GI area. It's only stormwater that's backing up behind Stephen Drive and in that area. In reality, under the zoning ordinance, that could be a manufacturing facility in the LI district. They're permitted. Machine shops are permitted in the LI district. Auto repair garages are permitted in the LI district. So any of those could end up, on this property as well. But you're absolutely correct that a commercial daycare is another one of the many uses that are allowed in the district.
And also, there's a lot of townships or boroughs that have sports facilities for kids to go in and do soccer in the wintertime and some other sports and stuff. It's really, it helps out the community as well as, give the children a place or teenagers a place to go and kind of blow off steam. You could do the same thing instead of having like a big warehouse, you have a sports facility.
That's not the plan that we have before you this evening.
I realize that, but I'm just saying, you could probably do something else that would probably meet the needs of the community versus a warehouse.
Thank you.
Anything further from supervisors? Council, you still have an opportunity to provide up to 10-minute closing. Do either council wish to do that? I'll start with you, Attorney Clark. I take that as a yes.
It is now Friday. I believe you have a violation of the Sunshine Act. Is it on? I think you have a violation of the Sunshine Act. You haven't properly advertised a meeting for Friday the 27th.
Thank you for bringing that to my attention, Attorney Clark. I didn't realize what time it was. And that allows me to mention that we did have a discussion during the break that the council would be willing, the applicant would be willing to offer an extension until October 11th. Is that still accurate?
Yes, that is still accurate.
We were hoping to do that and allow public comment to happen tonight, but Attorney Clark has pointed out aptly that we are on the following day. So with that, we will need to continue this, and I think we've talked about October 9th. We didn't discuss the time yet. I would be happy to allow you to say that Attorney Clark has raised that objection under the Sunshine Act, and we did not advertise for an additional day.
So you're talking about continuing to October 9?
That's correct.
And the applicant is on the record that they're granting an extension?
I think the discussion was to close the hearing this evening, and the applicant was willing to offer an extension until the 11th for the board to render a decision. But my understanding was that the hearing would close this evening. Was that?
That was the hope. It's 12 after 12.
I think it would be appropriate if you wanted to take public comment at that next evening, but I think our concern was bringing back the expert witnesses again.
Right. There would be no reason to bring back the witnesses at that point. What I would need from the applicant is someone who has authority to consent to any conditions.
Yes, we would have that person there that evening, yes.
And that could include conditions that the board explores that might require experts on your team to advise your client.
And we would have the people available to do that. Obviously, we won't know until we know what condition you're proposing, whether it's something different that we have already suggested, but we will have the people available to do that. We just may not have this exact team here behind us that we've had tonight. And we'll obviously need a date as well.
So we're October 9th. Is everybody able to check their calendars? And I think we need to, we'll also have to do this with the caveat that I think we'll want to have the space again instead of the township building.
Yeah, because my agreement with
Take a vote right now.
Okay. We'll find out the space for the folks that can back here tonight. If we can start, do you think we can start maybe at 5:30 if everybody has availability that night?
Let everyone speak tonight.
It's only public comment. Do we need to, I mean, we'll start whenever you want to start.
I suppose there's not going, let me, as I'm thinking through the sunshine issue, if there's not going to be board deliberation, there's not a violation of sunshine. Sunshine only applies to board deliberation. And they've not done that. There's not been a motion before them to deliberate on.
So you think you need to, can you adjourn this meeting to a specific date, time, and place, not have to go through the formal, I mean, you can advertise it, but the formal 2-week process?
But I think the suggestion was that since there's no deliberation going on with the board, we might be able to do public comment this evening still.
Right.
Now, first of all, Sunshine Act requires a reasonable opportunity for the public to comment. I don't mind if these people want to comment, but I gotta tell you something. This place was packed. You have lost the opportunity for the public to participate. The good people who are here, God bless them. If they want to comment, if you want to hear it, please go right ahead. I'm just saying, this ain't the way to do business. Now, do you really want to say that?
Until we resolve this issue. And so,
Sean, if I can speak, I would like to hear what other residents have to say, and there are quite a few that left. That's just my opinion.
The people that have left might want to hear what's said by someone that's here. I think when you have it earlier, you're going to have an order there that my mic's not working.
cut you off.
So my point is, we eliminate redundancy if we continue it. Everybody's there, everybody can hear what's said, so that it isn't turning into, well, we left thinking there was no comment, we got shortchanged. It should be everybody can hear what everybody has to say. It might bring up another question. To do it the fairest way, I say we wait, do it at the next meeting. That's my opinion.
I think we'd be okay with that, and we'd defer the closings to that as well.
Okay, we can do that.
You might not be able to come to the next meeting. We're here now. There.
That's,
We scheduled for tonight. You're putting that out there. You might get half the room because half the room can't come. We can go soon. So I don't need to be disruptive, but there's a law.
how about we do, if we can do this? Those who are here, is there anybody here who knows they cannot be here on October 9th?
I don't know right now. I don't.
Okay. So we have a few people who would like to be here.
Sean, this is being recorded?
This is being transcribed.
Transcribed.
Right.
But not, in other words, if there's the ability to say whoever's commenting can be recorded, put it on the website, and people who come tonight will have the opportunity to see what people said tonight.
Yeah, we don't have video here.
Make the next meeting virtual as well.
Okay, we need to work through this first. Hold on.
Add virtual capability to the next meeting.
Okay, and we have to explore the virtual capabilities of the facility. So I think where we are, I know I hate to, I think the few hands that came up that they did not make it at all on October 9th on the left side.
Yeah.
Yeah, and maybe someone in the back.
Someone's up already.
You have an opportunity for written comment, of course. I think I want to give folks who know they cannot make it on the 9th the opportunity to speak if they want to speak. That's something. I'm putting you on the spot, but I think if it's just a handful of people, maybe we hear from that handful of folks.
If she's transcribing, can we have her transcribe only tonight's public comment so that the transcript is available on a website or a Google Drive so that those people who do want to come on the 9th will be able to see what was said?
I was actually going to beg Linda to allow me to transcribe, or to have the transcription before the next hearing. But why don't we go off the record for a moment, and I'll work through this with you, Linda. You're going to need to respond, or would you be able to turn around the transcription in the next, really the next week, so that we could get that up and available for folks to see prior to the 9th. And I'm sorry to put you on the spot, but I don't usually do this.
Well, usually less than a week costs more, but
How much more?
like 30% more.
30%.
30 to 50, something like that. Well, 50% more is what it is.
The price is going up.
Yeah, that was less than a week, it's gonna go up. And I have a lot of work to do, so I'd be giving up something else to do it for you.
You're missing one important group here tonight. Texaco Road is the main access for first responders to either respond or back up Mechanicsburg, Hampton Township. And they should be able to tell you what they feel about their access being impeded by additional traffic. And that's all I've got to say. They should be invited to the meeting.
Thanks, sir. There's an emergency management committee that reviews, along with, there's an emergency management. But let me start with it. So is the board okay if there's an additional, perhaps 50% expense on the transfer? I assume it's going to be a lot of yeses. So we'll do that, Linda. Thank you for offering that.
Okay.
All right, we can go back on the record. Thank you.
I am still sitting here.
I have a question. They talked about the traffic study on Texaco out to 114. How about Texaco out to State Road? Yes. There's a good sharp turn.
You did, I think Mr. Leiter asked that question. So let me do this again. We're going to make this transcript available. Those who know they cannot make it on October 9th, let's take some public comment.
Okay.
I mean, I feel like you're putting a warehouse in the middle of town.
I can't hear two people talking at the same time. I'm sorry. Okay. Anybody let's do the public comment. At the very least, there are people here who would like to speak. Come on up to the podium. Let's do it online.
No, I thought Olivia was the one to put that in it. Is it working? Can you get it?
And so you made it here first, so you take the podium, unless you want to defer. And we'll need your name and address.
Christopher Venezia, and I'm at 10 Vicksburg Court in Mechanicsburg.
And before we start, the clock started, you have 5 minutes.
Okay, just two quick things. One was a statement. I've heard a lot about truck traffic. I've heard a lot about truck traffic and nothing about the 500 employee traffic. During that shift time, I've worked shift my whole life. During that time period, you get 500 people leaving, 500 coming, or half the shift. What about those cars? What about that traffic at the intersections? Besides the truck traffic. We have a lot of truck problems, but the other one was just a statement that the supervisor said about the tributary that was a 100-year flood tributary that you haven't seen in 20 years. I believe we haven't seen a 100-year flood in 20 years. If there was a hurricane that had happened, that there would have been some flow. Just a little bit. Because it is about the flood. It's not just about normal flow. It's about the flood. So that's all.
Thank you, sir.
My question is, if we can get out of our plans next week, are we still allowed more? Or whenever this is happening? Yeah. Okay. And then my second question is, I don't think I'll take 10 minutes, but can I perhaps have 10 minutes for my husband, or do we need to switch our sleeping baby if I need it?
The public comment was 5 minutes.
Okay, if I go over, I'm going to take my kid and let him just finish.
You can do that.
Okay.
You're two individuals. This might take care of the same
Are
baby.
you okay with that if he runs up if needed? Okay.
We need your name, though.
My name is Ricky McLaren, and I live at 111 Stephen Drive. Okay, I'm going to...
Ms. McLaren, you spell Ricky for us.
R-I-K-K-I.
And McLaren.
McLaren. And let's restart that clock. Okay, so a couple really quick things. First and foremost, I think that them saying that there's going to be no traffic on Stephen Drive is nuts. Yeah. It like directly connects to Keener Drive, so I think just that in itself should, to you all, discredit the entire study.
Like what's happening there? That should be a huge red flag for you. Moreover, I ask, why would the board think it's okay to have warehouse traffic on a residential street? Because it will go on the residential street, so you would be approving warehouse traffic on a residential street. That's a problem, and it needs to be considered. 3, the traffic study that's going to come afterward. What happens, so they say, okay, once we figure out a tenant, we're going to do another traffic study, we'll figure it out. What happens when they have a change of tenant? A year later, 2 years later, whenever. They can actually split this into 4 different tenants, right? They don't have it's not just one tenant, they can have multiple tenants in here. Are we going to do a traffic study every single time they have a new lease? That's a huge question that you all should be considering. 4th, I understand the process of getting the Clomar before the Lomar, and I think it's extremely dangerous. And I think that you all should be taking that into consideration. I understand that's the process, but once you start building this thing, there's no going back. You have shifted the environment. You have shifted the floodplains, you have shifted the sinkholes, it is unstable, so just keep that in mind when you're making this decision. And my 5th point on here is that a proposal does not mean a commitment to not do something. So they say there's no refrigerated in the proposal. There's no proposal to access the railroad. That doesn't mean that once they are in, they can't just change that, right? And maybe there's some things they have to go back and forth, but it's going to be way easier to do it once this thing is in. So proposals don't mean it's not going to happen. And if you are basing your decision on that, then I think you need to make it conditional and protect us, okay? Have you all seen and digested the letter that we sent yesterday from Stephen Drive residents? Okay, I'm going to read it out loud then. We are ready to request a vote to deny the Trindle Spring Trade Center development proposal. While the applicant has proposed conditions of approval affecting our properties and our street, we wish to make clear that we have not signed any agreement with the applicant and we do oppose the proposed development. As previously expressed in our letter to the Planning Commission, we have significant concerns about the vast negative impact that this warehouse will have on our families and property values. Most substantially, our homes will be most impacted by traffic on Keener Drive and Stephen Drive. The proposed access on Keener Drive would be subject to Stephen Drive to cut-through traffic by employees and would put our families at risk. Moreover, the increased traffic on Texaco Road will inevitably back up an intersection that is objectively unable to handle any more traffic. This will result in higher probabilities of traffic incidents, increased commute times, and negative impact on our quality of life. We are also extremely concerned about the negative impacts that this warehouse will have on our health and safety, including impacts stemming from increased air, noise, and light pollution. We do not believe the current plan does enough to address these concerns, particularly given the addition of truck traffic less than 300 feet from backyards where children play. It's our backyards. While we ultimately believe a warehouse should not be built at all, we understand that there is a possibility that it can be built against the community's wishes. Therefore, we communicated to the applicant a list of reasonable improvements that must be made in order to minimize impact of the warehouse on our community should it be ultimately built. While the applicant's proposed conditions of approval do include some of the smallest requests we included, their proposed conditions is lacking in the most significantly vital improvements that are necessary to preserve the safety and integrity of our neighborhood. The items that are lacking that are greatest concern are... Can I just keep reading this?
Go ahead as you mix it up. Okay. You have another 15 seconds anyway, your time's starting to go.
Okay. Our main entrance, move the main entrance off of Keener Drive and make Keener Drive emergency access. This is important because it has not been discussed tonight. The developer has identified 2 reasonable alternatives for the main entrance, both of which would be significantly safer and would alleviate congestion near State Route 114 and Texaco Road. Stephen Drive, our street. make Stephen Drive a cul-de-sac, and add additional evergreen tree screening to enclose the neighborhood. This will provide visual and physical separation, helping to preserve the integrity and safety of our residential community and protect our property values long term. Most importantly, this will prevent the cut-through traffic, which poses the greatest threat to our overall safety. Screening. Guarantee to increase the earthen berm by screening at least 18 inches. Signage. If the entrance is not moved off of Keener, the applicant has not agreed to install appropriate signs to deter traffic from Stephen Drive. I'm almost done. To reiterate, we believe that the application should be denied. Okay? If the application is approved, we urge you to condition its approval, condition it on these two top priorities: move the access off of Keener Drive, making Keener Drive emergency access only, and make Stephen Drive a cul-de-sac. Our letter dated September 4th, 2024 outlines at length why these traffic adjustments are most vital. In closing, we implore you to act decisively to protect the residents of Stephen Drive and the surrounding community. The health and safety of our families depend on your commitment to responsible development and community planning. The decisions you make regarding this development will have long-lasting consequences on our community. We trust that you will prioritize the well-being of your constituents in making this critical decision. The only other thing that we wanted to say was we wanted to ask, did you all get a letter from Dr. Gage Kerr about the light, noise, air pollution?
I can't be sure, Ricky. I don't know, and I'm going to misspeak.
Okay.
It's not ringing a bell.
You don't have that? Okay. I also have that letter, and I was going to read it if there was time, but I realized I'm out of time.
You can submit it if you
I'll
want.
submit
Make sure
it.
somebody, maybe Scott down at the end, if you want to pass it up.
I'll submit it.
Or we do read everything we get if we don't have a chance to respond, so please do.
Okay. Thank you for letting me read that out loud.
If I had it.
Whoever's next. You'll need your name and address.
Yes, my name is Charles Eimer. I'm at 16 Cumberland Drive in Mechanicsburg in Ginger Fields. I'm not very eloquent in my words, especially after that performance that the young lady gave, but I gotta tell you, I am disappointed in the supervisors in Silver Spring Township. This seems like it was hidden from the public from all aspects. Didn't know anything about this. You rezoned it in 2022 in the middle of the pandemic when everybody was locked in their doors and in their houses. That's not appropriate. You need to be more transparent, as are elected officials. It's just, don't disappoint us again. Don't be a failure and approve this warehouse. Additionally, there's other adjacent neighborhoods that are going to be impacted, particularly Ginger Fields and the townhouses down west of those and other neighborhoods around that. The warehouse is going to butt up right up against those neighborhoods. So it's not just Stevens Drive, although they will be the most impacted. There's going to be other ones that are going to be impacted. So please take that into consideration when they're setting up this escrow account to take in all adjacent neighborhoods. That's all I have to say. Thank you.
Hi, Denise Baylor, 32 Texaco Road. I do want to say that we appreciate you allowing the experts to be heard. That was something we asked for, and we appreciate you doing that. I have heard when I've been to the township meetings that the township cannot put undue hardship on an applicant. But I will tell you that the Silver Spring Township Board of Supervisors, and I quote, are charged with the general governance of the township to secure the health, safety, and welfare of the community. Yes, the community worked hard to raise the money to get experts and an attorney to make sure we were protected. And our experts have shown that there has been a dereliction of duty. If this is approved, when we had a floodplain expert with an HEC, whatever certification was, I can't think of it, it's probably at night now. I wonder who is then going to be held responsible when something goes awry and flooding happens to a house or kids are hit. You have extra traffic on residential roads. If one of these trucks hits a bus, who is the one that's going to be held liable? Because you're supposed to make sure that these roads are safe. This is not near I-81. It's surrounded by residential homes. It's irresponsible to allow 7 feet, 8 feet. Any rational person says that's not logical to raise a 1.2 million square foot warehouse 7 or 8 feet on a floodplain with a waterway and say we're not going to have any issues with flooding. I'm sorry. It's common sense. Thank you.
My name is Victoria Greenberg. I'm at 35 Keswick Drive. All of you being Silver Spring Township residents know of the Evergreen community. The builder who built it, you've praised him in many of your township meetings for the community that he built, the residential homes that he built. I will thank you for having us here tonight to listen and let our voices be heard. I will speak to the Developers Council. If you had done your due diligence, you would have realized my home sits 700 feet from the boundary of your property. And the first time in all the documents I have looked at that you have reviewed, sent to the township, you never once said anything about the residents of this community until yesterday, when a memorandum went out, specific street and a few residents on Texaco Road. But if you had really looked at it carefully, you would have realized that because of the Trindle Spring and the limestone geology of this area, when we purchased our home, our insurance carrier looked at the exact same flood maps that everybody in this room has reviewed or looked at. And our insurance is based on a 6 out of 10 for possible flooding. 700 feet from a 5.6 mile creek that is used to take away our surface groundwater and carry it to the Chesapeake Bay. But you don't know that because you don't live here. All of you do. All of you do. I will never walk away. I will always work with people. I will always work with the township for the good of the community. I hope everybody does the same because it means so much to all of us. All of us. Not just a few people that you, just by chance yesterday, called out. There are 29 to 30 residential developments that have been here before you stepped in. Thank you.
Mrs. Greenberg, could you please, is your last name is B-E-R-G or B-U-R-G for the record? Mrs. Greenberg,
do you spell your last name? D-E-R-G. It might have been my fault.
How do you spell your last name?
Spell your last name.
D-E-R-G.
Thank you.
Thank you. Go ahead.
Yeah, my name is Mark Lodiger. I live at 44 Texaco Road. I bought my property in 1979, so I've been there for 45 years. I was born and raised in Silver Spring Township. I've been here 68 years. I've never seen anything quite like this in my life. Never thought I would have to come to a meeting like this and try to defend our property and our well-being on how this is going to affect us. When the council to my right has said that they've contacted people near the development, I'm within, I'm right across the street from it. I can see it from my front door. They never once came to me or approached me or asked me any questions. Nothing. When he made the comment about 10 seconds to get a truck out on the Texaco Road, I can say that there's no way that's going to happen. I've already had to wait a couple minutes to get out my driveway. At 4:30 in the afternoon, you could take up to 3 minutes just to cross the road to get to my mailbox. And then you're lucky if you don't get hit by opening the door and trying to get your mail. The tanker trucks coming down there already, there's box trucks coming down, it's already a problem. You add on to this warehouse and you bring down another 1,000 trucks plus in a day, it's just going to be unreal. There's no way that the road's going to handle it. The lights, we're already, it's already a mess. And I was wondering, when they said about the roundabout, has anybody ever approached the terminal to get their input on the roundabout? Has the township approached them? Has anybody asked them? I take it that they've not. I have talked to them. My property borders their property. They currently have about 300 tankers a day that they are loading that's coming to their terminal. They're going to be getting some new contracts that's going to increase to approximately 400 tankers a day. You mix that in with now this warehouse, and it's a disaster waiting to happen. They also said that the roundabout, that their tankers will not use it. If that roundabout is built on Hemp Road in Texaco, their tankers will not go through it. They won't go that direction. So what it's going to do, all those tankers are going to be coming down Texaco to 114, right past Keener Drive, where all these other trucks now are going to be trying to come out. It's just an accident waiting to happen. I've had a lot more here that I wanted to say, but most of it has been said. But like I said, it's already a mess, and I can't see how by adding all these trucks and cars that it's going to get any better. It's only going to get worse. Thank you.
Well, I was going to say that if you lived on Texaco Road as we do, you would not be approving this warehouse. And it's sad to say that you really don't care about us and, our home and, the traffic. And, like I said, I timed myself getting the mail. It took me almost three minutes to go across the road and get my mail, and it's going to get worse.
I live on 114. Don't tell me I don't care. You just insulted me.
Well, 114 has mailboxes on both sides of the road. Texaco does not.
Try to pull out.
I know. We have the same problem. And it's only going to get worse if you approve this. It's only going to get worse. You can do all the things you want to do with coordinating the red lights, making turn lanes. You're not getting rid of the trucks that are coming, the volume of them. And you're not going to solve the problem. You're only creating a problem that already exists. You're just making it worse. This parcel, where it's located, this building should never be built there. It should have never been zoned that way in the first place. I'm not saying it had to stay agriculture, but it should never be rezoned to industrial 2, which allows this facility to come in. We get along with the industrial 1 companies that are along Mexico Road. They're there from 7 in the morning, maybe till 5 in the afternoon, and everything is fine. And they're not there on the weekends. This thing 24/7, it's gonna hurt everybody. Not just us, everybody in this township. These trucks are gonna affect.
Ma'am, can we just get your name, ma'am, for the record? Just want to make sure.
Sherry Pike.
Sherry, thank you.
Yeah.
Hi, this is Barry Smith. I live at 38 Texaco Road, right directly across from Keener Drive. I don't care about your money for your escrow. I care about my property that you're going to tear half all to pieces. And the amount of traffic that's on the road right now, that's why I ride a four-wheeler to get my mail, because it's on the other side of the road, because I don't feel safe trying to walk across and walk back. And now that road's closed. A lot of the tankers are going up Locust Point Road in either direction, but you still got them down 114. And if you live along 114, you know very well what it is to try to get out onto 114 and go toward Carlisle Pike. You just wait, and sometimes you're lucky you get out in the first blink, sometimes you don't. So it's something has to be done drastically, and has to be looked in really hard before we make any decisions. Thank you very much.
My name is Karen McAuliffe. That's McAulliffe. I live at 50 Longwood Drive. That's in the development of Evergreen. I always talk about Texaco and Keener. Well, State Road's right there too, and that affects us. In that short little State Road, you have 3 90-degree curves. I understand the other one's going to be smoothed out, but even if the big trucks don't go on it, you're still going to have 1,000 employees. Well, maybe not everyone's going to live that into town, but quite a bit of people will be using State Road to get to work or to get home. And that's not even taken into consideration Costco and all the development that's going on Hill Farms. So that's one thing, it's the traffic. The other thing is the weather too. You talk about the 100-year floodplains. Well, gee, we have climate change. What used to be a 100-year floodplain sure isn't a 100-year floodplain anymore. We have so many more hurricanes and storms, and now this massive warehouse is going to be built on landfill? Really? So, that's an issue too. And, I just talk about Silver Spring Township. Our pastor always used to talk about church, and he just said, it's not the bricks and mortar and wood and stained glass. The church is the people. And you know what? Silver Spring Township is the people. Big corporation out of state. Don't think about them. Think about the people of Silver Spring Township. Thank you.
My name is Lindsay Kavalak. It's Kavulak.
I live at 34 Cardamom Drive, which was typically considered the best property in our neighborhood because it's in the very back, it's a cul-de-sac, there's a farm field, and the other neighborhood is offset. So in a very crowded neighborhood, it was one of the few houses that appears to have a decent land around it. Now from my bedroom window, I will look out on a warehouse. And you can build it up as much as you want, but I live in a 2-story house and there's no getting around what you're going to see from your second floor windows. And there's no getting around the noise the trucks are going to make when they're coming in 24/7. And the staff when they're leaving, who from my understanding will be parked on the side where I live, which sounds great, but as they're coming in and out, that creates a lot of noise too, with talking, cars starting, cars idling, because I believe when I looked up, there are no laws against how long a car can idle. There is about trucks, hence the 5 minutes. I question who will actually enforce that. But there is nothing about cars. So when you have 250, 500 people leaving at once, it's cold, they start the car, they're chit-chatting, that's a lot of cars idling. Not very far from my house, which affects obviously the air quality and health of my family. The other thing I would like to address is also, she touched on it, the traffic. Obviously 114 gets stacked horribly already at Texaco. If you alter the light so that Texaco itself doesn't get stacked with the trucks, you are now affecting 114 even worse, which at times is stacked from Texaco to Mulberry, or vice versa the other direction to Woods and beyond during rush hours. It cannot handle the amount of traffic that the employees in the trucks would add to it. If they go the other direction, and if they are to go down State, Hempt, again, she brought it up. You now have Costco going in there. My understanding is there's another warehouse going in there. And you have an intersection that you share with the high school. My son will probably be out of school by the time all this is done, but he's a brand new driver right now. He drives to school every day. I can't even imagine the risk this is going to put our students at as they are coming to and from school activities and practices at all hours of the day with that amount of increased traffic at a school intersection, let alone the children that want to leave in between practices to walk to local convenience stores to get treats and stuff. It is just too much traffic in an area where you have a very, very large high school. This was once a very, very nice community. We moved here in 2009. We looked in multiple local communities, chose to live here. I have to say, unfortunately, thanks to the development that's been done in the past 10 years, I would not make that same choice nowadays. But we are kind of stuck where we are because of what the housing market is. Otherwise, I would gladly do it. So, thank you all for what you've done to our community.
Kathy Pfeiffer, New Kingston. As you all probably know, I'm the chair of New Kingston Vision. It started around my dining room table with about 8 little people. All we formed was for people to have pride in their property, sweep up out front, pull your weeds, make it look nice. And all we have done since 2008 is fight warehouses. Many of you up on this board have said no more warehouses in Silver Springs. I just wonder why you ever decided that all 5 of you would change it from I-1 to I-2 to allow these warehouses to come in. As you know, I call myself a hemorrhoid, and I'm going to say that for the record. Everybody knows it, that I fuss about warehouses. I know I'm going to get killed by a tractor trailer. Somehow, something's going to happen with the tractor trailer because I fuss about them all the time. We applied for grants to prevent the trucks. We want to prevent the trucks from coming into town and turning where they're not supposed to. They all say, we'll put up signage. Your sign could be blinking, blinking, blinking. And then trucks go where they want to go. They want to get to this place quicker by going in this area. Many of these, 20% of these trucks are going to be coming out Texaco, the Windy Road. I know you're going to straighten that, so now they're going to shoot even quicker. They're going to be on Locust Point Road, and as many as the police know and the fire companies know, accidents all the time on Locust Point Road. Just a couple weeks ago, they took out a telephone pole. They said the telephone poles were too close to the road. So we put more tractor trailers coming out Texaco Road on the Locust Point Road, which is already a heavily busy road. We can't take any more, and New Kingston can't take any more trucks. Everybody says, we need trucks, we need trucks. You buy stuff, but until you live in the middle of it, you don't understand what you have to put up with each and every day. Thank you.
I forgot to say also, all the car traffic is going to come to New Kingston too, to get to this warehouse.
We'll take these last two comments, and then we'll need to continue the hearing until the 9th. And then, of course, the state representative stands up. 3 comments. Okay, good. We'll need your name.
My name is Patricia Leib. That's Leib. I live at 2 Glenfield Drive. So I travel both Texaco and State Road a lot, so I feel I have standing in my observations about that traffic. I attend church in Churchtown. I have family that lives in the Monroe area, so I'm on those roads a lot. And that particular area is already very stressed with the traffic that's already there. And I can guarantee that approval of this warehouse project will not enhance my health or welfare. Until tonight, I didn't know we were talking about a high cube warehouse. The fact that it's in a floodplain that's going to be remediated by providing some fill so that the floodplain can be changed, but that won't be changed unless your applicant fulfills what he says that he's going to do. I don't know, in my way of thinking, that seems very convoluted. If the applicant doesn't do what they say they're going to do, now you have this huge warehouse in a floodplain, right? So, in my way of thinking, I think you have an easy decision. If the applicant thinks that extending a turn lane and making a dedicated left-hand turn lane is going to address all of the additional traffic concerns that there are going to be, I think that's a little disingenuous. So I think your job is easy. The highway system, the arterial support for this project is not adequate. And you're approving a project in a floodplain. I think that makes the decision an easy one.
My name is Samuel Corbin. I live at 38 Mayberry Lane. I want to applaud everyone tonight for coming out and speaking their piece. A lot of what I had to say has already been said. The only thing I wanted to ask of the board, and I guess probably specifically Solicitor Schultz, was to look further into the issue of the variances. Because what I heard tonight from the applicant about the Clomar is that they have a conditional letter. The line doesn't move until they complete it, and they get the Lomar, which means that all their construction activity is going to happen in the floodplain, which means I think that our ordinance still applies based on the fill that they would need the variance, especially since we also heard about both the federal government and the community, which you yourself said, and the municipal government needed to be involved in that discussion. Like I said, I'm not a lawyer. I don't know if the Clomar completely supersedes any township variances that would be needed. I'm just asking that you look a little harder instead of just waving it off. Thank you.
Good morning. Thomas Coates. I privileged to serve as state representative of Silver Spring Township. I ordinarily wouldn't speak at a local meeting, but I spent my day today on the phone with dozens of my constituents, who are yours as well. And they implored me to speak on their behalf. And for that reason, I'd like to preserve the opportunity to speak at a future meeting that I may be late for due to another official obligation. But let me start by saying this. A mentor of mine told me this morning, when giving advice on how to deal with a delicate situation where there really seem to be no winners. It's about how you deal with it. You want to be respectful of everyone's rights. You want to be respectful of everyone's time. You want to be respectful of the way that you go about making these decisions. It seems to me that there are so many questions left to be unresolved after this evening. I don't think an extension until October 9th is sufficient to deal with that. Having served 3 years as a township commissioner, I can tell you we saw projects 3, 4, 5 times before having to make a final vote on it. Typically, working with a developer back and forth engages. This is the first time this project has been before you tonight. I would respectfully request and submit that the developer should request a 60-day extension to resolve some of these issues. Now, let me be clear. And first, to the residents, thank you for waiting 6.5 hours. It is admirable, it is laudable, and I am deeply appreciative of your commitment to be here. Let me also say this. These are decisions that cannot be made lightly, they cannot be rushed. And I understand that the developer's been working with staff for some time. I understand that the developer has made an effort to reach out to residents recently. However, I feel those efforts have not been exhausted. I feel as though there are outstanding issues that must be addressed and resolved before a vote should be taken. Let me talk a little bit about social responsibility. You see, in the corporate world, businesses have an ethos that they are to follow, an ethical and social guideline for their actions, so that they act in accordance with what is best for a community that they are affecting. I believe the developer has a social responsibility that they have not met, and that is to consider the safety of the residents and the children in the immediate vicinity of the warehouse. Let's for a second put aside the commitments for trees and screening so that it's more palatable for people surrounding the warehouse, and let's for a second talk about safety. Because there's a time for preservation, there's a time for infrastructure improvement, there's a time for development, and there's ways to do it smartly, and there's ways to do it that respect the rights of everyone, but there is always a time to consider public safety. You see, there are residents who will be adversely impacted by this all across the township in its current form. We have to get to a point together where we can have a conversation that says, you know, we've heard about the zoning. We can't relitigate the zoning. It is what it is 2 years ago. We're here where we are now. And there's still a question of public safety. Let's also put aside the traffic concerns because 114 objectively cannot handle this extra traffic. Trucks already have to come in the middle lane to swing out right into Texaco, and repainting a stop bar is not going to be enough to do it. But the biggest issue in the last minute of my time is that employees will use residential roads as a cut-through. That trucks will inevitably turn down the wrong road and use a residential road as a cut-through. A road where a child sleeping in this very auditorium tonight will have to grow up and play. So the social responsibility for the developer is to take a 60-day extension so that they can move the entrance. Let us see a sign of good faith. We have seen these conditions of approval, and those conditions might be a start. I don't think they go far enough, considering $1 million includes costs to pay their legal fees, includes $360,000 of the TIF they have to pay for anyway. A typical developer would spend $3 to $5 million in offsites for this very project, and a nearby development at 10 to 15 million, that's a slightly bigger slide. And I'll close by saying this. There is time to make these improvements. There are two alternatives for the main access. I don't want a warehouse behind my backyard, 303 feet to be exact. I don't get to make that decision. What I'm asking you and what I'm asking the developer is to take one step further beyond these conditions that they've offered to say we are going to present a plan. 60 days, you have to do the NPDS permit resubmission anyway. You have more work, you're not shovel ready for 60 days. 60 days does not delay this project, contrary to the developer's claims. So take 60 days, show these residents who have sat here for 6 hours and were almost shut down a chance to speak, 60 days to say, here, we've done our work, we're gonna move the entrance, we're going to protect children, we're going to protect lives, and we're going to do something about the traffic that is going to drastically change the landscape of our township and our community for eternity. I thank you for your time and for the latitude, Mr. Solicitor, and thank you to the residents who have been here almost 7 hours. God bless you. Have a great night.
Okay, that is the final public comment. We are going to continue this hearing for public comment to October 9th. We had settled on a time. I think there were some comments 5:30, might be a little too early. We want to do 6 o'clock. Will that work for everybody here? 6 o'clock? We'll advertise that, of course. And then that's the time where we would conclude public comment, and then the board would be able to vote unless there's further extension offered from the applicant before that time. We are adjourned. Thank you all.
It's okay, I think we did it just to get them out of here. Get people. Oh my god. Eyeballs.